Someone make it make sense.
Probably a couple.
All right, party squirrels. I hope you guys are excited. From the snippets that I was able to catch today, I think this was one of the most important days that we've seen in either trial. I can't wait to watch all of this with you guys. Shout out to James, shout out to Twiz, shout out to Meg, shout out to Mary, shout out to Kim. Happy to see all of you guys again. Love y'all. I did happen to notice that there's a slew of new filings out of Idaho, and including the state's response to the defendant's motion to continue the trial. I am so excited to dive into those. We will do that this weekend. Hopefully we will already have a verdict in Karen Reed. We'll see. But, you know, never fear. I'm keeping an eye on all these other cases that we've sort of had at pause. You know, we're going to catch up on Lori Vallow as well. But I'm super excited to go through those documents as well. So yeah. And got some exciting stuff to share with you guys as well from the law firm. But first, we have a new filing. We have the defendant's motion for a curative instruction regarding Exhibit 88, an introduction into evidence of exhibits. Now, as we know, the quote unquote curative instruction yesterday was not that. So here we go. So Karen Reed moves the honorable court, or not so honorable court, to issue a curative instruction to address the intentional misconduct of the Commonwealth, which occurred before the jury and this court on June 9th regarding Exhibit 88, footnote 1. Footnote 1. Attached as Exhibit A is the recross examination of Dr. Wolf by Mr. Brennan and the redirect of Mr. Jackson. This is not an exact transcript produced by the court, but rather a transcription created by the defense to the best of their ability from the recording available on YouTube. I wonder if that's the court TV feed. This was created to offer context and clarity for all parties if necessary. Ms. Reed does not waive and hereby reserves all her rights asserted in her June 9th motion in open court for a mistrial with prejudice. Okay. So that exhibit is not attached, but it's just the freaking, you know, we've seen it. So Ms. Reed also requests that exhibits YYY, ZZZ, quadruple A, and quadruple B, which were marked as part of Ms. Reed's motion for a mistrial with prejudice, be admitted into evidence. Ms. Reed respectfully submits that the instruction issued by the court on June 9th, 2025 was not curative or otherwise sufficient. Yeah, I freaking agree. This point is underscored when one reads the deep level of prejudice that exudes from the questioning of Dr. Wolf by attorney Breenan, which is attached as Exhibit A. With this intentional misconduct being deeply and directly intertwined with the central issue in this case, whether or not an impact between Ms. Reed's Lexus and Mr. O'Keefe's even occurred, Ms. Reed's constitutional right to a fair trial and due process compel the requested further curative instruction by Your Honor. The intentional misconduct of the Commonwealth also wrongfully impugned the credibility and competency of defense witness Dr. Wolf by asserting that he did not properly account for the holes in the back of the sweatshirt and incorrectly posited to the jurors that the holes in the back of the hoodie sweatshirt of the decedent, Mr. O'Keefe, were caused by alleged events occurring on January 29, 2022. And then they reference a certain part of the transcript that they've fashioned here, especially the yellow highlighted text where attorney Breenan appears to cut off Dr. Wolf from noting the holes on the back of the hoodie sweatshirt were the subject of cutting. I remember that. This, therefore, must also be part of the curative instruction. On June 9th, Your Honor initially proposed the following language outside the presence of the jury. This was her initial suggestion. Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt, and I instruct you that those holes were made by Ms. Hartnett during the course of her inspection and sampling on May 18th. The court then instructed the jury with the following language. So, jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt. Yeah. Proposed curative instruction. Ms. Reed respectfully proposes the following language to address the misconduct and its harm to Ms. Reed. During the and there's another footnote here. Sorry. Attached as Exhibit B is a portion of the discussion between Your Honor and Mr. Alessi before the jurors returned. As with Exhibit A, it's not an exact transcript. Okay, and it shows the link there. Okay. So here's the proposed instruction. During the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about the holes in the back of the sweatshirt, falsely insinuating that those holes were sustained on January 29th, 2022 from a fall backwards. I instruct you that those holes were not present on January 29th, 2022. Those holes were made by Maureen Hartnett, a criminalist at the MSP Crime Lab, in the course of her inspection and sampling of the clothing on May 18th. Dr. Wolf correctly testified that those holes did not come from any alleged event on or about January 29th, 2022. Here's what I think she would probably omit from that, if I had to guess. I think she would probably omit the part about falsely insinuating. So I would imagine she might say, during the cross-examination of Dr. Wolf, Mr. Brennan asked Dr. Wolf about the holes in the back of the sweatshirt and suggested that the holes were sustained on January 29th, 2022 from a fall backwards. I think that might be sufficient. I instruct you that those holes were not present. I think she won't have a problem with that. Those holes were made by Maureen Hartnett, blah, blah. And then I think that the other part she might not be okay with, Judge Bev, rather, about Dr. Wolf correctly testified. So in his testimony, he initially pushed back and said that he thought they were from the criminalist, but then he continued to answer the questions. I feel like she would probably also say that the jurors can rely on their memory of the testimony. So I don't know that she will include that last sentence. I think I don't know. I feel like they would probably end up changing this. Disregard the line of questioning as it pertained. I don't know. I just feel like she probably wouldn't like that last sentence. Anyway, okay, let's keep reading. Yesterday, the court agreed to enter into evidence and allow the defense to display YYY, ZZZ, quadruple A, and quadruple B. This has not been done yet. This information regarding the clippings and from the crime lab still need to come into evidence and be displayed for the jury. It unequivocally establishes Maureen Hartnett cut clippings out of the gray hoodie sweatshirt and that the damage. So they really want to show the jury for real, that she cut those clippings out by bringing that into evidence, which is fair. Conclusion for the foreground. And in other words, and I think part of that is probably because there's been a lot of like quote unquote curative instructions. I think the point is they want to hammer home to the jury that sometimes there's curative instructions that might not, that might not correlate with what the jury hears in testimony, but are maybe perhaps sometimes due to some sort of technicality. For example, like with all the text messages, right? And it's like, these are not, it doesn't mean these things are, I don't know, this instruction she reads with the text messages, it doesn't mean that the jury might just think, oh yeah, she has to read that, but they might still take some of the things stated in the text messages as being true, as in for the fact of the matter asserted, right? So I think that the point of this is to show that this isn't just an instruction, just to say that it was da-da. They want to show the jury for sure. This is my thoughts on this, that 100% the clippings were cut out. This is not just a formality, right? Conclusion. For the foregoing reasons, Ms. Reed respectfully requests that the Honorable Court instruct the jury with the above proposed curative instruction in furtherance of Ms. Reed's constitutional right to fair trial and da-da-da-da. This is an inflection point for this trial and public confidence in the judicial system. And there you go, guys. Let me see what you guys are saying in the chat. So as far as what Judge Bev said yesterday, what she said yesterday, I'll read it again. Oh, hold on. We have to go back. What she said yesterday was this. So jurors, I instruct you that those holes were made by the criminalist, Ms. Hartnett, during the course of her inspection and sampling of the sweatshirt. So obviously it doesn't address the fact that the Commonwealth misrepresented it, whether intentionally or on accident. And it also doesn't address how he used that to then try to make it seem like Dr. Wolf didn't consider the holes when making his opinion about whether or not the fall could have happened from a, what do they say? Or the holes could happen from a fall backwards, right? So it doesn't, the two things that really matter, right? Besides just the holes are what they are. They came from the criminalist, right? Like, in other words, what she said here, that goes without saying. That's not a curative instruction. That's just like, here's what the evidence is. The curative instruction is the part that addresses the misrepresentation by the Commonwealth and the effect it had on the testimony of Dr. Wolf. So that, of course, was not included. So, Thank you, James. Thank you. Thank you. You're welcome, Kim. You're welcome. No squirrel left behind, as I always say. So, okay, let's jump into some of this testimony. At some point, we'll do a break for some show and tell stuff from the law firm. Okay, so, all right. Like I said, I think that first of all, let me just say, because you guys know I'm able to get bits and pieces. Here's what I saw of today's testimony. As I was driving home, I kind of skipped around. I watched a little bit of I think it's at the beginning of the day, their initial arguments. I saw some of that. And I happened to just randomly go to the part when I skipped ahead, just because I wanted to just take a look and see kind of what happened. I skipped ahead, and it was literally at the part where they're grabbing I don't want to spoil it, so I'm not going to say what it is, but a piece of evidence that had yet to come into trial, and we'll talk about it when we get there. And I literally landed on that part, and I was like, oh my God, I might have to pull over. And then I saw just a little bit of Dr. Laposata on cross exam, just a very small portion. I didn't see any of Dr. RENTSCHLER. But from those tiny snippets that I saw, like I said, I think that there's a lot of really important stuff that happens today that is really, really momentous. So, okay, here we go.
All right. So the order I'd like to do is, Mr. Jackson, yesterday you were going to take a look at any photographs you intend to put in with Dr. Laposata?
Yes, those have been presented to the Commonwealth.
All right. Can I just, are you all in agreement, or are you just looking at them now, Mr. Brennan?
For some reason, the CCs aren't available yet.
Mr. Brennan, but the issues that we have, obviously we're not at this juncture.
We'll have a show and tell.
We're not going to bring in anything having to do with dog bites, claws, dogs in tissue, any of that information. But we are going to bring in exactly what we indicated yesterday. If there's an issue with, for instance, the ecchymosis, we've got a clean copy of the photograph without any of the narrative next to it, which is explanatory. The only one I think that does have narrative is the one with the Lucas machine, which Mr. Brennan indicated yesterday.
All right. So I need to know, just for instructions to the jury, I'm concerned about the photograph on page 5, figure 3. Yes.
Yeah, that's going to be, we intend to show that. That shows the.
So what I would like you to do, if you could, is just crop the center that shows what appears to be blood cells, or the red. I assume that that's the part you want to get into? Sure. If you can crop that, I'll let it in, and I still want to give an instruction, so I need to know what you're going to do with that. I was going to exclude it, but I understand. So if you can crop, yes, if you can do that, I think it takes away some of the sting on the gruesome photographs. All right, so you'll do just the brainstem on that, Mr. Jackson? All right. And so I'm concerned more about the ones that I think may cause the jurors some concern. So the photograph, figure 5, the Wisniewski spots, I thought that was in evidence. I don't know for sure if it's in evidence.
We went back and forth yesterday, and I don't believe that it's actually in evidence. It is not.
Okay, so
it's not in evidence.
Okay.
Yesterday we all assumed it was.
Yes.
I'll put it in evidence as.
All right, they've already seen it, so it's less likely to have an impact on them for purposes of the gruesome photographs. And then on page 8, figure 6, the stomach lining.
Correct, that's already in evidence.
Okay, that's what I thought, Tori, you told me yesterday the number, right? So those are in. So are you using them again?
I'm going to use it again comparatively, probably side by side.
Okay. All right, I don't have a problem with that. Does the Commonwealth?
I don't.
Okay. All right. Those are the ones I was concerned about for purposes of an instruction. If there's objections to hearsay or something, I'll give Mr. Brennan an opportunity to take a look at whatever he's got.
Understood.
Okay. All right. So with that, that's helpful. Thank you. So there is a new the door with the questioning of Dr. Russell to allow.
Okay. So this is one of the snippets that I heard. And this, I think, in my opinion, guys, is the best I've heard, in my personal opinion, of Alan Jackson arguing for the defense. This argument was brilliant. It was succinct. It was impactful. And it did the impossible, which is he managed to get Judge Bev to at least partially, I don't know if agree with them is the right word, but at least partially, what's the right way to say this? At least partially cure what happened here again, from Breenan and the nastiness that he does. Did I see Abby? Abby, happy to see you, my friend. That's awesome. On the way to see her fresh newborn. Love it. Shout out to newborns and nephews. How's your vacation, Mary? Are you still having fun at the beach? Hopefully you're having good weather. And yeah, a lot of these mic drops, so I haven't even seen, but I just had that feeling. Like yesterday was really anxiety inducing, I feel like, and kind of like a lot. Today had a different vibe to it, I feel like. And it's so, this day was just wild, man. So, okay, let's hear this brilliant argument.
Dr. Laposata to talk about bite wounds. So I've read that.
Correct. I'd like to be heard on that briefly.
Okay, sure.
Thank you. I'd like to start, if I may, by marking two documents with the court permission. One is Dr. Laposata's entire report, the second is
great.
her entire CD.
Okay. Yeah, those are the ones I needed from yesterday. So, yes. Yes.
Exhibits DDDD and exhibits EE.
All right, go ahead, Mr. Jackson.
Thank you, Your Honor. We are asking the court to reconsider the court's ruling yesterday concerning Dr. Laposata and her ability to opine on the issue of dog bite and claw mark wounds and pattern recognition. We had some concerns yesterday and previous to yesterday about an issue that has been ongoing with the Commonwealth, and we brought this to the court's attention. The Commonwealth has been using a tactic to shift the burden to the defense with cross-examination that's laced with indications or implications about witnesses that may or may not be called by the defense. That is a problem. I brought it to the court's attention at sidebar. The court will probably remember that colloquy. It was not an open court, but I expressed grave concerns, to use that phrase, that there was a burden-shifting system that was going on when Mr. Brennan is asking our witnesses about, or his witnesses, about other witnesses that may be on the defense witness list and may be called. Obviously, as the court knows, foundationally, we don't have to call anybody. We don't intend to call anybody. We don't have to call anybody, but we can call whoever we feel like. But we shouldn't be put in a position where our hand is forced to call witnesses because of questioning by the Commonwealth, which is improper. After I brought it to the court's attention, Mr. Brennan has continued along that same line. The Commonwealth has continued along that same line, and I want to bring something to the court's attention specifically. Last night, we pulled the tape. Dr. Russell was cross-examined by Mr. Brennan on the issue, specifically, of Dr. Laposata and her opinions regarding dog bites. He asked questions over and over and over again. The colloquy probably lasted more than 5, 6, 7 minutes with Dr. Russell, specifically on the issue of whether or not she had seen Dr. Laposata's reports, whether she was aware of Dr. Laposata's opinions, implying that Dr. Laposata had opinions about the dog bites. She was asked if she was familiar with Dr. Laposata's credentials. Dr. Russell said, yes, she was familiar with Dr. Laposata by name, that she thought she had impeccable credentials, and she very much wished she could have seen her reports as it relates to dog bites. It was an intellectual curiosity by Dr. Russell that was evoked and elicited by Mr. Brennan on cross-examination of Dr. Russell. She was then asked the seminal question: did the defense, Dr. Russell, give you any reports by Dr. Laposata related to dog bites?
What page is that on here?
On the transcript?
Hi, Iowa.
Oh, my motion's back at the desk.
Oh, I see it.
I'll just read it. Question by Mr. Brennan to Dr. Russell. And so you think, of all those forensic pathologists, medical examiners, you think that qualification and experience itself is not enough to qualify someone to give an opinion on a photograph about the genesis of a wound related to dog bites? Answer: well, if a forensic pathologist autopsied 1 or 2 cases of dog bite wounds versus my experience with over 500 to 1,000 cases of dog bite wounds, I'm not sure that person would be a very good expert in that kind of case. Question by Mr. Brennan. Have you ever heard a doctor named Laposata?
So are you going to read all 3 pages?
No.
And what's wild is this followed, let me try to think. This followed, no. Right, no, yes. Okay, so like back to back, you had the issue with the hoodie, right? And then you had this ruling on Dr. Laposata not being able to talk about the arm and the dog bite and whatnot, right? And then of course they went back to Dr. Russell from whenever that was last week. And I actually remembered, I didn't comment on it last night, but I remembered this whole bit about the questioning about Dr. Laposata and how Dr. Russell already knew her ahead of time and really respected her and da-da-da. And like, I remember thinking, the defense isn't saying anything about this yet, but now they are. It's like crazy, right? The back to back, and there's more to come.
So I've read it, Mr. Jackson.
I'd like to read it into the record, Your Honor.
It's in the record. I will put this transcript into the record. I'm not going to let you read 3 pages here.
It's not 3 pages, Your Honor. It's about another 5 lines.
The
It just
part
goes to
that
the
you
top of the
brought
next
to
page.
my attention is on page 15, not where you're reading.
Colloquy between Dr. between Dr. Russell and Mr. Brennan was specific to dog bite wounds. It was specific to Dr. Russell's understanding of whether or not Dr. Laposata had been retained by the defense, whether she was a defense expert, whether she had written a report, and whether she opined about dog bites and dog bite wounds. And after she was asked if she had been provided any reports by the defense attorneys specifically, from Dr. Laposata related to dog bite wounds, Dr. Russell said, no, I haven't been. And to summarize her statements, which the court has in front of it, Dr. Russell went on and said, I really wanted to see what Dr. Laposata had to say about these dog bite wounds. I really wanted to read her report. But no, I was never provided her report or reports by the defense. And of course, Your Honor, as the court knows, that is standard operating procedure. I don't trade reports between and among experts because obviously I want independent analysis. I don't want to cross-contaminate any opinions, et cetera, and be accused of doing so. So of course we didn't provide a report from Dr. Laposata to Dr. Russell. But Dr. Russell's intellectual curiosity was then extracted from the witness stand, and the jurors heard all of that. So then days later, not weeks, not months, 3 days later, 3 days later, after eliciting testimony from Dr. Russell about Dr. Laposata having a report, being hired by the defense on the issue of dog bites and not providing that report to Dr. Russell, the Commonwealth then moves to exclude the very testimony that he was eliciting from Dr. Russell, leaving the jurors with a very, very deep and irremediable misimpression. They used it tactically as a sword and a shield, and that's burden shifting. That leaves the jury with the impression that Dr. Laposata was consulted by the defense, number 1, that she wrote a report, number 2, that the report was about dog bites, number 3, that she didn't provide that report to other experts, number 4, and the reason she didn't, obviously, is because her opinion, Dr. Laposata's opinion, would be harmful to the defense. That's the only reasonable interpretation of those facts. And the Commonwealth has taken advantage of that. The Commonwealth's questioning of Dr. Russell about Dr. Laposata and her report and her opinions about dog bite wounds specifically was deliberate, and it left the jury with an open question. We know they consulted her. We know it was about dog bites. This is how the jurors are thinking about it now. We know they consulted her. We know it was about dog bites. They hid the report from Dr. Russell because they didn't want her to know about it. Ergo, must be harmful to defense. Now we've got Dr. Laposata on the stand. Her credentials.
And the thing is, like, this whole thing is planned, right, from Breenan, because then what does the Commonwealth do? After asking those questions, the Commonwealth objects to her being able to testify, to her being Dr. Laposata, anything regarding the dog bites. It's horrifying.
Are peerless.
Oh, happy birthday.
Absolutely peerless. They've got possibly the most qualified medical examiner in the country, certainly on the Eastern Seaboard, right in front of them, about 6 feet away, and the defense is not going to ask a single question about her opinions concerning dog bites when she reviewed the entire autopsy. How is the jury going to conceive that? How is that going to land with them?
Yeah.
The answer is they're going to think, they have no choice but to think, the only reasonable explanation is, if Dr. Laposata's opinion helped the defense, they would ask her.
He's absolutely right. And the other thing is this, that Dr. Laposata comes across as so credible and all that it's like, again, the jury would be thinking, and I don't know yet what she's going to testify to as far as or what she would testify to as far as the dog bites and whatever. But regardless, of course, I can only imagine it's going to be logical, and it's going to then therefore, be something along the lines of, it's a dog bite, and it's going to be something that it would support what Dr. Russell said. So if you're the jury and it's like, oh, they've got this really, like the jury might perceive, again, like we talked about this last night, right? The jury might perceive some jurors might perceive Dr. Laposata to be even more qualified than Dr. Russell from a, what's the right word, academic standpoint, and like a scholastic standpoint, if you will. You know, because some jurors might think, oh, like that's, you know, more qualified, especially given that she only does autopsies. So she's done more autopsies than Dr. Russell. I mean, it just depends on the juror, right? But regardless, you've got another really, really, really highly qualified expert. And yeah, the jurors would be thinking, clearly she didn't agree with that opinion. And that's not correct. So
If they don't ask her, it's because whatever Dr. Laposata says about that right arm and those wounds, it's got to be harmful to the defense. They would absolutely ask the question. So the Commonwealth got to have it both ways. They got to ask Dr. Russell about Dr. Laposata and imply that Dr. Laposata had opinions about dog bite wounds. And then they have it the other way, which is, let's ask the court if she will exclude Dr. Laposata from testifying about the very issue that they brought up in front of Dr. Russell. That cannot stand. That it reasonably ensures that the jury will misrepresent or misunderstand the import of why we're not asking Dr. Laposata about her expert opinion, especially as it specifically pertains to dog bite wounds. I want to talk for just a second, and that has, by the way, that has constitutional implications. Ms. Reed is entitled to a fair trial. Not a fair trial that the Commonwealth designs.
Yes.
Not a fair trial that the Commonwealth curates, but a fair trial.
Let's hear that again. This is brilliant. Jackson bringing it today.
Constitutional implications. Ms. Reed is entitled to a fair trial. Not a fair trial that the Commonwealth designs.
I mean, that's hugely important because literally that's exactly what has happened here.
Not a fair trial that the Commonwealth curates, but a fair trial. Regarding Dr. Laposata's credentials, we went back through, specific to the court's questions yesterday, her resume. There are no fewer than 13 classes, 13, that she has taught specific to wound pattern recognition that have included dog bite recognition. On page 7, she was the course director for medical legal death investigation. That was in 2013. She taught about dog bite recognition in that case, or in that course. She was a thesis advisor for Master of Science Graduate Medical School, Boston University School of Medicine, taught about dog bites. Staying with page 7, forensic pathology course director in pathology, course 205, taught about dog bites. Member of Quality Assurance Committee, Training Division of Trauma and Surgical Critical Care, teaching on the issue of wound recognition, animal bites, and specific to dog bites. Pediatric forensic pathology, Texas Homicide Symposium. She was a presenter in 1989. She taught about the issue of dog bites as it relates to pediatrics, children, dog bites in children. Forensic aspects of physical child abuse as related to being left with dogs that can injure a child, dog bites, dog bite recognition. These are all classes taught by Dr. Laposata on the issue of dog bites to other medical professionals. The one that stands out, however, and I'm not going to go through the other 9 or 10 or 11, the one that stands out is 2015 and 2016, 2 courses. The name of the course, Emergency Room Forensics, Evidence and Patterned Injuries, New England chapter of the International Association of Forensic Nurses, taught in Norwood, Massachusetts, both times.
Wow.
Specific to dog bites and the issue of dog bites as seen by emergency room physicians, how they should handle them, what they should do with them, how they should view them, what to look for in terms of pattern recognition. She's eminently qualified. I will leave the court with one thought. The court indicated when qualifying Dr. Russell, one of the preeminent things that the court mentioned in qualifying Dr. Russell is that Dr. Russell utilized a methodology that the court sanctioned and quoted and said the methodology that she used of wound pattern recognition, dealing with differential diagnosis, utilizing and interpreting dog bites by the method of exactly what Dr. Russell did. Differential diagnosis is something that the court said was exactly why the court sanctioned Dr. Russell and blessed Dr. Russell as a qualified expert, and that's exactly what Dr. Laposata testified yesterday she utilized and utilizes in coming to her opinions and conclusions. Going back to the open door issue, obviously she's eminently qualified, but Your Honor, this cannot stand. The Commonwealth cannot have it both ways. They cannot walk up and say, and leave the impression with the jurors that Dr. Laposata opined about the dog wounds, but we're not able to hear it. We, the jurors, are not able to hear it because obviously that is something that is her opinion, whatever it might be, is harmful to the defense.
Yeah.
When in truth and in fact, it's exactly the opposite. Dr. Laposata's opinion has never wavered. Those injuries on John O'Keefe's arm are from a dog, period, full stop.
Yeah.
Anything less than presenting that to the jury at this point would be to perpetrate an intentional fraud on this jury. Ms. Reed is entitled to more. She's entitled to better.
Yes.
She's entitled to the evidence.
Yeah.
All right, thank you.
Beautiful.
Brennan.
Jackson! Oh, God. Buckle up.
The pattern of conduct that stands out is persistent, repetitive, contrary to court rulings and court orders, and deliberate. And that is the defense uses
About your own conduct?
their witnesses to vouch for their own credibility. They use their witnesses to introduce information they know is not admissible. And they use their witnesses to introduce otherwise inadmissible hearsay.
It's just, Breenan, you're the one that opened the door. You're the one that introduced the whole, look, the defense never asked Dr. Russell about Dr. Laposata. As we know, weirdly, in this trial, the experts are not allowed to opine as to, whether or not they agree with the opinions of other experts. Yes, Breenan, of course, does that with every witness. And same thing here. The defense never asked her about Dr. Laposata. He did. Listen.
Contrary to court rulings and court orders, and deliberate. And that is the defense uses their witnesses to vouch for their own credibility.
As in, talk about the other witnesses, right? He did that. He did that, not the defense.
They use their witnesses to introduce information they know is not admissible, and they use their witnesses to introduce otherwise inadmissible hearsay. Dr. Russell took the stand, and she was led into answers where she was vouching for her own credibility. Dr. Russell promoted herself not only as an expert, but through the defense's questions, as virtually the only expert in America who has the...
No, that was you. He harped on that. We talked about this because it was really annoying. He tried to get her to say that like 25 times, and she never said it. But he tried to say it, that she's the only person in the world, and she never said that. Ugh.
Expertise to give this type of opinion. It is the defendant's tactics that open these doors that they then want closed. The defense had Dr. Russell all but assure the jury that she uniquely was in the position to give any type of opinion regarding dog bites. Inevitably.
Yes, Kim.
When I asked Dr. Russell...
Sorry, I have to read this because this comment is just spot on. Kim says, oh, he's good. He combined deflection and gaslighting in less than 7 words. Yep.
I began asking her about her credentials, whether she thought that she was exclusive. And I mentioned Dr. Laposata. She denied ever reading anything about Dr. Laposata. I did not specify whether she read an opinion about a dog bite. I asked if she had heard about Dr. Laposata. She denied it.
That's not true.
And then she told us that she knew about Dr. Sheridan. Unsolicited, then added that Dr. Sheridan, involved in a previous proceeding, believed that the bites were consistent with dog bites. I don't know how she became aware of Dr. Sheridan's testimony, and since the defense doesn't speak to her about these things, she must have watched it on her own. But inevitably, she introduced inadmissible hearsay and inadmissible opinions. And so the sum zero here is that Dr. Russell has denied that she saw anything relative to Dr. Laposata, ensured that she was exclusively qualified, and introduced an improper opinion of Dr. Sheridan. Dr. Laposata was voir dired briefly. She did not provide qualifications that she has a history of education or training on pattern wound recognition analysis as it pertains to dog bites. We asked her questions about her specific experience. She did not provide a basis. And so her opinions regarding dog bites should not be permitted in this trial.
That's asking if the jury is present. The jury is not present. Jury is not present. They're waiting. Remember, she told them to come a little bit later?
2 things stand out about that speech. Mr. Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse me.
No, I'm not going to.
So,
Wow. No, that's not what I said. Lies.
Brennan literally just said, I didn't elicit any information about dog bites. I just asked about her experience. Question by Mr. Brennan.
That's not what I said.
That is so improper. It blows my mind. It's like, does he think he's a 2-year-old fighting with a sibling? Blows my mind.
Any information about dog bites? I just asked about her experience. Question by Mr. Brennan.
That's not what I said. That is
Excuse me.
No, I'm not going to.
so I heard what Mr. Brennan said. You don't need to tell me what Mr. Brennan said, but go ahead to
How
your
about if I quote
argument.
his words? How about that?
Yes.
Question. And so you think of all those forensic pathologists, medical examiners, and you think qualification and experience itself is not enough to qualify somebody to give an opinion on a photograph about the genesis of a wound related to dog bites? The question was specific to dog bites. That's how he introduced the subject matter to Dr. Russell. Then his next question was, have you ever heard of a doctor named Dr. Laposata? Those were his words. Then he goes on, I think he also just said that he did not elicit information about other individuals, including Dr. Sheridan or anybody else. Question by Mr. Brennan. Were you ever told what other people's opinions might be regarding those photographs? That's the question that she was answering when she said, quote, I'm aware that there was a Dr. Sheridan involved in the previous proceeding, and he believed that those were consistent with dog bites. That was in relation or in response to Mr. Brennan's specific question. She didn't just elicit that. She didn't volunteer it. She said it because he asked her. And that was all by design. The entire thing has been by design.
Yep.
We elicited the information suggesting that Dr. Laposata was being hidden from Dr. Russell because her opinion would harm the defense. He left that with her on purpose, then turned around and 3 days later said, and by the way, the defense should be disallowed from using Dr. Laposata to talk about the very dog bite wounds that I asked Dr. Russell about. That cannot stand as a slogan.
Go ahead.
It's helpful if you read the entire thing in context, which I won't do. We always have a right to object to an inadmissible opinion. So the suggestion that somehow an ambush here is not only misplaced, it's strategic by the defense to try to create a narrative. It's improper.
All right. I'll be out in 10 minutes on this, and we'll get started right away with Dr. Laposata.
All right, record, please.
Okay.
Nothing to see, hear, or read anything about this case since we left yesterday. Everyone's in motion. All right, can we have Dr. Laposata back,
Already,
please?
so you guys, are y'all familiar with the goal thing? That's a newer YouTube thing. I don't know that every channel has it yet. I think it's like a beta. Are you guys interested in doing anything with that? I'm looking at the options here. I know Runkle does it. It might be the only channel I know of that does it, though. I just don't know if everyone else has it. The defense diaries actually might have it. I don't remember. I don't know. Yep, very well.
Dr. Armani, you're still under. Thank you.
Thank you. I will.
Good morning, Dr.
Morning, Your Honor.
Wait, Kim's asking how long has he been a prosecutor? Are you talking about Breenan, Kim? So I can answer that question. Are you talking about Breenan? Because if you're talking about Breenan, he's really a defense attorney. He's a special prosecutor on this case. You know, when they bring in those defense attorneys. So I don't know that he was ever a prosecutor. If anyone wants to look up his background, you know, oftentimes defense attorneys are prosecutors first. But I don't know. I wouldn't be surprised if he's never been a prosecutor, except for maybe when he's invited as a special prosecutor, which means a defense attorney, but in wolf's clothing, as it were, like a sheep in wolf's clothing, in a costume, right? Obviously, he's not trying this like a prosecutor. I really feel like he doesn't even have the right to be called a defense attorney at this juncture because there are no ethics, dude. It just blows my mind. Oh, it's not a leaderboard. And the leaderboard is different than a goal. And I don't know if I have the leaderboard thing yet. That's a different thing. Y'all are saying it's distracting. The goal is just like for you can set a certain number of super chats and then pick a goal for like how, anyway, it seems like you guys don't care. So we'll just carry on. Okay.
All right, Mr. Jackson, go right ahead.
Thank you, Your Honor. Good morning, Dr. Laposata. Nice to see you again.
Good morning. Glad to be here.
Yesterday, when we last left off, we were talking about a small injury to the upper eyelid of Mr. O'Keefe. Do you recall that?
I do.
Can we have Exhibit 165 with the court's permission, please?
Okay.
And what I will note, one thing that I was thinking of, you know, it used to be that you got like, as a creator, you got like, I think it was 10, you got a certain number of memberships that you could gift per month. And I was able to do that a few months ago. And I didn't know that it existed until I think it was Mandy, like of Miss Mandy Reacts told me. And then it worked and I was able to gift memberships. And then I've been literally checking ever since. And it's been way more than a month. It's been probably 2 or 3 months. And it hasn't given me that option again. And I don't know what that's about, but anywho.
I'd like you to take a look at a specific area. I could. There we go. Right here on this exhibit. Do you see that area?
Yes, I do.
Tell us what that is.
And that is a horizontal splitting of the skin, which was caused by application of force that overcame the tissue's resistance, so the tissue split. And behind that, we see the raccoonite discoloration of the eyelid from the basilar skull fractures.
Can we have exhibit
And one thing
13?
I would say is like, I don't think the goal gives you an option to do gifted memberships. I wish it had that because I think that's a lot more fun. And yeah, I mean, I love the idea of setting goals, just that's like my personality. I don't like the idea of like I think the goal thing is fun, but like the money thing is weird. So we can always just set our own goals. Like if I don't know, let's say, what would be a different thing we could do? Like as soon as we reach 10 objections, perhaps something like that. Like instead of like 10 super chats, it's like when we reach 10 objections in a row, right? Then we have a goal, and it could be like different pictures in the law firm or a different story or whatever you guys want. Anyway, you guys just let me know if you want to do anything like that.
Please.
That's not.
I want to draw your attention to this area of the vehicle. First of all, do you recognize this photograph?
Yes, I do.
How do you recognize that photograph?
I recognize it from looking at it in my materials reviewed, that it's the rear of Miss Reed's SUV.
Taking a look at the area that I'm highlighting, right about there.
Yes.
Can we zoom in on that area? Do you see that overhang over the window?
Yes, I do.
If I use the word spoiler, would you understand what I'm talking about? Call that
Yes,
spoiler?
yes, I do.
You wouldn't call it a wind wing?
Is the laceration to Mr. O'Keefe's upper eyelid that we just looked at, is that consistent in your opinion with a strike from that area of the vehicle if that vehicle were traveling in reverse at say 20 plus miles per hour?
No, that rounded, thick area would not cause that skin defect in his upper eyelid.
If in fact a person were hit at say 20 plus miles an hour in the face with that rounded edge, what kind of what kind of injury would you expect to see on that person's face?
I would expect to see a ribbon of bruise that would correspond to the height of that spoiler, and it would go across the eyeball, it would hit the nose. So I would expect to see some horizontal ribbon of bruise.
Did you see anything consistent with that, with Mr. O'Keefe's injuries?
No, nothing.
Thank you. We can take that down. We talked yesterday about this phenomenon known as coup contra coup injury to the brain, correct?
Yes.
What happens to the brain after a coup contra coup, a significant coup contra coup injury?
Yes, this was quite a severe brain injury. Was injured on the back of the brain and also the front of the brain. The falling back and impacting the back of the head made the skull fracture radiate along the base of the brain on the right and left sides. It also radiated around on the side of the skull, and that indicates a tremendous transfer of force and energy to the skull and then to the brain. And the brain is rattled around, therefore, within the cerebral spinal fluid in the skull. So what that does is that it breaks the connections between the neurons in the brain and causes small little hemorrhages, and it causes the brain to swell. So when you get an injury, like if you get an injury on your arm, it starts to swell. The same thing happens when that injury energy is applied to the brain. The brain starts to swell. And unfortunately, the brain, when it swells, it doesn't have anywhere to go because it's encased in the skull. So what happens is that the brain and the brain stem under the brain starts to go down the opening in the base of the skull where your spinal cord goes. And that is a harbinger of death, because that means
A harbinger of death. I love that.
the brain stem is getting pushed down in this hole in the skull and compressing the areas in the brain stem which control the heartbeat and breathing, and that's called brain stem herniation, and that you just die after that. So that's what happened to Mr. O'Keefe's brain.
I have a document to approach with.
There, I pinned the message to make it look like a other goal, like the one was for money.
If you recognize it.
O'Keefe, Looky, and the whole hemorrhages,
How do you spell that?
D-U-R-E-T, with a little accent somewhere there.
Just getting these into evidence. So
Over the E.
Neurons, a harbinger of
okay,
Your Honor, with the court's permission, with the redaction.
And I'm instructing you again that your verdict must not in any way be influenced by the fact that these photographs, you'll see some more today, I believe, that have already been introduced into evidence. So you're not to Your verdict must not in any
Was there already a sustained objection that I missed because I was putting this in the chat? Let me know.
way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant's entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by the photographs. Importantly, consider the photographs only as they may draw your attention to a clinical medical status or to the nature of Mr. O'Keefe's injuries themselves. So again, these will be presented to you in the deliberation room in an envelope. But today you'll see some on the screen, and I just wanted you to know that before you see it. So now you can display it.
You want me to approach very briefly?
Yes.
If you wouldn't mind taking a look at that document.
Oh,
Is there
yes.
a redacted version or a version of just the brainstem?
Yes, this photograph shows the cross-section going this way of the brainstem with the hemorrhages caused by the brainstem going down into the foramen magnum.
With that, Your Honor, actually, if with the court's permission, I would trade that as the next in order rather than the unredacted version.
All right, is there any objection to this?
Did I miss a sustained objection?
Switching the exhibits like?
So this is going to be the next exhibit.
That'll be it.
Say a cross-section across the brainstem of Mr. O'Keefe, and it shows where the blue arrows I've put in there show the red areas, which are areas of bleeding, which is the sign of brainstem herniation. All the background is white material, and that's part of the appearance of neurons in the brain. So that shows that the brainstem, because of the brain swelling, pushed it down into the hole in the base of the skull where the spinal cord goes, and it pulls on the blood vessels, causing the blood vessels to break and the blood vessels to bleed. And that shows you that the brainstem has been compressed and damaged, causing.
So I'm going to skip ahead a little bit, and here's why. This is the least maybe monumental part of her testimony, and this is not being contested, right? This is in line with what everybody else says. So let's just skip ahead a little bit. You know what I mean? The nature of the coup contra coup, like, we get it. Okay, let's just see where it's
Over here and over here, and also some of this is also bleeding with the blood looking brown because the brain was placed in formaldehyde. So all this brown area, the red area.
Again, the brain,
After they suffer a coup contra coup injury of this magnitude with the concomitant injuries that you see in the brainstem.
Well, there would be
Okay, this is more important, I think.
two parts to what that injury would cause the body to do. First, there would be immediate unconsciousness because of the transfer of all the energy to the brain and the massive skull fractures. So that,
Immediate unconsciousness.
excuse me, so that would disrupt the normal function of the brain and produce immediate unconsciousness.
That
Then the
matters.
brain would start to swell, and within 15, 20 minutes or so, then that brainstem starts to go down the opening in the bottom of the skull, and then the blood vessels are broken, the brainstem.
This is very much in line with what we've heard from the other experts, that he would be immediately unconscious, but he would have been alive for a little bit longer. They can't say exactly how long. I believe I think she says something like, she thinks that he would have died sooner, died. I mean, I guess he was still technically alive. Anyway, I think she thinks that the head injury was more of a contributing factor than the supposed role of like any type of hypothermia, which is a little bit different than what the other Dr. Wolf testified to. But I mean, I think overall they agree with on a lot of things. Again, for our purposes, the most important thing that everyone agrees on is he would have been unconscious immediately, right? Which means he couldn't have moved anywhere. So
stem gets compressed, and the centers in that brainstem, which control the heart and the respiration, then stop. So you go unconscious, brain swells, then you die.
Turning to the actual, your review of the actual brain in this instance, Mr. O'Keefe's injuries specifically, did you reach any conclusion or opinion to a reasonable degree of medical certainty about his incapacitation, the length of time it would take for him to become first incapacitated and ultimately to be rendered dead?
He would be immediately incapacitated with a decreased level of consciousness. Once he received that impact on the back of the head, he would not be able to make any purposeful movements. There might be some arm jerking or some seizure activity, but he would not be able to carry.
that's what Dr. Wolf said.
He wouldn't be able to get up. He wouldn't be able to walk. He wouldn't be able to do any purposeful activity. He would be severely concussed, unconscious, not able to walk, not able to carry out purposeful activity. And then as the brain continues swelling and that brainstem gets compressed, then the heartbeat is disrupted, the breathing is disrupted, and then those heart and breathing stop. And within 15 or 20 minutes, then he could be dead.
Is that opinion to a reasonable degree of medical certainty?
Yes, it is.
And Kim's asking a great question that I know a lot of people have been wondering, because the impact of the alcohol so far, and again, I haven't heard all her testimony, the impact of the alcohol so far hasn't really been brought up a whole lot. you know, the closest thing so far was like the Wisniewski spots or whatever, but that's not really like how that would affect the time of death or anything like that. So Kim is saying alcohol thins the blood. I wonder if that had anything to do with time of death. Well, the other thing that alcohol can do is affect your body temperature, right? I think it's supposed to make you hotter. So I don't know if that, I mean, you know, anyway, if he had had a lot to drink, certainly that would have had some impact on the, I mean, you know, it's not like he would have survived the head injury. I mean, regardless, right? But it still could have had some impact on what took place afterwards and the timing of it all. But yeah, no one's really gotten into that. So I wonder if we'll get to hear more about that from this witness.
He testified concerning wound pattern recognition pretty extensively during the course of
I will say, I do think that the defense potentially, and maybe why we haven't heard much about that yet. And again, I don't know if we will, but to the extent that we don't, I think that the defense potentially might be being careful, because I think that you have to be, what you don't want is you don't want it to seem like victim blaming in the sense that it's like, oh, he was super drunk and like that was a contributing factor, you know, if that makes any type of sense, because especially when, even if he'd been sober, right, the head injury would have killed him regardless. I think that even if he wasn't in the snow, it would have killed him regardless, right? I mean, that's pretty clear. So I think that even if he'd been found and then immediately rushed to the hospital, I don't think he would have survived. So in other words, it's almost like, would it be worth it to risk that with the jury, you know? But I mean, for the sake of having a full understanding of the total picture, I think it's important. So
your giving your qualifications. What is a patterned injury?
A patterned injury is very basic to the training in forensic pathology and medicine, because it helps us understand some change on the body, some pattern injury that corresponds to the object that made it. So we can look at an injury and say, we can figure out what made that. Sometimes you can, sometimes you can't. But a pattern injury is very important for a forensic pathologist to recognize, because it's going to really help the police investigation. Because I can say, oh, this looks like it's a wound from scissors. This looks like it's a wound from a screwdriver stab. So by identifying the pattern that that object makes on the body, I can help the death investigation by helping the police say, you know, look for some screwdriver, look for some hammer. So look.
Those are really good examples that totally are relevant as it pertains to identifying dog bites, right? I mean, the scissors. I personally have seen, or, you know, I've heard, I don't know that they've gone to trial, but I've heard of many different cases where somebody killed somebody with scissors. Also, I've seen at least 1 or 2 screwdriver instances. So she makes a really good point here with that, you know, and especially when it's like a sharp object, but it's not as common as a knife, right? You can find that and potentially find that in the house or whatever, and you could maybe get the murder weapon. But yeah, great point.
Looking at that, identifying a pattern injury is really important it's basic to the forensic pathologist's knowledge base, and then also very important to the investigation of the crime or incident.
Yeah, people are investigating, that is, right?
I'd like you to look at another photograph, an exhibit that's already been put into evidence. 160, please, with the court's permission.
Meg, is that
Yes, sure. This may be one of the photographs as well. Right. Or there'll be a series.
Why does she make such a big deal
Dr.
about
Laposata, I want to draw your attention to the center
in every trial there's graphic pictures? It's just
of
weird.
this photograph.
Yes.
First of all, do you recognize what's depicted here?
Yes, I do.
How do you recognize?
I recognize it from reviewing the autopsy photographs of Mr. O'Keefe.
You reviewed it, informing your opinions and conclusions?
Yes.
Can you describe what's depicted in this photograph? What are we looking at?
Yes. So we're looking at the back of Mr. O'Keefe's head, and an injury caused by the angular acceleration going down and hitting his head in the back. And then this is also a pattern injury. So what we see is the horizontal tear of the scalp, and we can see it's undermined a little bit. So that means the direction is going from bottom to top. Also, we see these sort of vertical lines in here and down below. So what that tells me is that the back of his head hit something that had a fine granular pattern to it to cause those individual little marks. And then also something that had a linear or ridged pattern that he went back on that broke the scalp there. So we have 2 parts really to this pattern injury. We have the horizontal tear of the scalp made by impact with some sort of ridged surface. And then we have these vertical scraping of the skin above and also below. They're obscured a little bit by the ruler there, which says that whatever he hit had some little like granularity to it with each little sort of granule making those vertical marks, and then the ridged pattern having the major point of impact.
What is the significance of the pattern when you say ridged pattern? And there's two things we're looking at: the laceration or the abrasion versus the defect above and below that laceration.
Yeah, so what this injury tells me, what I would tell the investigators, is that Mr. O'Keefe went back onto some object that had some sort of ridge to it to make that horizontal tear in the skin, but that ridge also it wasn't smooth. It had some little grainy grainy thing sticking up on it that would make each of then these little things. And then it's the job of the police then to go back to the scene and look around for something which might fit that pattern.
We can take that down. Did you, in furtherance of your investigation,
Even that right there, that goes to Bowden. I mean, I don't know that they're still even trying for that. There's so many other issues right now, right? But right there, I mean, what she's saying is they should have recognized this pattern and gone and looked for something that could have created that injury on the head, which we all know how that went.
coming to your opinions and conclusions, look at the area of 34 Fairview?
The outside, yes.
Meaning photographs?
Yes.
Did you also see photographs of any significance to you related to the garage, the interior of the garage?
Sustained. Jurors, disregard that.
I don't know about the ground floor.
What part of the area did you see? What part of the...
So she testified, so she mentioned the lateral marks, but what she said yesterday, when she initially on direct, and I'm sure she'll talk more about it, but what she said was the way that those look, it indicates that it hit a ridged surface. So if it was outside, the only thing I could think of that could have caused that would have been the berm, as it were. However, we know how far away he was found. Well, we don't know exactly because nothing was measured, but he wasn't found on the berm, right? We know the whole thing, he would have been unconscious right away. So if he fell backwards and hit his head on that berm, he would have been on the berm, and he was not on the berm. He was in the yard from, 6, 7, 8 feet away from the berm. So that could be problematic, but she did say a raised surface. So
location, did you see?
I saw all the scene photographs taken by the police, which showed the front yard in the area where Mr. O'Keefe was found. I also saw some photographs of the inside of the house and the inside.
So I'm going to stop you there, Dr. Laposata. Jurors, I'm striking anything after the pictures from outside, Mr. Jackson.
I have to note that there was actually not an objection. That was Bev doing that thing again, which is disgusting.
Found. I also saw some.
I forgot, right? If she jumps in and without an objection from the Commonwealth and just decides to randomly strike shit, that doesn't count towards the goal because we need an objection from the Commonwealth.
Photographs of the inside of the house and the inside.
So I'm going to stop you there, Dr. Laposata. Jurors, I'm striking anything after the pictures from outside, Mr. Jackson. Move on.
Yeah, the
Let's
berm
stay with the outside of the home.
like a curve.
Did you see the front lawn area?
Yes, I did.
What did you note about the front lawn area?
Well, I was looking at the area where Mr. O'Keefe's body was found because we know once he came back and slammed his head, he's not going to get up and move around.
So
There's
I'm
one.
going to strike the second part of that.
Okay.
Answer the question specifically.
Okay, I'll try, Your Honor. Thank you.
Why were you interested in the outside area where his body was found?
Because then I could identify an object possibly there that would have caused the injury on the back of his head.
Did you see any such object in any of the photos that you reviewed?
No, there was nothing there. It was a flat grass surface.
Would the flat grass, let's assume that the grass was very cold and very hard, the dirt was very cold and very hard.
Okay.
Would falling backward onto that dirt, hard or not, would that cause the patterned injury that you see, that we just saw in Exhibit 160?
No,
Why do you say that?
because if you fall back on a flat surface, you get many times the tear you get in the scalp can be more like a star because you've just hit one part and then the tears go in kind of a star pattern. And also because you would not have those discrete vertical scraping of the skin. You would tend to, if you fell back on grass, you might see grass in the wound, or you would tend to see an irregular kind of crisscross
That's
pattern.
another great point. I never even thought of that. I don't think this has come up before. There was no grass in the wound. And I know for anyone who's like, well, there was snow. We know there was only enough snow to track a cat, right? And as deep as that gash was, there was no grass in the wound. Another interesting point. Again, it would make more sense if he was moved there later, there would have been more snow accumulated and then hence no grass, right? Well, and also, I should add, you would be less likely to have grass in the wound if it was like you were set there versus like the big time fall, right? Like if you fall and there's like the force and all that, and it's like that actually causes the wound. You can imagine how the force of the head against the ground would be more likely to get some grass in there, you know what I mean? Versus like if somebody just sets you there or what have you.
flattened grass.
Right.
And that's not what we have here on Mr. O'Keefe.
Do you have any training or experience in diagnosing hypothermia in individuals?
Oh, yes.
Have you conducted autopsies of individuals who've suffered from or died from hypothermia?
Yes, many.
How many?
No, 100 or more, and then I've supervised my assistants who've also diagnosed the same death from decrease in body temperature.
Have you ever engaged in any death investigation, aside from the actual autopsies, death investigations in which the cause of death was deemed to be hypothermia?
Yes,
How many times would you say you've undertaken that type of investigation?
at least 100.
Have you ever reviewed any peer-reviewed medical literature associated with or discussing hypothermia and something known as Wisniewski spots?
Yes, that's in the medical literature and also in our forensic textbooks.
Did you review the medical examiner's file, Dr. Scornbello's file, as it related to, well, in connection with this case, you reviewed the entire file, correct?
I did.
Did you conduct a differential diagnosis as it relates to the potential for hypothermia?
Yes, I did.
Describe, before we get into your findings or your conclusions and opinions, what is inferential thinking?
Inferential thinking is another name for making a differential diagnosis. In other words, seeing a finding and then saying, how many ways can I get that finding? And then go and investigate each one of those ways and either rule them in or rule them out as being responsible to causing that finding.
Did you note whether or not the medical examiner, Dr. Scornbello, mentioned hypothermia as a potential cause of death in this case,
She did put that on the death certificate,
along with something else?
along with the blunt force head injury.
Do you agree with or concur with blunt force head injury as
Yes,
a cause of death?
yes, Mr. O'Keefe died from the blunt force head injury.
Do you concur with the diagnosis of hypothermia?
No, the body did not have any hypothermia.
What led you to that conclusion?
Well, when you have we know that normal body temperature is around 98, and we know that then at the hospital that Mr. O'Keefe's rectal temperature was around 80. So we know that his temperature went down. So there are two ways the body temperature can get down. It can get down while you're alive, or a dead body also cools when it's in a cold environment. So those are the two things you have to look at.
I want you to take a look.
I certainly hope, and I would expect there's more. I would imagine there's got to be more than that for her to say that she doesn't think the hypothermia was a factor, but I'm sure she'll talk about it. Kelly's asking, who said the track a cat comment in this trial? I'm forgetting his name. It was the Commonwealth expert, the weather dude, who talked about the hardness of the ground and the coldness of the ground and whatnot. That dude. I'm forgetting his name.
Show Mr. Brennan.
This is a photograph of the stomach abrasions throughout the stomach, which are called medically visual.
Describing it, but they're just getting into evidence. So I'm gonna go ahead.
Speed gets break, and then findings I look. Yes, we're due.
Okay.
So this is exposure to a cold environment, and this is the stomach has been opened, and we're looking at the inside of the stomach. And the normal appearance is kind of pinky white. That's how it should look like. And what's abnormal here is all these black dots, which are the Wisniewski's ulcers, which are diagnostic of death due to exposure to the cold. So these areas are little tiny craters, and they fill up with blood. And we see that in over 90% of the cases of people who die from exposure to the cold.
Doctor, did you also look at Mr. O'Keefe's stomach lining?
Yes, I did.
If we could have, with court's permission, Exhibit 164 put up as well.
Okay.
Do you see the photograph on the right?
Yes.
What is that of?
This is the Mr. O'Keefe's stomach, which has been opened up, and we're looking at the inside. We see that the mucosa is a little bit red, and there's a little bit of increased blood flow here. And this is the normal pattern of the inside of the stomach. It's kind of ridged. That's called rugae. That's the normal folds inside the stomach. But there's no ulcerations here. So the diagnosis of death due to hypothermia is not appropriate in his case.
Did you see, or do you see, any classic Wisniewski spots in Mr. O'Keefe's stomach lining or gastric mucosa?
No, no.
Do you observe any ulcers specific to Mr. O'Keefe's stomach lining?
No, there are no ulcers. It's a normal appearance of what we would call a gross specimen. When you open the stomach at autopsy, you can see some redness of the normal lining of the stomach.
Did you, let me ask this first. Do you have an opinion as to a reasonable degree of scientific certainty based on the totality of your review and examination of the autopsy and its associated file, an opinion as to whether or not Mr. O'Keefe died of hypothermia or complications related to hypothermia?
I do have an opinion.
And what is that opinion?
He did not die of hypothermia.
And is that opinion to a reasonable degree of medical certainty?
Yes.
Taking a look at the darker red areas in the stomach lining of Mr. O'Keefe on the photograph to the right,
Yes.
that's Exhibit 164, can you describe what those are? What are those darker areas?
Well, here we see a little bit of bleeding. The darker areas are the areas of the lining that are in the bottom of the normal rugae, because the inside surface of the stomach sort of looks like it's covered with little mountains. And so we can get the redness in between what the rugae and the stomach. And there's a little bit of increased redness here, but no ulceration.
Do you have an opinion, or were you able to form an opinion as to what the increased redness might be or is associated with?
Yes.
Did you note anything of significance in the rest of your examination of the file, the autopsy file, the medical examiner's file, that was related to what you see in the photograph 164?
Yes.
Right, I see it's eyebrow for just a minute here.
We can take that down.
Okay, sorry. Kat Randall's asking about, is it coming up, Brennan question about the brain? Well, they're not on cross yet, so it's not, they're still on direct. So it's not coming up for a while.
May I continue?
Yes.
Thank you. With regard to the, it's my word, not yours, doctor, so forgive me, the defects, the red marks that you're mentioning on the rugae or in and around the rugae, on the gastric mucosa, did you note that there was a machine that was used for life-saving measures as it related to Mr. O'Keefe?
Oh, yes, it caused some damage to the body.
Okay, let's talk about that for just a quick second. What is that machine called?
It's a mechanical device to administer chest compressions, and the company that makes it is called Lucas, or one of the companies, so it's called a Lucas machine, and it can be attached to the body. Your arms go up over a ridge, and there's a plunger, and it goes around your back, and so it just plunges, and it does mechanical resuscitation and chest compression, compressing the chest right over the lower sternum, about 2 inches or so, and it's very helpful where the manual compressions, where the attendants and the ERT people, they get tired continually compressing for a long period of time. So the mechanical device was invented to prevent the EMT fatigue when administering chest compressions.
When you mention the sternum area
Yes.
of the body, are there, go without saying, but there are organs beneath the area that's being compressed by
Right below the sternum, which includes the heart. But what is also under there is the esophagus and in the interior of the stomach. So this area is right under, in addition to part of the head of the pancreas, which is also right there under the lower sternum, a depth of compressed between. So you have the Lucas machine compressing these organs, and they're compressing them against the vertebral bodies of your bony vertebral column in the back. So you can get other injuries, organ injuries, that is a complication of the automated mechanical resuscitation. You can get cardiac ruptures, you can get ruptures of the liver, because all those organs are clustered right there, and that machine is pushing those organs in between the pump and the back of the bony spinal column.
machine was used on Mr. O'Keefe.
Yes.
May we can take this down?
Yes.
Finish,
Hey, we've got some more
A cat.
things getting into evidence.
Oh, sure.
Can you tell me what we're looking at? Yeah, let's take the top half of the document. What is that to the left, and then what's the machine in the
Okay,
middle?
so what you see on the left is a anonymous patient showing how the Lucas machine is placed onto the patient, where the arms are pulled up and clasped against these rigid mechanical bridges. And then here is the engine which push the pump, and that's the pump which just goes up and down to do the chest compressions. And so that's how it's affixed to a patient.
To be clear, Doctor, that is not Mr. O'Keefe. That is
No, this is
Could be a model.
an unknown person.
Okay.
Patient. You can see how it encircles the patient, and then there is this circular pump, which is the compressor pump.
If we can look at what is that, a picture of the highlighted portion?
That's the circular part that actually is projected down onto the body.
That makes contact with the chest?
Correct, and it has a spring in there. The engine above it gives a certain number of compressions per minute.
And you said on average the compressions per minute would be about what?
They should be around 100.
Okay, if we could go to the
Is
bottom
it
half of the page.
glitching for you guys?
Graphics on the bottom. What are we looking at in this photograph?
And we're looking at, on the left side, we're looking at a CAT scan, which scans a person who's had some injury from the Lucas compression machine, and it's a cross section. So the arrow here is pointing to the head of the pancreas and the area of the esophagus, and then the machine would compress down onto that And the important part is that, I don't know if that's working on there, the little thing that looks like a,
Things you can get on eBay, Lucas Machine, and what did they call it in Twin Flames? The golden bowl made by a monk or whatever the fuck, or blessed by a monk. Something like that.
not life-threatening usually to the other organs there.
We can take that down. Doctor, take a look at the second document that's in front of you. Do you recognize what's depicted in that document?
Yes.
What is that?
This is a picture of Mr. O'Keefe's chest while he's at the hospital, which shows a lot of the resuscitation equipment.
Is that a true and accurate depiction of the of Mr. O'Keefe at the hospital based on your review of the medical file?
Yes.
I'll move for the admission of that. Permission to display briefly.
Okay.
Taking a look at the photographs to the left and to the right, do you see any indication on Mr. O'Keefe's body
I
that
pointed out here with the blue arrows, that big circular mark there is the mark on the skin where the compression pump compressed the chest of Mr. O'Keefe, and it caused some rib fractures, and it also caused those reddening of the stomach and some hemorrhage in the pancreas.
we can take that down? Doctor, based on your review of the medical records, did you calculate the number of compression calculation?
His body was found around 6 a.m, and he
Yeah, I
got to the
can see it does
hospital
look a little
around
bit glitchy. Let me
6.
try, you know what? Let me try this. Let me try refreshing the stream, because also Court TV, you know what it might be? With live streams, sometimes it varies on how long it takes for YouTube to, what's the word that they call it? Like, kind of like upload it or whatever, like processing. It's like for example, sometimes I'll have a live stream and it's like done processing pretty soon. And other times it's like takes a long time. But the reason I'm saying that is because the CCs aren't available until it's done processing or uploading the way that YouTube does it. And the CCs are not available yet, and they usually are. So let me try refreshing this, and that might fix it. So in the meantime, let me give you guys something to look at here while I pull that down and then refresh it. We're still waiting on our goal. But in the meantime, we'll do a little sneak peek. We'll do a little sneak peek. Okay, how about that? So just 1 second. You guys can wonder what this is and hope we get to our goal. And then I'm going to refresh this, the court feed here. And hopefully it'll also have subtitles, or CCs rather, whatever the case may be. No CCs yet, but let's see if it's better for the glitching at all. Okay. Otherwise, it might just be, I mean, I don't know if it was like this today when it was live. Maybe I need to try a different feed, but we'll see how this goes.
And it's compressing at 100 times a minute. And that is from the time of the body being discovered to the time at the hospital. That's around 37 minutes. So if you multiply 37 minutes times 100 compressions a minute, that's around over 30,000 compressions that would have been done to Mr. O'Keefe's body in the course of his resuscitation efforts.
Doctor, do you have an opinion as to what caused the hemorrhaging that we saw on Mr. O'Keefe's stomach lining?
Yes.
What is that opinion?
It was from the blunt compression of the Lucas machine.
Is that opinion to a reasonable degree of scientific certainty?
Yes.
You indicated earlier that there is a difference between someone dying of hypothermia or complications associated with hypothermia and a body that's already passed away just cooling, correct?
Correct.
Oh yeah, this is what I wanted to hear more about.
Opinion as to a reasonable degree of medical certainty as to whether Mr. O'Keefe suffered from hypothermia.
I do have an opinion.
What is that opinion?
He did not experience hypothermia.
Did you observe any signs of frostbite?
No.
Did that have any weight concerning your opinion, overall opinion, as to whether or not Mr. O'Keefe died with complications associated with hypothermia?
Well, if someone dies due to exposure to low temperatures, you expect to see not only the Wisniewski's ulcers, but you expect to see some frostbite changes in the extremities.
Based on your overall review of the medical records associated with Mr. O'Keefe, were you able to reach an opinion and conclusion as to the cause of death of Mr. O'Keefe?
Yes.
What is that opinion?
He died of brain injuries and skull fractures due to blunt force trauma of the head.
Do you hold that opinion for Mr. O'Keefe's cause of death to a reasonable degree of medical certainty?
Yes.
thing I will say is, as far as the part that I was really interested in, which is like how she's able to say that the change in temperature is not due to hypothermia, she didn't really answer that as much as I would have liked. Basically, he asked her that question, and then he followed it up with like frostbite. And essentially what she said was like, well, usually you would see frostbite. But what I was wanting her to say is, how could you tell if that temperature was due to being cold from being dead at the hospital versus like being left in the snow, for example, right? I mean, and it makes sense that it would be really hard to know that, but of course, I'm also not a medical professional. So I was hoping there would be a definitive way. It sounds like she's basing a lot of that, though, on the lack of frostbite, which I mean is valid, right? But yeah. Oh, Breenan will
I want to shift gears for a minute, Dr. Laposata, and talk about patterned injuries elsewhere on Mr. O'Keefe's body.
I have a feeling that we're going to reach our goal pretty quickly here now that we're getting into this.
You've obviously talked about your training and experience as it relates to recognition of patterned wounds, correct?
Correct.
That's something that you were trained in when you were training, correct?
Yes, it's very basic to the discipline of forensic pathology.
And have you also trained others during the course of your 4-year career on the issue of wound pattern recognition?
Yes.
You've taught courses and given lectures, is that right?
Yes, I have.
I'd like to show you Exhibit 167 with the court's permission.
Okay.
Do you recognize what's depicted in this photograph?
Yes.
How do you recognize it?
Is a photograph of the right arm of Mr. O'Keefe.
Did you review and consider this photograph and others in coming or forming your opinions, coming to your conclusions and opinions in this case?
Yes.
In order to come to your ultimate opinion and conclusion, or opinions and conclusions in this case, is it important to take all of the injuries that a decedent may have suffered into account rather than one or two piecemeal?
Now, you have to look at the whole picture to understand what happened to the body.
Why is that? What's the importance of that? It may be obvious, but explain that for the jurors, please.
Well, when you're looking at changes and injuries to the body and trying to understand what happened to the body, there are different patterns of injuries on different parts of the body. And by trying to separate those and understand what patterns were caused by certain things, then you're able to put together a sequence of events that happened to the body prior to death.
That's a really
What
good
role do
point.
photographs play in?
That's a really good point. So she's saying the patterns of injuries aren't just important in terms of determining the cause and manner of death, but like essentially what happened prior. That's a really, really, really good point.
A forensic medical examiner reviewing the medical evidence and coming to opinions and conclusions. How important are photographs?
Oh, those are huge. It's standard practice to always document at the post-mortem examination important findings with photography.
Were the photos in Mr. O'Keefe's case useful in coming to opinions and conclusions concerning his injuries altogether?
Yes.
What about the injuries to his right arm?
Yes, those photographs are very important to understand those injuries.
Do you believe that there is a patterned injury on Mr. O'Keefe's right arm?
Yes, there is a pattern injury there.
Basically, the closest that the Commonwealth got to trying to explain that the arm injuries were from a taillight was Judd Welcher standing in front of the car and being like, if I hold my arm like this, it could be hit by a taillight if a car backed into me. That's it. Not in terms of the injuries, nothing like that. Not even they haven't even tried. They have not even tried.
Have you ever seen, in your experience, either being taught or teaching, patterned injuries as they relate to animal wounds, generally?
Oh, absolutely. Very common.
Do animal wounds include both claws and teeth, dentin?
Yes.
So bite marks and claw marks might be two different types of patterned wounds that you may see in your evaluation, just in general?
Correct, because when an animal approaches a body, there may be damage from the claws and also from the mouth.
Do you expect to see punctate wounds as well as linear abrasions?
Yes.
Do you expect to see certain bite patterns as well?
Yes.
What types of injuries, let's talk about animals in general, what types of injuries do animals produce on the skin of human beings?
Well, animals can produce, if you're talking about, mammals, they can produce injuries from their claws, where you get parallel scrapes of the skin from the claws applied to the skin, or you can see a pattern from the jaw configuration of the animal. And most animals that attack or get in contact with the body have canines, so there's two canines on either side that make paired marks, and that would be called a pattern injury. So it makes parallel sort of gouges And as the canines move in a horizontal pattern or a vertical pattern, the space between them can change. The other thing you see in a animal bite is you see not only the canines that come out, but depending on how the jaw is applied to the body, you can have little dot-like imprints in sort of a U-shaped pattern, which are from the incisors, the little incisors of the animal. So you look for punctures, you look for paired gouges, which would be the canines, and then you look for arced patterns of little dots, which can be the application of the incisors of.
I'm such a weirdo that when she mentioned the U-shaped pattern, my immediate thought, just automatically without trying, was thinking, I thought contrary to a more pointy triangular pattern like you would have from an alligator or a crocodile. I love crocodiles. Some of you guys know they're one of my favorite animals.
Of an animal bite.
What is an incised wound?
An incised wound is a wound due to cutting from a sharp object.
Would you expect to see incised wounds from an animal bite or claw marks?
No, they don't cause, they're not like knife wounds. They cause more of a scraping injury.
Do you see the injuries that you're looking at in Exhibit 167, are these more consistent with incised wounds or the scraping abrasions that you just talked about?
Sustained.
Now we've got another
Were
one.
you able to determine from your review of the medical records whether the injuries that you see on Mr. O'Keefe's right arm were pre-mortem or post-mortem?
They were, oh yes, I can determine that. They were inflicted prior to death.
Okay.
Do you have an opinion as to whether or not the wounds that you see, the pattern?
I have to say, I don't think that that in either trial that opinion has been offered before as to when those happened, because actually I can say for sure, because there was some thought that maybe it happened after, when he was laying there. That is really interesting. Wow, we're learning a lot.
Right arm were pre-mortem or post-mortem?
They were, oh yes, I can determine that. They were inflicted prior to death.
That's really huge.
Do you have an opinion as to whether or not the wounds that you see, the patterned injury that you see on Mr. O'Keefe's right arm is consistent with an animal bite or claw marks?
Yes, it is, very much.
Thank you. You can take that down.
I wish he'd asked her why or how she knows. I mean, I'm not doubting her, but I want to know. I think it's interesting. I want to know how she can tell that they're from the arm injury is pre-mortem, but maybe that'll come up in trial. We got
I
8
have just
more
a
to
moment,
go.
Your Honor. Actually, Your Honor, may we approach very briefly?
Okay.
Okay, they're approaching. We have 8 more objections to go. Sustained objections.
May I inquire?
Yes.
You indicated that, in your opinion, the wounds to Mr. O'Keefe's arms were pre-mortem, not post-mortem. His right arm, I should say, were pre-mortem, not post-mortem, correct?
Correct.
What's the basis for that opinion?
Well, a forensic pathologist has to be able to differentiate changes that happen to the body while the person is alive versus things that happen after the person is dead. For instance, there is something called post-mortem predation, where if the body is out in the woods and dead, then wolves and such can come and make, quote, injuries to the body. But we're able to tell from our training and experience that those were made after death. The usual way we tell is that when it's made during life, the blood vessels that are damaged, the heart's pumping blood through. So you can see a reddish color and maybe some blood around it. Whereas if the body is damaged after death, the changes to that body and those, quote, injuries look more yellowish and kind of brown.
This is what I wanted to know. Excellent. I'm happy to learn this. This is how she can tell.
Because
Okay.
the blood is not flowing. So that's how you can tell if something done to the body is while the body was alive or whether it was done after death.
Do you have an opinion to a
it's a
reasonable
great
degree of
point because we've seen that arm a bazillion times and they're definitely red.
medical certainty that the wounds on Mr. O'Keefe's right arm were pre-mortem?
Yes, they were done while he was alive and bleeding.
Yeah.
You talked about death investigations. As a matter of fact, you mentioned something about what a forensic pathologist's role is in a death investigation to potentially send investigators back out to answer certain questions, correct?
Yes.
Did you see any evidence in the medical records or the medical examiner's complete records that any effort was made to send investigators to the location to see if there were any animals at the location at or around the time of John O'Keefe's death?
Oh boy.
Sustained.
And there's another one.
Do you believe it's important? Well, let me ask it a different way. Would following up with investigators be an important part of any
Odin.
forensic pathology investigation?
This goes
No, absolutely. You're working as a team to figure out what happened to the body.
Thank you. We talked about the theme and theory of differential diagnosis, correct?
Yes.
How does engaging in the process of differential diagnoses avoid bias in an investigation?
By after you have your findings and you sit back and think, well, how many ways could I get this finding? And so bias sometimes means, oh, I think it's this, and then you just stop. So that's a sort of a bias where you make a decision too quickly and you don't then stop to consider what other things could cause this same finding. So you have to consider not only what immediately comes to mind, but then you think, how else could we get this pattern of injuries?
Did you engage in a differential diagnosis as it relates to this case?
Yes,
Did you consider whether the injuries could have been caused by a motor vehicle accident?
I did consider that.
Did you consider whether Mr. O'Keefe's right arm injury specifically could have been caused by being hit by a motor vehicle?
Yes, I did think about that.
Were you able to rule that out?
Absolutely.
Like, I didn't think about that very long because duh.
Not.
So the objection sustained, jurors strike that answer.
Okay, I don't know why, but also now we have another one for our thing.
A motor vehicle.
Yes, I did think about that.
Were you able to rule that out?
Absolutely. Not.
So the objection sustained, jurors strike that answer.
I have no idea why, but you know, should we be surprised?
Tell me about. Well, let me ask it this way: did you
Kim's excited.
come to an opinion or conclusion as to whether or not Mr. O'Keefe's injuries as a whole were produced by a motor vehicle pedestrian incident?
Sustained.
Why?
You indicated that you've
Why?
done
Why is this?
thousands of autopsies yourself.
I'm wondering-
correct?
Yes,
You've supervised many times more than that.
correct.
How many of those autopsies that you've performed or supervised have involved motor vehicle incidents?
No, hundreds.
How many of those hundreds have involved motor vehicle pedestrian incidents?
Almost as many.
Have you performed autopsies specifically on individuals known to be hit by vehicles?
Yes,
Have you performed autopsies on individuals believed to be hit by vehicles?
yes,
Have you engaged in differential diagnosis and inferential thinking in terms of developing an opinion or conclusion to a medical certainty about whether or not the injuries that you see on a decedent are consistent or inconsistent with a motor vehicle pedestrian incident?
yes. That's part of what we figure out as a forensic pathologist.
Did you do that in this case?
Yes, I.
Sustained.
All right, getting ever closer.
What are some of the injuries that you would expect generally to exist if a pedestrian is hit by a motor vehicle at speed, not 1-2 miles an hour, let's say 20 plus miles an hour?
Yes, one of the things you see is a pedestrian is standing upright and is impacted by this blunt object of a automobile or a van or SUV. And what you see first most is the tissue is crushed where the projections of the vehicle impact the tissue. And when you crush the tissue, that gives you a bruise. So that's the first part of the pattern of impact. It crushes the tissue, it gives you a bruise because it breaks the blood vessels underneath the skin. And then depending on how much more force is applied, the skin can break.
So I'm going to strike that. Next question, Mr. Jackson.
In addition to bruising, what else might you expect to find in an individual who's been struck by a vehicle at speed?
So let's come over to second.
Okay, we got 2 now. We've got 8 now. Getting super close. Oh boy. Go ahead and skip past the sidebar. Sidebar. There's the end. Okay.
May I inquire?
Yes.
I forgot where I left off, so I'm just going to pick up
Okay.
as best my memory can serve me. It has been suggested that Mr. O'Keefe's right arm, doctor, was injured by contact with the right rear taillight of Miss Reed's 2021 Lexus LX570.
No, I'm allowing that in.
Thank you. As Mr.
That was
O'Keefe
a
was struck,
rule.
as Mr. O'Keefe was standing and the Lexus backed into him. That was a postulate put forward. I want to find out from you, do you agree with that?
Well, that's something to think about.
So,
Oh, I'm sorry.
yes, I'm going to strike that question and answer.
Let me ask it a different way. Let me ask you a different question. Do Mr. O'Keefe's pattern injuries on his right arm, do they correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm?
No, not at all.
Why do you say that?
First of all, those injuries are patterned injuries from an animal bite. We have the canines, we have the incisors.
All right, so I'm going to strike that, and let's see what's sidebar.
And we're there. All right, so I got a couple rounds of this that we can do for our goal. We're going to start with part 1 of the fun pictures/stories. Okay, let me actually pull this down. So, woo, we'll get to start. We can start back over again after this. Okay, let me just unshare, reshare here. So we'll start with, let me see here. Okay. Okay, so some of you guys have seen this picture, but just for anyone who hasn't, just to give you some context. So this is my office if you're looking into my office, and there's my window, right? So some of you guys, again, may have seen this. There's some of the filing things that I've made. Now, here's why I had included that one. So now I'm going to show you guys what it looks like. So this is, oh, I need to share my whole screen. Hold on, let me do this better. Let me do it this way. Okay. So now this is my view looking out. So if I'm sitting in my office, then I look out and that's the lobby. So now I'll show y'all the whole lobby situation. So this is the lobby. Very nice. There's the a scanner, copier, printer, majigger is back here. You can't see it. It's in this corner. So there's the lobby. Very nice. And then let's see the conference room. There's the conference room. So I think some of you guys may have heard my mint story, my novel idea. The attorneys all love it. They love the mints. So anyway, when I took this picture, I think it's before we got the mints in. But now this little silver bowl has some nice mints in it. It's the Lifesavers wintergreen ones. So there's the conference room. So this is where I had my interview. And then when they bring clients in, you know, they'll go in there. So basically, if you go from one side to the other, you got the lobby, and then on the far right side, you've got, so it's like the conference room, and then my office is next to the conference room, and then next to me is one of the attorney's offices, and then next to that is the other attorney's office. So it's just the three of us, and then the conference room when it's not in use. Oh, it is super, super, super classy. It's very classy. It is amazing. I've got so much to tell you guys. I'm going to try to do it in rounds, which is why there's this goal situation. So some of you guys have heard me talk about the e-filing thing. So North Carolina is transitioning into e-filing, and it's like a whole thing because you guys know how lawyers are with technology. So I was tasked with like researching it and trying to teach it to the attorneys. But this is the system. I've described this to you guys, right? I wasn't kidding. That's why I took a picture of it because I had to use this today. It's a nightmare. This is the current system for some of the counties in North Carolina. It's from like the 1200s basically. And it's like from when computers were like, this is what it looks like. And when you go past this screen and you start actually pulling up records, I kid you not, it's black like this, but then it's got that neon green. Think like Oregon Trail or something. It's like that neon green. I couldn't take a picture to show you guys because it has confidential information, right? So it's blue here, but then the rest of the entire thing, once you log in, it's all that bright green, like crazy, right? How did I hear about this job? I saw it on LinkedIn because like, I guess LinkedIn knows I have a paralegal certificate and like they sent me a notification and I was like, okay. So then I'm going to show you this picture. This picture is going to be for a separate goal. This will be our next goal. You guys, some of you guys have heard my knife yielder story. There's another round of the knife yielder story. And that's why I took this picture because I've got a Swiss Army knife there. Twiz, no spoilers. Twiz knows the story, but no spoilers. But what's really funny, if you guys look, so there's my keychain, right? So I've got my Swiss Army knife and there's a squirrel keychain, cute. Looks like stained glass, right? Medieval style. So I've got a really good story about this, and it has to do with my trip to the court because I went to court with one of the attorneys. I should just use their names because there's only two of them. I went to court on Friday with Scott, and he was being heard in court. This is going to be a whole separate story, guys, because I have so much to tell you guys. Anyway, that's the sneak peek, and this is involved. Okay, so then I think that's so we'll come back to that picture. But yesterday, some of you guys heard me say I was preparing stuff for expungement, but I was waiting on some of the information from this client. But here's what I did. One of many things I did today. I literally filed expungements. Like I filed them, and I filed them with the new e-court system, like with the brand new system that the attorneys are like, don't know how to use. I filed them. I prepared them. I filed them, and I did just like we all see, right? I filed them electronically with the e-courts, and I prepared the paper copy to be sent in for certificate of service and all of that. That was one of the many things I did today. There's just so much amazing stuff, you guys. It's like, basically, even just since I started, these two attorneys are amazing, and they charge a lot, and they should. They're really, really, really well known. Their reputation precedes themselves. So it's like, what happens is, like, if somebody calls, right, and the people who call are facing serious, serious charges. So the people who call, they talk to me, and I talk to them, and I hear their story. And you guys know how I am. I remember people's names. I remember their voices, right? Sometimes I even remember their phone numbers if I see it and I recognize it. So they talk to me. I get their information. I get their story. And depending on whoever they called, Chris or Scott, and then I get everything that they need and I pass it along. And this is what's so crazy, right? Because already how rewarding this is. Like, so for example, let's just take today, for example, right? So somebody calls in, they have these serious charges, right? I get everything they need. I pass it along to, let's say, Scott, okay? And then sometimes it might be an hour later. Sometimes it could be several hours later. It depends on, like, if they're in court and whatnot. But, like, within a number of hours, they have talked to this prospective new client, right, who's facing these serious charges. They've talked to them on the phone, and they have, and the client has decided, yes, let's, like, you're my attorney. You are that person, right, who I will tell the things, I won't tell anyone else. And it's like the trust, right? And it's because these dudes are so freaking awesome. And so then what'll happen is, like, sometimes an hour later, sometimes a number of hours later, you know, for example, like, Scott will come back and he'll come in with, like, this sheet that has, like, the handwritten notes, and they both do their notes differently. It's really funny, different handwriting, all their handwritten notes, right, with, like, however much their fee's going to be and da-da-da. And literally what I've been doing is, like, when this happens, right, I set it up. I set the client up in the portal that we use. I have them in there, and I have their court date. I have their charges. I have their citations and whatnot. And I prepare the representation agreement, that's the first thing that has to happen, right? I prepare that, and then I prepare it for e-signature, and then I send that to them, and then I prepare the invoice, right? And they have to pay it right away, like the invoice, right? So that has whatever the fees are, and it's a lot of money, and that goes through after that. And so there's, like, those little steps, and then that goes through their email, and then I create a file on the computer for their digital file. And then what happens is then I get notified once they've paid their invoice, and then all of this stuff gets copied into their electronic file. And then once they've paid their invoice, then I create a paper file, like an actual file, right, with all their information and, like, the different attorneys. They have there's the two of them. They have their different ways they like to do it. I switched it up by changing the size of the font, and I thought Chris might lose his mind because he's very particular. And we were joking about it, like, what's Chris going to do? Like, I was like, let's just test it out and see. And it's like, oh no. And then sure enough, he loves it. So now we've got these better stickers on the folders. Anyway, so and then I print everything off, and I have, like, all their paper stuff, and that all goes in the file. And I do that a certain way. There's, like, all these little things that, you know, they each have the things that they like, and, you know, prepare the paper file. And so within, like, the same day, I've talked to a complete stranger who's, like, facing huge charges and needs help, right? And within a matter of hours, they've gone from someone who's, like, has nowhere to turn. And by the way, in North Carolina, they get their court dates really soon. So people will call and they'll be like, yeah, I got these charges yesterday. My court date is in 3 days. Guys, mind blowing, right? Like, they have, like, max a week to find an attorney. Can you imagine? And so they're, like, desperate, right? And they're scared and all this, and they don't, you know, and so within a number of hours, they go from that to having completed this entire thing to where now they've got their files. I got their court date on the calendar, right? And it's like, I can look at, and I'm looking at them. I'm like, I just talked this, here's their paper file. They've paid for you know, whatever the agreement is. I've got their court date on the calendar, you know, and it's like, it's so, and what's going to happen is, as we have these different clients and as we go along, I'll get to see it all the way through, right? Whenever there's motions filed, if there's a trial, right? Or if they show up for a plea, which is what happened on Friday, and I'll get to see it all the way through until their case is resolved, and it will be resolved and they will get the best possible outcome, I guarantee, for their clients. They will get, these guys get acquittals that no one else gets, and they get, plea deals that no one else gets. And they could probably be charging way more than they are. And they're just amazing humans, and they're so good at what they do. But it's like with every single person that calls, it's like people don't just like call and then they're like, oh, let me think about it. It's like they call, and then within a number of hours, like they're taken care of. And I'm going to get to see it all the way through. And like, for example, the expungement I took care of today, this dude was a client from years and years ago, because you have to wait a really long time for expungement. But it's like, if I was to be there for that long, right, I would even maybe see the time where they're trying to get it expunged later on. And it's like, I remember you. And Mary says her court date took 2.5 years. Right? Isn't that wild? Yeah. So it's like crazy, right? And it's like, when I went, well, for the Friday day is going to be a separate story, but I will say briefly that when I went with Scott, he had his attorney and the church, his client, who was Hispanic, and he brought a bunch of his friends with him, and they didn't speak very much English. They were all, and they were younger. So it was just a group of like maybe 6 or 8 of these dudes, like Spanish dudes. And like Scott comes over, and they're all just like, yeah, hey man, good to see you. And they're like, it's so cool, right? They just like totally love him. Like he's like just, it's not like, oh, that's your attorney. You know what I mean? He's like, and both of them are like that. They're so down to earth. It is really an amazing, they treat everyone as equals. Everyone. It is just the most incredible thing. I could go on and on, so I should probably stop myself and save more for another story. So, oh my God, the retrial, right? Oh yeah. And the other thing I researched the type of copier scanner that we have, and I watched some videos on it, and literally I taught them stuff they didn't know. I figured they knew, like, for example, if we're scanning like a file, it could be like hundreds of pages, and some of the pages are different sizes. Some are front and back, others are not. And like, for example, today, Scott was scanning a huge file, and he was like, okay, so after this, we're gonna have to pull it up on the computer, and then we're gonna have to go through page by page and delete all the blank pages, because whenever it scans the back and there's nothing on the back, you get a blank page, and we're gonna have to delete all the blank pages. And I was like, wait, you didn't know about this setting? So I showed him, I was like, here, you can go in here and you can set it, and it'll automatically not scan the blank pages. And then I was also like, did you also know you could put the file name in here and do this and that? And he was like, oh my gosh, you're teaching me things, and you just got here. I'm like, yeah, I watched videos on this. I was like, dude, it's so amazing though. Every day is like the best day ever. And every day is better than the last day. I mean, it's really funny too, because it's like, when I first started, I've only been doing this for like what, a week, 2 weeks, something. When I first started, it was like not clear, like how much of like what I would be, when I would be doing certain things. And like, I'm surprised that I'm already filing stuff. Like I'm already like, there's nothing really that I haven't like done that I would do, unless it's just certain things that haven't come up yet. But like, and they said that that this is like one of their busiest times. They're like, yeah, we're like slammed right now. So like when I happen to start, they're like, it's not always this busy, right? So they're like, anyway, but I freaking love it, man. It is so great. And so, yeah, I mean, it is great. So yeah, anyway, but we have the next goal. We will do the knife story, which is also the day I went to court story. And I've got loads more, guys. Yeah, anyway, we'll save it for another goal. Yeah, right. One thing that was funny today is like, people don't usually come to the office, right? Because it would be kind of weird. But like this group of 3 people showed up, and let me pull up real quick. This is a quick one, the lobby. So here, so Scott was preparing something in his office, and I was in my office doing things. And in walks, because usually it's only appointments that come in, right? In walks 3 people, and I was like, who are you guys? And they were like trying to sell something. It was like Amazon Business or something. But here's what's so weird. One of the people came and stood like literally right here, which is close to my office, to talk to me. the second person went and sat all the way over here. Can you guys see the hand? Went and sat all the way over here. And then the third person went and sat all the way over here by the printer. And then they just sat there, and the one dude did all the talking. And he was like, I was like, what is going on? Like, this is not, you have to go into this like office building onto like the third floor and like all the way down the hall. And it's like like, what is happening? And he was like trying to talk about Amazon business. And I ran into Scott's office, and we both I hid. And then he was like, no, wait, I want to hide. Anyway, it's like, and then eventually he called my phone in the office. So then I had to come out and be like, oh, sorry, I can't talk. I'm on the phone. And anyway, it was just really funny. It's great. So I'm glad you got a good attorney though, Mary. It's worth, and I was asking them, I was like, how do people just like have some charge that they're not expecting, right? And then the next day have tens of thousands of dollars at hand, like ready to go. Like, I don't even know. It's wild. Do you get which story? The knife story? Oh, you're talking about Mary's story? Yeah, we want to hear your story. And I was talking to Scott too about Idaho a little bit today as well. So Mary's story. Should we set a goal for Mary's story? No, Mary can go ahead and tell her story whenever she feels, if she wants to. No pressure. Okay, so now we will jump back to the trial. I think they were going to sidebar. So I haven't had a chance to talk to Chris as much because he's like literally been in court just back to back. But I've had more, I was able to talk to Scott about it today, and he didn't know anything about it except for just he'd heard of it. Right. And I figured as much because how would they're not going to follow cases. They follow their own cases, which are just as interesting, if not more interesting. And they've got a ton of them at once. You know what I mean? Like every single one of their cases, they're like, sometimes they'll be like, oh, this is a boring one. I'm like, what is wrong? Like, every one of their cases is interesting to me. So interesting. So anyway, they're not like, he heard of it, but he didn't know anything about it. And we only had a brief period of time to talk about it because it was while we were waiting for the scanner to scan a file, and I was working on the expungement. But basically I was just like telling him how well, here's what I was telling briefly, right? I was telling him how the prosecution's case is like, they have no case, and it's really insane. And I was, the first thing I went to describe, because I knew I wasn't going to have long to try to summarize it. I went to the timeline, right? I said, initially it was a 13-minute window to stab 4 people, to get in and out and stab 4 people, right? On different levels of the house, And then I told him, I said, recently the state has changed the timeline to being 2 to 4 minutes. And what Scott said was, well, he said, and this is very logical, right? If you assume that, if you're thinking, oh, well, the state's timeline, they must have the timeline correct, but maybe the wrong person, right? So that's what he's saying, reasonable. So he's like, oh, so interesting. So he said, so was it more than one person in order for them to get it done in that period of time? He's like, because someone must have done it, right? In that period of time. And I said, no. I said, it's like, he must have been so disappointed, right? I'm like, the state's timeline is a complete mess. And I'm like, but they are married to it. They've made their bed and they have to lie in it. And that is their timeline and they can't change it. And so they're married to that 2 to 4 minutes. And then at that point, it was like, that was all we had to talk about it because we were doing things. So they can't, they're not going to weigh in on, and the other thing is regardless of somebody did it or not, they're going to say what I would say, which is everybody deserves the most zealous advocacy as possible. And he's getting that. But yeah, I told him, I was like, the state should never have brought this case. It's insane. Yeah. I mean, we've talked about that time because you guys heard me lose my mind when that came in. So yeah, I didn't have time to get into more of the nitty gritty. I wish I could. I was about to try to get into the whole, the dude that tested it out running through the house. And I picture him in his socks and how it wasn't even videoed or had any photographs, and the thing that I freaked out about with this 2 to 4 minutes and then the whole thing about how they tested it is to me one of the craziest things I've ever heard. I was about to get into that and we didn't have a chance. but I'm sure we'll talk about it more whenever things are less crazy. But like I said, like it's really, really busy, which is awesome, you know? Like sometimes it's like a lot back to back. Sometimes there's a little couple minutes of downtime, but basically people are calling right now anyway, like pretty much constantly, like seeking legal representation. And then in the middle, I'm like doing a million things. Which as you guys can imagine, this is like my dream thing. Like I'm not going to sit around and be bored. Like I'll be doing like a bunch of things at once and on the phone, and I'll be like, put more stuff here. Give me more to do at once. Cause I have like multitasking. Right. And I'm like, yeah, it's awesome. But whenever there's more downtime, it'll be really cool to get to talk to them more about like their favorite cases and the cases that I'm covering or following, because they don't have time to look into that. But there's so many crazy things. The other thing I was thinking about is like if they heard the part about Donna Adelson and how it was recorded, her saying that they're going to flee to Vietnam, they would lose it. Like there's so many of these things, right? They would be like, you what? You know what I mean? One of the attorneys was telling me this crazy story about how they had a client who, and this never happens, right? It was a first-degree murder, and the defendant shot somebody with a shotgun, and the entire thing was on video. You know, that like never had, like that's direct evidence. You never have that. Like I'm not talking about before, after, like the shooting was on video, and you could see the person. Like there's no question, and that this defendant wanted to take it to trial with being on camera shooting the shotgun. And like they did not want to take a plea deal, and they said like last minute, and this person would have gotten LWOP, right? They said like last minute, right before trial, like day before trial or day of trial or whatever, and it was going to be like a month or 2 month long murder case, they said, and they were going to try it together. They said like right at the last hour, he was like, he took the deal, and they got him a really good deal. It's something like 27 years versus it would have been guaranteed LWOP with a jury. But like the fact that he wanted to take it to trial, right? And they said it was like a younger person too. Like I think they were 18 when it happened, when they did this. And yeah, they got like 27 years. And then of course it's like you take 10% of that off or whatever. So he'll serve like whatever, 23 years or something. Anywho. Hello, Needs and Z's. Welcome. We've just been doing, for anyone who's just now getting here, we've reinvented the goal. You guys know the goal, especially those of you guys who watch Runkle, which is like all of y'all probably. We've reinvented the goal to where we're making our own goals that don't have to do with money. So it's like right now we're doing sustained objections, and then we have a goal. So, and happy to see you as well, Kit Smits and Needs and Z's. Let's see, did I miss anybody else? Oh, and Mary told her story. Let me see what okay. Mary said she tried to mirror, I shouldn't put that on the screen. You guys can read it in the chat. I'll just not read that. She tried to do things, and you can't do these things, and these things are a felony. Mary says she knew she could take it on the plane, but the post office didn't tell. Yeah, the post office, they will get you. They'll get you. Yeah, was it across state lines? Your boss offered you bail money. That's awesome. County in Georgia, Mary? Was this in Georgia? Yeah, and for anyone who didn't know too, like these guys, they do state, but they also do federal, and they'll travel anywhere in the country as well for clients, for federal cases. And they you know, it's funny. Do you guys ever hear this from attorneys where they just like say that they love practicing in federal court? You know what I mean? Like they just love trying cases in federal court. These guys say that, like they love these federal cases. And I should ask them, I should ask them more about why they love them. But like the impression I get is less BS, right? Because it's like when the date is what it is, like that's going to happen then. It's not going to be continued or moved around. And I guess also like for them, I think they feel like when it's the feds, they brought a case that deserves to be tried. And that's one thing that like they'll talk a lot about. And we've all heard this from people, right? It's like nothing, it's like so depressing when it's like, if it's the state bringing a case and it's like, they shouldn't have brought this case. And that happens all the time. For example, the case we're watching right now, right? But with the feds, it's like, I think part of it is they feel like at least it's justice because at least if they're bringing charges, the charges are legit, right? And like they said, like they would rather there actually be evidence. Like that was what Scott was saying there. He was like, the worst thing is when there's a case and it's like there isn't any evidence because it's just depressing. It's like if you're going to be bringing a case, like I want you to have evidence against my client. I want you to have all the evidence against my client because that's how it should be, right? It's just awesome perspectives to get. I don't know what a Droogs. Oh my God, I'm an idiot. So did you say it was mailed across state lines or no? Because if it went across state lines, seems like that would be federal. But anywho, so I wonder what happens if you try to put it in like baked goods. Do you guys know? Oh, Cali to Georgia. Okay, wow. Like if people do like brownies or like gummies, you know. But also it's more complicated now because, you know, it's legal in so many states. But all right, so now we're going to jump back into this. Uh-oh, that's too bad.
Tissue bruising from.
Okay.
May I, Your Honor?
Yes.
In your report, Doctor, you indicated that Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. You recall putting that in your report?
Yes, I wrote that.
Do you stand by that?
Yes, that's my conclusion.
And you also wrote his arm had no tissue bruising from impact injury. Do you remember writing that?
Yes,
Do you stand by that?
I do.
You also wrote, neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. Do you remember writing that?
I did.
And do you stand by that?
I do.
You also wrote that you noted Mr. O'Keefe had no bruising on his arms or torso. Is that right?
Correct.
And you also wrote, in particular, Mr. O'Keefe did not have bruises on his legs, correct?
Yes, correct.
And you indicated that that was shown by dissection of the leg tissue and muscle at autopsy. Is that right?
Yes, there was a special leg dissection done to look for bumper impacts.
You reviewed the entirety of the medical records associated with the autopsy,
Yes.
including photographs,
Taken to the hospital, yes.
okay, and autopsy photographs,
Yes.
and other data and documentation, correct?
Yes.
Are x-rays an important part of an autopsy generally?
Oh, yes, usually there are x-rays taken of the body prior to the examination.
What do x-rays show? Why are those important?
They're important because they show foreign material in the body, like a bullet. They also image the skeleton, so we can look for fractures of the bones.
What does that sound? Oh, I didn't realize this was here. That's what that sound. Okay. So as some of you guys heard, the little snippets that I saw of this before now, this is one of the places that I randomly saw. And I couldn't freaking believe this. Did you guys see this? I died. Literally, I died. Here's what I will say. I actually saw, I had it mounted in my car and I was stopped in traffic on the way home. Literally, I saw this and I'm sure I was like, what does that sound? Just like I said now, but I saw the big white sheet of thingies and I knew immediately, I was like, no way. No, that can only be one thing. No way. Mary, what is happening? Okay, let me just recap. So we talked about when was it with Judge Welcher on the stand? We talked about the fact that there were no x-rays in this case. And I know a lot of you guys thought, well, you know, why would there be, and it's normal, right? Why would there be x-rays? And I was saying how, like, I remember specifically referencing, like, for example, the Ezra McCandless trial, because, like, it was just one example of where, like, the normal protocol, right, is you take x-rays of everything and you measure everything. Like, that's standard procedure, even if you don't see any injury. Like, that's standard for an autopsy, right? That's standard. And so far, in trial number 1, I don't think the x-rays really came up, but so far in this trial, the only time that x-rays came up was with Judd Welcher on the stand. And he was asked about, did he look at any x-rays? And he said emphatically more than once that there were not any x-rays. This is one of the times we talked about it. He's like, yeah, there were no x-rays taken. And it was like, well, I guess whatever, like everything was fucked up in this case. So is that really that surprising? Although it's like Dr. Squirty Bello knows what she's doing. Like, why aren't there any x-rays? But like, I guess there's not any x-rays, right? I actually went back right before I went live. I went back and I watched Dr. Squirty Bello's testimony on like a bazillion times speed from this trial. And nobody asks her about x-rays. Because I thought to myself, surely somebody, you know how they usually ask, like, what did you do for your autopsy, right? And it's like they talk about the toxicology and they talk about all the other things. And I heard all, like, she talks about all that stuff. But nobody, the word x-ray does not come up with her. As far as I can remember this trial, it doesn't come up until Judd Welcher in terms of the trial testimony. And Judd Welcher is like, yeah, there were no x-rays. And I'm trying to remember, do you guys remember with Dr. Russell? Did it come up? I feel like if it did, she might have said, I didn't see any x-rays. Now, the difference being that it's the Commonwealth's job to provide the evidence, right? So Judd Welcher being the Commonwealth's expert saying that there were not any x-rays is a completely different thing than a defense expert not being provided with something, because they don't have to be provided with everything, right? Okay, he said he reviewed x-rays. Okay, I remembered him saying there weren't any x-rays, period. But thank you for that, Need Some Z's. He reviewed x-rays, but none of them were the arm and the hand. Okay, thank you. And welcome, Heather. Happy to see. So we loved Mary's story. It was great. Yeah, no x-rays is what I recalled. But yeah, I mean, it's so funny how, like, it was so surprising when I went back to Dr. Squirty Bello. I'm like, nobody asked her about that. Like, it's wild to me. And it's like, were both sides, was this like the elephant in the room that both sides were avoiding? Like, I don't know. But then I thought about it more as I was finishing my drive home. And let's watch this, and then I'll tell you guys what I think the defense's strategy was here. This is insane. This is something that we will never, as basic as, like, pick your most basic thing of evidence in anything. This blows my mind still.
May I approach?
Absolutely fucking, I still can't believe this. I still can't believe this.
Yes.
That makes sense. Oh, now they're approaching. Karen said while leaving court that the x-rays were in the autopsy file, but the Commonwealth never brought them out in either trial. Yep. And again, it's wild, right? This is not normal. It's not normal. You know, again, there's some overlap here with Casey Anthony, because in the Casey Anthony trial, there's this, one of the similarities is, like, a lot of the evidence came out through the defense, just like here, where it's like the state, like, basic stuff, right? The state, or in this case, the Commonwealth doesn't provide it. And it's like, this thing is missing. This thing should be here. And it's like the defense admits it. It's like, what does that say about the case, right? Y'all.
Dr. Laposata, you can step out. Okay. All right. I did receive another motion this morning for a curative instruction. I'm not going to even consider this today. We can consider this.
Okay. So this is what we read this at the beginning of the live stream. This blows my mind. Guys.
This morning for a curative instruction. I'm not going to even consider this today. We can consider this at the charge conference. So that's where we're at with that. All right. Work it out.
Can someone just, like, set her on fire? Like, I mean, I'm just going to say something terrible. What? I'm not going to even consider this? In the motion that we read, it's not long either. The when she's, like, acting all whatever, it's only 3 pages, although the third page is short. And part of it quotes verbatim the instruction she was initially going to read before she acted all toddlery and got all offended because they weren't listening to her, and then, like, did the whole 180. And it's like, there's your own words, Bev, literally. Like, this is the problem here is this should have been fixed yesterday, but the timeliness matters. And the fact that she's like, I'm not even going to consider it. We'll deal with this at the charging conference. You mean after they've finished, both sides have rested, when the jury has probably if not definitely made up their mind. Like they've heard closing arguments, like, or they're about to hear, like what? This is, and of all of the things, this should be a quick one, right? This is not hard. This is not hard. She could have given 2 minutes to this. They made it easy for her. They gave her the instruction that she said she was going to read, the instruction that she did read, and the instruction that they would like her to read going forward. They made it easy for her. This is disgusting. To me, if she's convicted, add it to the list. This is a huge appellate issue. Another one. Another one. You guys.
If you can't work it out, let me know. I'll come up before the jury.
All rise for the court, please.
It's crazy. Yeah, right. I mean, and that I'm with you, Kitsmits. Initially, when she said, I'm not going to consider this today, initially I was pissed at that. And I was like, oh my God, that's wild. Well, they better get this done tomorrow morning. And then she's like, we're going to deal with this at charging conference. I'm like, get her out of here. Get her out of here. This is crazy. Like, why? Why are you going to wait? Like, and why wait that long? Like, what? On what basis? Like, why are you specifically saying we'll do it then? I just can't, dude, you guys. I mean, it's like literally waiting as long as possible. Like you can't wait until they're already deliberating, right? Like that's literally as long as you could possibly wait before they start like deliberating, which means it's the most remote in time as possible. So, you know, Heather, I've thought about this. And if there's a third trial, I think I'm not alone when I say that I don't know that I'll be able to do it. And I say that, of course I will, but I can't fathom that, to be honest with you guys. So we will all lose our minds. What is going on?
On the
Okay.
court's bench, there's an item I'd like to retrieve back.
Miss, we need that marked for
We're back with the expert.
identification.
I need all three of them marked.
Okay, and we'll do that afterwards. Just please go ahead.
You see any x-rays?
Oh, that was another
did.
one. Yeah.
What were the x-rays of?
The x-rays were taken of Mr. O'Keefe at the medical examiner's office, and they were x-rays of his chest, his arms, and his legs.
Did you specifically
Arms, people. Let's hear that again. And Needson Z says, in my opinion, all Bev cares about is conviction. She's been told to do anything she can to limit it. I appreciate you every time Needson Z for saying in your opinion, but I think that at this point, there's really no way to say that that's not the case. So I appreciate that disclaimer, but I don't know. At some point, opinion becomes like, you know, not opinion, but more like established fact, I would say.
see any x-rays?
I did.
What were the x-rays of?
The
I
x-rays
did
were
that.
taken of Mr. O'Keefe at the medical examiner's office, and they were x-rays of his chest, his arms, and his legs.
I thought about this as well. I thought, how would you guys, let me ask you guys this. How would y'all feel if you were on the jury right now? How would you feel? How would you feel?
Did you specifically review x-rays of his right appendage, hand, forearm, arm?
Yes, they were included in the x-rays.
Have you seen x-rays before?
Oh, many times.
How many times?
Thousands, probably.
Is part of your job to review x-rays
Oh,
to make a
absolutely.
determination of whether or not they indicate broken bones, fractures, hairline fractures, things of that nature?
Yes, it's part of the medical legal autopsy to study the x-rays of the deceased.
That's done in the ordinary course of being a forensic pathologist, is that right?
Yes,
Are you trained on how to read x-rays?
yes,
You have to be a radiologist to do an x-ray as a medical doctor?
no.
Medical doctors do that all the time, correct?
Yes, it's part of general medical training.
And is it also part of specialized training for forensic pathologists?
It falls under the rubric of general radiology that a doctor knows. There are some specialized areas in forensic where you have to understand like decompositional changes that you can see on an x-ray that aren't something that you would see in a clinical setting.
And to be more specific, what I was referencing when I said, how would you feel if you were the jury? What I meant was when he asks the question and she says x-rays of the arm. How would you, that's the part that, like, for me, that's specifically what I'm wondering.
Taking the appendage one item at a time, did you look at Mr. O'Keefe's x-rays of Mr. O'Keefe's right hand?
Yes.
Did you see any defect in the bones of the right hand?
No bony defects and the tissue was normal.
Did you take a look at the x-ray of Mr. O'Keefe's right arm?
Yes.
Did you notice any defects at all in the bones in the right arm?
No, the bones in the right arm were intact.
No breaks,
Correct, no breaks.
fractures, hairline fractures?
Nope.
Did you look at the upper arm x-ray of Mr. O'Keefe?
Yes.
Do you have any defects in the bone structure of Mr. O'Keefe's upper arm?
No, the bones were 100% intact.
No breaks, fractures, hairline fractures?
Correct, none of those.
Was there any indication in your mind, based on your review of those 3 x-rays, the hand, forearm, the arm, that that arm had suffered any kind of bone trauma at all?
Sustained.
Was there any indication, based on your review, your expert opinion, that his arm had been broken, fractured?
No, the bones were intact. No breakage, no fractures.
Thank you.
Thank you.
So Kat says, I thought I heard there were no x-rays by the Commonwealth doctor. Maybe in the first trial, but you may have missed it. I went back and watched, after this happened today, I went back and watched, again, I watched it on really fast speed, but there were the CCs on, which helped. I watched Dr. Squirty Bello's testimony from this trial, and nobody asks her about x-rays. Not even when they talk about, like, what testing did you do? She doesn't even mention it, which is really funny, because when they ask, like, an open-ended question, like, what testing do you do or what did you do in this case as the medical, the medical examiner? It's weird that she didn't say x-rays, right? It's like, did someone tell her not to? Because, like, that would be, if you're just answering that question, that would be one of the standard things. Like, how would you, like, it's, in other words, for her to even avoid saying it is crazy to me, because it's like one of the most basic things you could be doing. But not only does she not say it, at least in this trial, neither side asks her about it. So as far as the defense strategy, again, I was thinking about this as I was driving home today. I'm wondering if the defense did this on purpose, because they could have, they could have brought this up. Okay, when Dr. Squirty Bello was on the stand, they could have asked her about the x-rays. They could have gotten these x-rays in. They could have also done it when Judge Welcher was on the stand. And he said there were no x-rays of the arm. I recall him saying there were no x-rays, period. But I know some of you guys said you recall him saying there were no x-rays of the arm. Either way, they could have done it then. But here's the thing. It is not the defense's fault that we're just now finding out about the x-rays, obviously, right? It's the Commonwealth's fault. But the reason I think the defense waited until now to bring this in is because how much more impactful is it now that the jury knows they're at the end of the trial? And bringing it in with their last 2 witnesses, ostensibly, right? Because my thought is they're going to end with Dr. RENTSCHLER. Bringing it in, and literally because they couldn't wait any longer, right? Because basically, by bringing it in now with Dr. Laposata, this not only is going to be helping her with her testimony, but this is all, like, I would imagine, laying the foundation for Dr. RENTSCHLER. And by waiting this long, I think it's so much more impactful, and just makes you, at least for me, it makes me feel just all the more infuriated at the Commonwealth that these exist. Had these come in with Dr. Squirty Bello, it would have been like, I don't even know, I would have been like, oh yeah, well, of course there's x-rays. Had it come in with Dr. Welcher when he was like, yeah, there's no x-rays on the arm, and then it's like, well, what about these x-rays? It would have been like, oh my God, he doesn't know what he's talking about. And like, but the fact, like, at this moment, for me, it's so much more impactful. And so because the defense didn't have to bring them in at all, right? I think they did this now instead of earlier. I think that they did that on purpose, and I think it was very perfectly timed. So let me know what you guys think, though.
Good afternoon, Dr. Laposata.
6 minutes till the afternoon.
And the thing is, right, Neeson makes a good point, right? That if Welcher, if they remembered about that, right? Oh, I would be shocked if they didn't remember that, because that's like such a huge thing, right? The injuries to the arm is like 60% or maybe more of this case is talking about that arm, right? And I would expect that they remember that. Plus, they're taking notes. But also, we know he's coming back for rebuttal. I wonder if the Commonwealth will chicken out of calling him, because can you guys imagine what that's going to look like? Oh boy.
Okay, good afternoon.
That's okay. You wrote a report in this case, doctor?
Yes, I did.
Do you think that based on your analysis, was Mr. O'Keefe thrust backwards? Is that what you determined looking at his head injury?
That he was, I didn't understand, you had your hand in front of your mouth.
Sure, I'm sorry.
Yeah.
You talked about a head injury that Mr. O'Keefe had, that he
Yes.
suffered from?
Yes.
That caused his death?
Yes.
Was that?
Yeah, sorry, I just want, exactly, you guys are right. The jury has to wonder where were the x-rays earlier. Yep. And that's why I think waiting was really brilliant. Really, really brilliant. Yeah. And remember, Dr. Squirty Bello was testified for the Commonwealth, which was a surprise. So if anybody told her not to mention it, it would have been the Commonwealth. Had she been called by the defense, then it would have been the defense, you know, again, if she intentionally didn't mention it. But in this case, because she was called by the Commonwealth, it would have been the Commonwealth, which tracks because they didn't bring it in last trial.
Injury?
That he was, I didn't understand you had your hand in front of your
Sure,
mouth.
I'm sorry.
Yeah.
You talked about a head injury that Mr. O'Keefe had, that he
Yes.
suffered from?
Yes.
That caused his death?
Yes.
Was that caused by being thrust backwards?
Yeah, she just owned him. I need to back this up. Yeah, it's been 3 years and we just now know that there's x-rays. Yeah. Like, I will just say when I those x-rays, first I was shocked and disbelief, but then I was furious. And I just thought exactly that. How the hell? How? And that's, I'm wondering if the jury, I wonder if people in the gallery, like, did they have faces? I don't know. We'll see. All right.
Good afternoon, Dr. Laposata.
6 minutes till the afternoon.
Okay.
Good afternoon.
That's okay. You wrote a report in this case, doctor?
Yes, I did.
Do you think that based on your analysis, was Mr. O'Keefe thrust backwards? Is that what you determined looking at his head injury?
Yeah.
That he was, I didn't understand you had your hand in front of your
Sure,
mouth.
I'm sorry.
Yeah.
You talked about a head injury that Mr. O'Keefe had that he
Yes.
suffered from?
Yes.
That caused his death?
Yes.
Was that caused by being thrust backwards?
Yeah, the motion was upwards, down.
Okay. And the way you just showed, it could be a fall?
Correct.
Did you have an opinion looking at his wound that he was thrust backwards?
What do you mean thrust?
Well-
His body went backwards. There may have been some applied force to it.
I don't know about thrust. I'm asking if you have an opinion. Your words. Do you have an opinion about thrust?
What do you mean thrust?
Did the forensic pathology diagnosis mean Mr. O'Keefe's body was thrust backward?
If you want to say thrust as indicating movement, that it went backwards, then you could say it was thrust.
May I approach?
Yes.
Yeah, so as far as Breenan with his paper shuffling, my take on the Breenan paper shuffling. So because there's been times where I've actually counted it, like at certain hearings and stuff. I think what I call it is Breenan angrily stacks his papers. My take on the Breenan paper shuffling is probably at some point early on in his career, he started doing this loud paper shuffling or loud paper stacking, potentially as like a way to intimidate witnesses. Because I've seen other attorneys do it, not as compulsively as he does, but they can have a thing like that where it makes it seem like I don't know. I don't even know what it's supposed to convey, but it can convey something. I would think he maybe started doing it as like an intentional thing for when he's especially frustrated or whatever, but it's supposed to make it seem like you're actually the one in charge. And I think what happened is because he's probably, he's just like frustrated and grumpy and whatever all the time, awful, right? Like, in other words, I think now it's just happens all the time and it's not, and it's a subconscious thing, but it's because how would you call it? His mood. What is how would you name his mood, guys? Because whatever it is, it's like he's stuck on that, I feel like. I mean, he doesn't ever smile or laugh or, I don't know. To say he's wound tight would be an understatement, I think.
I'm showing you page 2 of your report, Dr. Laposata.
Yes.
I'm just going to ask you to read it, not out loud.
I wanna
and
know
can
what
ask
you
you
said.
a question. But I want to.
Yes. Yes.
Are you familiar with that?
No, absolutely.
What did she say? I don't have Twitter. What did she say? Yeah, you could be right, Pat
So,
Randall.
Dr.
Now-
Laposata, what did you mean
Yeah.
when you described that Mr. O'Keefe's body was thrust backward from a standing position?
I mean that he was standing upright and his body had momentum and went down and hit at the back of his head. So it was thrust backwards.
You cannot tell forensically how much momentum he had, can you?
No, we don't do those analysis.
If you can't tell if anything caused that momentum based on the head injury, can you?
What do you mean caused it? It was caused by his body went backwards.
Yes. And so the amount of force causing him to go backwards, that's not something you can determine from the head wound, is it?
No, I can't tell you the amount of force. It was significant because he had the massive skull fractures.
Did you say it would be significant?
Yes, significant force.
In modern medicine, there are a number of different machines that can help us see the brain, like a CAT scan, perhaps,
Sure.
MRIs.
Yes.
Would you agree with modern medicine that the use of MRIs and CAT scans and other tools give a clinician equal, if not better, opportunity to examine the brain as actually cutting it and holding it in your hand?
No, the actual gold standard is the pathology, to be able to have the brain in your hand, look at it with your naked eye. And we have conferences in the hospital where we meet with radiologists and say what we find at autopsy and see if their radiology was correct.
Can CAT scans and MRIs show contusions on the brain?
Well, they might.
Subdermal hemorrhages?
Subdural hemorrhages. Yes, they can.
Herniations?
They can.
Do you have any doubt about the modern medicine and the use of MRIs and CAT scans? Do you think they're inadequate in any way?
Well, I'm not a clinician, so I don't use those to diagnose diseases in living patients.
Dr. Laposata, have you ever had any experience studying the brain in real time, clinically, going and opening somebody's skull and treating the injury before the person dies?
No, I'm not a neurosurgeon.
You don't have any neurological expertise, do you?
I'm not a neurologist. I'm not a
Just said she's not a neurosurgeon, Breenan.
neurosurgeon. I'm a forensic pathologist.
Do you have any clinical experience at all where there's an acute head injury and you're making an effort to observe it and analyze the injury as it progresses in an attempt to save the person's life?
I don't treat or diagnose living patients.
I understand, but as far as your background, have you ever had any experience, clinical experience, showing the progress of an actual brain injury and trying to treat it?
I understand the physiology of what happens to the brain when it is impacted by something, whether it be a bullet, a boulder, a fall. So I know what happens to the body to cause the changes from that trauma. I don't.
What he's going to try to do is suggest that the neurosurgeon's opinion, whatever, is more reliable than hers. Clearly, that's where he's going with this. But he may as well be saying, like, you're not a fireman, are you? You've never driven a fire truck. Or how many times have you gone in a rocket ship? It's like, I'm not an astronaut. I'm a forensic pathologist. It's like, that's how I feel about this.
Treat people for those injuries.
In observing a brain that's in trauma and making determinations of how long it's viable or whether the person will expire, do you know the process that a neurosurgeon would go through in order to fight to preserve the person or save the person? Do you know the step-by-step process that they would undertake?
To do what?
To try to operate or save somebody from a head injury, from a brain injury.
I'm going to allow it because of prior testimony.
Well, it depends on what the brain injury is. If you have head injury and you have bleeding on the brain that's pushing the brain one way or the other, it would be a subdural, then a neurosurgeon would come in and try to take that blood away so it doesn't compress the brain. So that's something that neurosurgeons do to treat head trauma. They can also put in drains into the ventricle of the brain, and that can relieve pressure in the brain because that brain swelling is a bad thing. So those are some of the things neurosurgeons do to treat brain injuries.
And can they remove part of the skull to relieve pressure?
Oh, yes, they can do that. It's called a craniotomy. They can take out part of the skull if they need to.
So there are a number of different steps that a neurosurgeon can take when someone suffers acute brain trauma to try to save the person, isn't there?
Well, the job of any...
So maybe what he's actually getting, I thought, well, maybe it's 2-4. I was going to say what he's trying to get at is maybe make it seem like his expert's opinion is better. But I think also, in addition, clearly he's now trying to get to this whole thing of like, he could have lived. John O'Keefe could have lived. Which really, I think that's probably more of like a sympathy ploy for the jury to play on their emotions, because I don't think that anybody has really offered the opinion, including the neurosurgeon. Nobody's said that John O'Keefe could have been saved. Like that, no one has said that. But Breenan's trying to suggest that now, I think.
Doctors to try to save a human life if you treat living patients. So certainly a neurosurgeon would evaluate the patient and decide if there's any treatment needed that could improve the patient.
When you've had cases in the past as a medical examiner where there have been issues regarding brain injury, wouldn't you agree that you have sought outside consultation with people who have a higher degree of specialty in brain injury than you?
Sometimes what we do is when we're examining the brain, we can call in for a conference and have a neuropathologist come in and review the brain with us.
And back when you were a medical examiner, you did that on a number of occasions, didn't
Yes, that's routine.
you? The reason why is because there are different specialties in medicine, and some are different and separate than your specialty, correct?
Of course.
Obviously.
And a neurosurgeon or a brain surgeon, it would be a different specialty than yours.
Yes.
And they're focused on the brain, yes?
A neurosurgeon does brain surgery.
And so, how many times in your career do you think that you've assisted the help of neurosurgeons to take a look at brain study to help you?
I've never needed to speak with a neurosurgeon to look at a brain. Sometimes we call in neuropathologists and we have a forensic
This part, I did hear this part. She's like, I've never had to consult a neurosurgeon to look at the brain, but instead, sometimes I talk to them because they come in, essentially my interpretation, they come in seeking my help. Is that how you guys heard this? Let me back it up so we can hear it in its entirety, because this is great. Yeah.
And so, how many times in your career do you think that you've assisted the help of neurosurgeons to take a look at brain study to help you?
I've never needed to speak with a neurosurgeon to look at a brain. Sometimes we call in neuropathologists and we have a forensic neuropathology conference where we look at brains with the interns and residents.
How often?
We look at the brains with the interns and residents. Yep.
would you call a neuropathologist?
Maybe once a month, we would have a routine conference.
And again, the neuropathologist
And she's saying routine conference with the interns and whatnot.
that's dealing with a person's brain after they already died.
Correct.
So it's not a clinical setting or a clinical experience of actually watching the brain at work and seeing the injury as it progresses.
We don't do neuropathology like that on living people. The person is deceased.
You had
She's like, are you dumb? What is wrong with you?
an opinion to the jury today, and you said that you believe that Mr. O'Keefe died within 15 minutes.
Yes, I think that process would start within 15 or 20 minutes.
Is that to a reasonable degree of medical certainty, that opinion?
Yes, based on the severity of the injury and the brain swelling.
You're aware that there are numerous level 1 trauma centers around the country that deal with brain injury, right?
Sure.
And the idea is that people suffer all types of brain injury, and if they are given medical attention in a reasonable amount of time, there's a chance they can be saved, yes?
Well, it's possible, but many are so severe that they cause death no matter how fast they can get medical attention.
In fact, every day when people get the right attention or proper attention, they're brought to level 1 trauma centers around this country to try to help them or save them. Isn't that fair to say?
I would hope so.
Do you think?
Sure.
When
I was thinking the
you
same
looked
thing.
at Mr. O'Keefe's brain, obviously it's after he already expired, correct?
Obviously,
And
yes.
so you didn't have any clinical observation of the progress of his injury that night, did you?
I was not observing him. I did not observe how he got his injury.
When you gave an estimate or you give an opinion about how long he was alive for, are you aware that there's certain tests that are done by neurosurgeons when people are suffering brain injuries but there's an attempt to save them?
Sure.
Have you ever heard of a Guzma coma score?
You know, I think that Breenan was conflating neuropathologist and neurosurgeon. What do you guys think? Do you think he was actually trying to say it as an, I think he was conflating them or getting them confused because he does that. Now, here's a good one. This is a good one.
Brain injuries but there's an attempt to save them?
Sure.
Have you ever heard of a Guzma coma score?
Guzma coma score. Listen,
Glasgow, you mean?
You know, it is Glasgow, but you've heard of Guzma?
he says it again. Now, we've heard him mispronounce all kinds of things, right? But the fact that he says it again, listen. So at first, when I heard this, I thought, I was driving, right? And I thought he was just getting it wrong, right? Again, classic Breenan. But then he says it again. Now, let me tell you something.
Or you give an opinion about how long he was alive for. Are you aware that there's certain tests that are done by neurosurgeons when people are suffering brain injuries but there's an attempt to save them?
Sure.
Have you ever heard of a Guzma coma score?
So at that point, I'm like, okay, stupid Breenan.
Glasgow, you mean?
You know, it is Glasgow, but you've heard of Guzma?
Then he says it again. And so I was like, is this a real thing? Note to self. When I get home, I'm going to look it up. So I did. I got home. I looked it up. I spelled it a number of different ways. I could not find anything online, nor could AI suggest anything even remotely close to Guzma coma. All that would come up was the Glasgow coma score. So he made up this word, and he made it real enough in his mind that he repeats it like it's a real thing. I mean, it makes you wonder if he's okay mentally.
It's called Glasgow coma score.
Have you ever seen the assessment that a level 1 trauma center goes through when they're trying to save somebody with a brain injury?
I'm generally familiar with the emergency procedures to save somebody's life.
Have you ever read any statistical studies attempting to correlate the brain injury with the time somebody would live for?
I'm aware of that, and I see that in my practice of people who have survived brain injuries and die of something else. Then I can look at the brain and understand how the brain can heal or react to injuries.
And many people who suffer coup will go into a brain surgeon center, and many of them pass after time, don't they?
Now, every case is different.
Right. Some might live for an hour, hours, weeks, months, or survive the injury.
It
Isn't that fair to say?
it depends on the case.
In this case, you don't have any objective criteria to identify the amount of time Mr. O'Keefe would have lived if he had the appropriate help. Isn't that fair to say?
I don't think it would have been effective because there were massive skull fractures to the base of the skull, and there are cases where the amount of force and energy applied to the head, causing skull fractures, breaking the neurons, causing the brain swelling, despite rapid medical treatment, those people cannot be saved. They can't effectively stop the brain swelling.
Many people can't be saved. Did you know that about 1/3 of them do get saved?
I don't know what you're talking about. 1/3 of every.
I love this so much. By the way, you guys, when Dr. Wolf, as in the neurosurgeon, testified, let me know what you guys remember. I absolutely unequivocally don't remember him saying John O'Keefe could have been saved. I don't think he ever said that. I remember something about a statistic with 1/3, but of course, I'm sure it was not the way that I'm sure that Breenan is not representing that in the way. Like, I remember that coming up, but I remember thinking to myself, oh, that's one of those things that doesn't really mean what, like, that Breenan is trying to make it seem like it means something it doesn't actually mean. And it was like a leading question. And it wasn't like, it was one of those things where like, if you actually are paying attention, it's like, yeah, that means nothing. It's not relevant. It's not actually that, whatever. But like, I was like, that's going to come back up. And sure enough, right? But again, the thing is, right, he's still trying to suggest that somebody thought that John O'Keefe could have been saved.
Head, causing skull fractures, breaking the neurons, causing the brain swelling. Despite rapid medical treatment, those people cannot be saved. They can't effectively stop the brain swelling.
Many people can't be saved. Did you know that about 1/3 of them do get saved?
I don't know what you're talking about. 1/3. Everybody has different sorts of injuries. 1/3.
I don't know what.
With a clivus fracture.
Oh my God. I don't know what you're talking about. And then she's like, 1/3 of what? I mean, great question. This is the thing. So this is the thing. He does this. He's been doing this with every witness, right? And it's like, I love that she's like, you didn't even specify what you're talking about here. And she's just so matter of fact.
Despite rapid medical treatment, those people cannot be saved. They can't effectively stop the brain swelling.
Many people can't be saved. Did you know that about 1/3 of them do get saved?
1/3 of them, as in what? Who?
I don't know what you're talking about. 1/3. Everybody has different sorts of injuries. 1/3 of what?
With a clivus fracture. Coup contre coup. Are you aware that 1/3 of those patients survive if they get the proper treatment?
It depends.
And again, I don't even think I think he's misstating whatever that statistic was. I'm sure he's misstating it. What am I even talking about?
On the amount of force.
Okay. Are you aware that a study would show, have you ever read a study by Isaac Wolf on clivus fractures?
Oh my God.
No.
Have you read any studies
I love how she's just like, I'm not impressed.
on clivus fractures?
Clivus fractures? Yes, I understand what clivus fractures are. It's a part of the base of the skull.
Okay.
And it
have
depends.
you,
Oops. Okay, go ahead.
please. Did you want to
No,
say?
you go ahead.
Oh, I'm sorry. Have you read any studies that tell you with the proper treatment, despite these potentially catastrophic injuries, that 1/3 of patients can survive?
No, but that's not the case we have here.
And so in this case, I asked if you had any objective criteria. You don't have any objective criteria about the progress of Mr. O'Keefe's wound that can be a basis for you to conclude that he would have died in 15 minutes. Isn't that fair to say?
No, I understand what happens to the brain when it gets that sort of injury. I understand the time course and the physiology. I've seen hundreds of individuals who've had brain injuries. Some survive for a longer period, some die earlier, and it depends on the amount of force and the amount of brain swelling. And in Mr. O'Keefe's case, we had the massive skull fractures at the base of the brain and immediate swelling and subarachnoid and subdural. So he had a large force applied to his head, which caused the brain swelling and the herniate and the progression of the brainstem down through the foramen magnum that stopped the brain. It was a very forceful impact.
You examined his brain.
If I were Breenan, I would cut out with this bullshit, right? And I would switch over to this part because she's saying it was a very forceful impact. And you know what? That doesn't sound like an accident, right? Which is what his neurosurgeon said. And maybe that's why he's not going to switch over to it, because it would contradict what his expert said. However, we have heard him undermine literally every opinion that was offered by the Commonwealth's experts in the course of the defense's case in chief. He's literally contradicted all of it anyway. So, you know, and if nothing else, right, at least just to try to suggest that there was some force applied, like from a collision, like this is maybe his best avenue that I can see with this.
Brain after you look at photographs. You can't tell us objectively when his brain swell started.
It started immediately after impact.
And you can tell us what the progress of that brain swell was by looking at his post-mortem photos.
By looking at the post-mortem photos and the post-mortem examination, I can tell the degree of force from the extensive skull fractures that were present.
What was the degree of force?
It was medium to large.
Well, that's a wide range. What do you mean? Quantify medium
I'll
to
strike
large,
the comment.
please.
Ask the question, Mr. Brennan.
What is medium to large?
No, wait.
Photos and the post-mortem examination, I can tell the degree of force from the extensive skull fractures that were present.
What was the degree of force?
It was medium to large.
Well, that's a wide range. What do you mean? Quantify medium
I'll
to
strike
large,
the
please.
comment.
Okay, so we get to
Ask the question, Mr. Brennan.
What does medium to large mean?
Enough to cause a lot of fractures to the skull. He didn't just like sit down and lie down.
If he sat down,
So instead, he's hyper fixated on the fact that it's like medium to large. How much force is that? Instead of like, dude, what are you focusing on that for? Focus on the fact that she said it was a lot of force. What is wrong with you?
lie down, he probably wouldn't have fractured his skull, correct?
That's obvious, yes.
Right. And so when you're telling us you can identify that he immediately died or died within 15 minutes, I'm asking you for objective criteria. For you to give that opinion, I'm asking you what objective information you have. And so you said that there was a large amount of force, correct?
Sure, but because there were massive skull fractures, and there's a lot of energy transmitted to the brain, starts swelling immediately
How do you know this wasn't medium force and not large force?
because of the extensive number of skull fractures,
So are you saying it was medium or large force?
medium to large.
Okay. How much force is that? Can you quantify it?
No.
What other objective criteria do you have?
So I think what she's actually wanting to say here is that the large amount of force was actually the force, and we've heard about this, the Contra-Coup thing, that the force is from the brain swelling. In other words, the brain, the head did it to itself, was the large amount of force. That might be what she's saying. I'm sure we'll hear more about it.
Support your opinion that Mr. O'Keefe died within 15 minutes.
My training and experience of seeing thousands of deceased people from head injuries and knowing some of their clinical course when they get immediate medical treatment, they don't survive.
But you would agree many do.
Depends on the case.
And in this case, you didn't have any opportunity to observe the progress of Mr. O'Keefe's injury that night, correct?
I'm going to allow that.
I wasn't there.
You
The body told me what happened to it.
You have no assessment of the development of his brain injury and how much time it took that night, do you?
I do, from understanding the significant skull fractures and the swelling of the brain and the compression of the brainstem that all happened very rapidly because of the amount of force that caused all those skull fractures on the base of the skull that actually then hemorrhaged into his upper eyelids. That's a large amount of force.
Was gross edema found on his brain?
I think it was swollen, yes.
But was that a finding?
Yes.
Where did you see that finding?
Well, in order to have the herniation of the brainstem, the brain swells.
Where did you see that finding?
I can't answer that. I just know it from understanding, looking at the pathology.
So at the end result, at some point, Mr. O'Keefe had gross edema.
In order to get the brain stem hemorrhages, the only way you get that is because the brain has swelled. And there's no, after injury, tissue swells, and there's no place for the brain to go when it swells, except down into the natural hole in the bottom of the skull where the spinal cord goes down. So that's where the pressure goes. So that seeing the brainstem herniation tells you that the brain has swollen a lot.
Undoubtedly, but it doesn't tell you when it began to swell or the progress of
Inevitably.
that swell, does it?
I don't know what you mean.
You see inevitably because of the swelling, there's a
Oh my
suffocation.
God, literally. And then he says inevitably. That is hilarious. Because he said undoubtedly. And I'm like, wait, he means inevitably. But then he went and fixed it. But also she's like, what are you talking about? Oh my God.
Where the spinal cord goes down. So that's where the pressure goes. So that seeing the brainstem herniation tells you that the brain has swollen a lot.
Undoubtedly, but it doesn't tell you when it began to swell or the progress of that swell, does it?
I don't know what you mean.
You see inevitably because of the swelling, there's a suffocation, but when you see that, you don't know when the swelling began or how quickly it progressed. You can't tell that from an autopsy.
Yes, you can, because of the severity of the skull fractures. I know there was a lot of force, and that force applied causes you to go unconscious, then your brain swells. If there was just like one skull fracture, then that's a little bit different. But this was massive skull fractures on the base of the skull. So there's a lot of force applied. So I know because there's a lot of force applied to cause the skull fractures.
Again, so now it's really clear, right? The force applied that she's talking about is because of the fractures and not because of in other words, the force happened because of the injury. The force didn't cause the injury, if that makes sense, right? It's not like he fell over because of a force. That's what it sounds like she's saying.
That the brain would swell rapidly.
You would be unable to identify the rapidity of the swelling if you don't know the amount of force. Isn't that fair to say?
Well, I do know the amount of force because of the amount of skull fractures.
In what you know is, in your words, medium to large force.
Yes.
You've heard of periorbital ecchymosis?
Yes.
And that's sometimes called raccoon eyes?
Well, periorbital ecchymosis just means bleeding and bruising around the eyes.
And you saw the bruising around Mr. O'Keefe's eyes, didn't you, in the photographs?
Well, it wasn't bruising caused by blunt force trauma to the eye. It was bleeding in the upper eyelid because the plates above the eye and the base of the skull were fractured by the brain hitting it. So, and that's a result of basilar skull fractures and not the application of force directly to the eye.
Would you agree it takes a few hours for the bleeding to accumulate in the person's eyes?
No, as soon as you break the skull bones and the heart's pumping, the blood comes out of those injuries. And it starts to accumulate right away. It starts within minutes, you can see it.
So you would disagree?
I just love how she's not even arguing with him. She's not argumentative. She's just like, you're wrong. Here's the answer. There's no narrative. There's no fluff. She's not getting emotional about it, which, sometimes the experts get because they don't like being told they're wrong, right? There's no ego. This is my favorite thing ever. This is probably one of my favorite expert witnesses. The way she's testifying is just so matter of fact and no nonsense. And I adore this. And we don't have, this is very unusual, right? Because sometimes it's nice to have these experts, or the jury might like experts who are a little bit more charismatic, like a Dr. Wolf, right? she's not got the charisma, but like, damn if I don't maybe love this even more.
Guys,
No, as soon as you break the skull bones and the heart's pumping, the blood comes out of those injuries.
So
It
you-
starts to accumulate right away. It starts within minutes, you can see it.
So you would disagree with the suggestion that it takes at least 1 to 2 hours for that bleeding to occur in the eyes. You disagree with that?
I do disagree with that. It starts immediately.
Do you have any studies that you've relied on or literature or support for that?
I understand the physiology of what happens when you get those skull fractures and the density of the blood vessels. And if your heart is pumping, you pump the blood out those broken blood vessels into this small area above the eye. And
Do you
it
have-
it can happen within minutes.
Do you have any studies or literature to support that?
That's my training experience. I can't cite you a particular article at this time. I could certainly go look it up and bring it to you.
Okay. Let me ask you questions about the wounds to the back of Mr. O'Keefe's head.
Yes.
You see a linear abrasion?
Yes, vertical lines, yes.
Now, would you characterize this as a classic wound caused by falling backwards and landing on your head?
What do you mean, every wound is different?
Every wound is different?
Sure, every person's different. Every way you get injured is different.
And so if somebody falls backward on their head and suffers the basal fracture, the wound, from your perspective, can look different.
It depends on the impacting surface.
Wounds on the same surface, say 2 people fell on the same surface, could they have different wounds on the back of the head if they suffered the same injury?
In theory, if they fell, if they rotated their body, if you could reproduce something exactly, then you would see the same wound patterns.
This wound pattern is typical of falling backwards on a hard surface, isn't it?
We know it's from falling backwards and striking something hard.
Can the frozen ground be hard?
A frozen ground can be hard, but it doesn't fit the pattern in this injury.
We'll get to that, but is it
Oh, okay.
hard enough to cause a basal fracture?
It can cause a skull fracture.
The frozen ground is different than a sheet of ice, right? It's not smooth and flat like a sheet of ice, is it?
It could be, I guess.
Okay. You mentioned there's some granular patterns in this wound.
Yes,
didn't
yes.
you? The area in front of 34 Fairview, the frozen ground, do you know if there was any impediments in the lawn that was frozen?
In the what? Oh, the lawn?
Yeah, sorry.
Yes, I saw the scene photographs when the snow was removed, and it was like winter lawn grass. So it was some green, some brown that was pushed down, and like straw that was going different directions, which wouldn't give you that pattern.
Did you see the exact area where Mr. O'Keefe last moved?
I saw that general area, and there were a lot of photographs,
Well,
yes.
You say general area. Can you tell us that you saw photographs of the spot where Mr. O'Keefe was lying when he was found?
Yes, that general area.
Could you see the ground where his head was? Can you identify that?
Yes, with the scene investigation, they shoveled the snow off of that area.
And you had never had a chance to go up to that scene yourself, did you?
No, I just looked at all the photographs.
You cannot see what's under the grass and the dirt, can you?
Well, dirt's under the grass.
Well, do you know if there's any rocks or impediments or bumps?
You know why she took a second? I guarantee you she took a second to answer that because she's like, wait, I like literally what I thought to myself when I heard that pause, I thought to myself, wait, are you like if I was her, wait, are you asking me if I have x-ray vision? And I'm wondering if she literally paused and thought that before she answered. Dude.
You had never had a chance to go out to that scene yourself, did you?
No, I just looked at all the photographs.
You cannot see what's under the grass and the dirt, can you?
Well, dirt's under the grass.
Well, do you know if there's any rocks or
Even better.
impediments or bumps?
It was a smooth surface covered with grass.
It was a smooth surface? The front lawn was a
It
smooth
was a
surface?
flat surface
Flat.
covered with grass.
Okay, and do you know what was under the grass, whether there was any pebbles, rocks, debris
I didn't see any.
from the photo?
Correct.
But you don't have any firsthand knowledge, that exact area where he ended, what the turf was like, do you?
I saw photographs of that lawn where they removed his body from.
So you're relying solely on the photographs, is that fair to say?
Correct.
Do you know if Mr. O'Keefe was wearing anything that could cause abrasions when he landed to cause that scraping pattern in addition to the linear
You
abrasion?
mean the super ultra soft hoodie as it's called on the label?
He did have a baseball hat on, but that would not cause that pattern.
The area of the abrasions, is that in the area of the level of where a baseball hat would be on the back of somebody's head?
It could be.
Could be. If somebody hits the ground and falls backwards, can they slide?
Thank you.
If they're on an incline,
What if they're thrust?
What if they thrust? What is happening?
They slide?
if they're on an incline,
What if they're thrust?
well, if you fall backwards and you fall backwards on an incline, your body might move.
What if you fall backwards
I wouldn't call that thrusting. What is happening to Breenan?
on flat ground?
Oh.
Does the body, can it move after it falls?
Not really, maybe a little. If from the momentum of the impact, it might move slightly, but not really.
Oh my
So
God.
when a person falls backwards and lands, you don't think their head has any room for movement?
Not significant.
Well, not significantly, maybe just a quarter inch, half.
I'm lost. And I don't even know what he's hoping to prove, but he sounds like he doesn't even know like gravity or like basic stuff of like, I don't even know, man.
Half inch?
No, it's possible.
And did you see the scrapes around the wound of Mr. O'Keefe's head?
Of course I saw them, yes.
And they're all within, what, about an inch?
What are you describing? What part? Are you describing the tearing, the laceration of the scalp, or the vertical abrasions?
The vertical abrasions.
There were maybe an inch, inch and a half.
Inch and a half? Do you think that if someone fell backwards and landed on their head, they could move an inch and a half?
Well, he landed on something that had a ridge on it to cause the laceration in the scalp, and then with a little bit of movement, those vertical scratches were caused by some kind of like pebbly-like surface.
You mentioned that the orbital bones were broken and you had opined that it was caused by the brain. Do you agree that a brain is very soft, consistent with, for example, tofu?
Oh my God. Dude, need some Z's right here. You're killing me. You need some Z. I don't know that she meant this to be funny, but this is both funny and also sadly, I think exactly what we will see. Need some Z says, in my opinion, Welcher will be saying something about the tail light thrusting the arm or something like that. I mean, yes, literally, verbatim. That's it. I'm going to take a screenshot of this so that when he testifies to that, we can pull this up and give Need some Z's the due credit there. The tail light thrusting the arm. That sounds like exactly what we will hear. But why is he bringing tofu into this, though?
And it was caused by the brain. Do you agree that a brain is very soft, consistent with, for example, tofu?
Well, and here's the thing. Okay. What a fucking idiot. Because, you guys, there are all kinds of tofu. Everything from silken to extra soft, very soft, medium, firm, extra firm, and then I forget what the most firm one is, like super duper firm or something. So, and like the really firm tofu is what it sounds like. Hard as a rock almost.
Oh, gross. What do you mean?
Why does she say it's gross? I guess because the comparison is gross. Soft like tofu. It's also just, that's a weird thing to say.
The orbital bones were broken and you...
I think also she's never thought about brains in that manner, right? I bet when she's doing autopsies, she's not thinking about human parts of the human body and comparing them to food that you would eat, because that would be gross, right?
Opined that it was caused by the brain. Do you agree that a brain is very soft, consistent with, for example, tofu?
Oh, gross.
I mean, like, imagine if he had said cottage cheese. What if he had said, do you think a brain is very soft, for example, like cottage cheese? To me, like that, like, I think it probably would have elicited the same response. What do you guys think?
What do you mean? It is soft.
Right?
Is it that soft? Is that the texture of
Well,
it?
it depends on what kind of tofu you have.
Okay.
Thank you, ma'am. So there you go. The fact that she knows that means she must eat tofu. And clearly what Mary said, she enjoyed tofu until now. He made the tofu gross by comparing it to scooping out a brain and eating it.
Do you think that the orbital could have broken when the break on the back of the head split the skull and then would cause the orbital break instead of the brain?
The orbital plate fractures, if you look at the base of the skull after you take the brain out, you can see the fractures go up from the back to the front into the orbital plate. Sometimes when you fall backwards, the brain can also slap those orbital plates and cause some damage, but I could trace the fractures from the point of impact along the base of the skull to the part of the skull over the eyes.
Do you think the base of the skull break, when it separates, could have caused those orbital fractures?
I don't understand your question.
Yeah.
When Mr. O'Keefe incurred that head injury,
Yes.
the basal fracture, do you think that the pressure, the damage from that basal fracture, the separation, could have caused the orbital breaks in his eyes?
Well, the fracture of the plates above the eye, when the blood is still pumping, there's a space there where the blood can come down into the upper eyelid.
So you described the brain as causing that break. I'm asking you, could it have been from the basal fracture, from the skull fracture?
Yes, the fracture that was caused by the impact to the back of the head, radiating to the front of the base of the skull.
So when you told us on direct it was from the brain that caused those fractures, was that just a summary, or is that to a reasonable degree of medical certainty?
Well, sometimes the brain can also, in a fall, flap and hit those, but in this case, I could also see that the skull fracture started at the back and came to the front, but it could also be contributed to by the brain hitting those delicate bones.
I guess my question is, when you've provided the opinions generally of what you believe and what you've
He's like, I don't even know what my question is. Excellent.
seen, are these general opinions, or are they actually specific opinions based on the facts of this case?
They are opinions based on my examination of this case, but all that's based on my 40 years of training and experience.
What a fucking phenomenal answer that is, guys. You could not ask for a better answer. And it's the fucking truth. But you know what? This could have tripped up a lot of experts. Literally, I kind of expected her to be like, oh, I don't know which one she's going to say. I don't know that I've ever heard an expert answer that same question, because they all get asked that, right? I don't know if I've ever heard anyone answer it that well.
Are these general opinions, or are they actually specific opinions based on the facts of this case?
They are opinions based on my examination
It's both. Amazing.
of this case, but all that's based on my 40 years of training and experience.
Well, when you told us about the
Excellent,
brain
man.
causing those orbital fractures, you would agree with me, at least now anyways, that it very likely could have been the basal fracture that caused those breaks.
Yeah, both.
It could have been both?
Sure,
Okay, could it have been just the basal fracture?
that's possible.
When you offered the opinion to a reasonable degree of medical
Like, I
certainty,
never disagreed with you on
had you
this.
considered the basal fracture as the source of those breaks?
Of course.
Is there a reason you didn't share that with us and you just said it was the brain?
I had no reason not to share it.
Okay. Was there any depressed
She's like, if you had asked questions that weren't so nonsensical, maybe I would have said that earlier.
fracture to Mr. O'Keefe's skull?
No.
Can you tell us a little bit about a depressed fracture? Depressed fracture is different than what we saw with Mr. O'Keefe, isn't it?
A depressed fracture is when something fractures the skull and then pushes the skull and moves the skull inward. This just
Sounds a bit thrusty to me.
had a fracture, but it didn't move the skull inward.
And you've seen depressed fractures in your practice over 40 years, did you say?
Of course.
In those 40 years, depressed fractures can happen from sharp objects,
Sure.
pointed objects.
Sure.
If someone hit a person in the back of the head with enough force, with like a hammer, for example, that could leave a depressed skull fracture, couldn't it?
Certainly. You can hit somebody on the head with a hammer and cause the fracture, and then the continued force will move that fracture into the brain.
There was no depressed skull fracture in this case, was there?
Correct.
I was about to say, is he going to try to suggest that the tail light had a hammer with it? And I'm like, where is he going with this? And he's saying, oh, there wasn't one. Okay.
You gave some opinions today
I
about
haven't been to lunch yet.
you gave some opinions about wounds on Mr. O'Keefe's arm. I'd like to talk to you a little bit about that.
Sure.
Could we have that photo brought up, please?
Wait a second. Wasn't she not allowed to testify about this? Like, sorry, I'm not crazy. That literally happened, right? That literally happened. They talked about it a lot, I think earlier on this day, but also yesterday, because it was crazy, right? You guys remember? And then, did she ever rule on that though? Hold on, I'm trying to remember. Because, no, I don't think she has ruled on it completely. So, okay, so what happened up to now, just refreshing my own recollection here, is that the defense had came in with that amazing argument in the morning, which I thought was one of Jackson's best, where he said that, he said to Judge Bev, Judge Bev ruled that she couldn't talk about this, which now Breenan's asking. Judge Bev said she couldn't talk about this. Then he comes in and says, well, hold on, the Commonwealth opened the door, which they did because of the whole thing with Dr. Russell. And then she hasn't ruled on that yet, to my knowledge, unless it happened outside the presence of the cameras or whatever. But now Breenan is asking her about it. So is he trying to open the door, the double door? Like, I don't understand. Let me see what happens. I wonder if they're going to approach.
Do you see all of those superficial abrasions?
Yes, I see patterned injuries.
Right. Would you agree that they're superficial abrasions?
Yes, they go along the skin surface.
How many punctures would you identify in that photograph?
Let's see, there may be some punctures like around the elbow, consistent with the teeth puncturing. Most of them are the teeth scraping along the skin.
I'm not going to ask you what you believe the cause was. I'm going to ask you just about the wound. How many punctures do you see?
Well, this doesn't show, there are other photographs which show more of them, but there's the little dot-like areas you could call an area of skin puncture.
Can you tell us from this photograph how many punctures you would say are in that photo?
I didn't count them.
Did you suggest that there was more than one puncture on that wound?
I think I see more than one, yes.
Pardon me?
I see more than one on there.
Okay, could you give us a count of how many punctures you see?
Well, without looking at all the photos, I couldn't give you a correct number.
Okay. You've written a report, haven't you?
What?
You wrote a report?
I did.
And in your report, you describe many of those abrasions as punctures, don't you?
Yeah, yes.
And a puncture isn't just a scratch. A puncture is a penetration of the skin, isn't it?
Yeah, a point-like penetration.
A puncture has a very specific medical meaning, doesn't it?
Yes, it's a point-like penetration of the skin.
And according to you, there are many punctures in that wound.
Yes, I can see 1, 2, 3, 4, 6 or 7.
Can medical professionals disagree on opinions about wounds and causes?
So I don't think
I
this has happened yet, guys.
You also gave some opinions that you did not believe that Mr. O'Keefe's scratches were caused by
Yeah.
having some impact with broken pieces of plastic or glass, correct?
I don't think this, you guys, what you guys are saying, y'all heard it earlier. This hasn't happened yet today because literally they haven't, she had not, the last we heard, this witness was not supposed to be testifying to this.
Also gave some opinions that you did not believe that Mr. O'Keefe's scratches were caused by having some impact with broken pieces of plastic or glass, correct?
Correct. They weren't caused by that.
Broken plastic or glass can cause a number of different angled wounds, can it?
It causes an array of irregular, random injuries.
It can have infinite different patterns, couldn't it?
Could.
There's nothing to hold a wound from a broken shard to be north or south, east and west. It all depends on how the force is impacted on the body, true?
I'm not quite clear on your
Okay,
question.
I'll try to do better. We're talking about shards of broken glass or broken plastic. There's no set direction that they may cut somebody, is there?
Well, it would depend on the case and how those occurred.
It can happen in many different forms as far as depth, yes?
Well, anything's possible.
Oh my God, this line of, this is so fucking dumb.
How about length?
What about length?
Wouldn't that change? Could
What about length, guys?
that change depending on how the injury occurred, the length of the wound?
Sure.
And in this case, you talked about your opinions of injury relative to a motor vehicle, didn't you?
That was something I considered.
That's something you considered. Did you know much about the details of the motor vehicle in this case?
Yes.
Okay. When you considered your differential diagnosis, did you consider whether there was any DNA on the vehicle?
I didn't look at any of that.
I'm sorry?
I did not look at any DNA.
Did you know if there was any hair on the vehicle?
I don't know.
Did you consider the scene itself where there may have been a debris field? Did you take a look at the debris field in this case?
I know there were photographs of various pieces of plastic around the area where the body was found.
And do you remember where those pieces were found?
Somewhat, yes.
Did you have an opportunity to consider other evidence like
Feel.
a shoe in the area near where Mr. O'Keefe was found?
I know one shoe was on his foot at the hospital, the other was at the scene.
Do you know if his hat stayed with him after he landed on the ground?
The hat was in the area where his body was found.
Did you take a look at his pants, the back of his pants?
I looked at that, yes.
Okay, what did you see when you saw the back of his pants?
Well, because he had bled from the back of his injury and he was on a hospital gurney, some of that blood came down, so some of the blood was on the back of his pants.
Did you see anything else other than blood on the back of his pants?
I don't remember.
I'm sorry?
I don't remember if I saw anything else.
Did you look, when you were doing your differential diagnosis, did you look at any evidence other than physical evidence? Did you look at any data evidence?
I don't know what you mean, data.
Like data you would find on a cell phone?
Oh my God. And what she means by that is that question is the dumbest fucking thing, which it is.
Did you look, when you were doing your differential diagnosis, did you look at any evidence other than physical evidence? Did you look at any data evidence?
I don't know what you mean, data.
Like data you would find on a cell phone?
No.
Did you look at any of the data evidence from the defendant's Lexus?
No, other than looking at the contours of the back to see if it had impacted Mr. O'Keefe.
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Oh my God. Y'all. What?
When you were doing differential diagnosis, did you look at any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Her facial, I agree. That right there, dude. The way she says it, again, there's been no emotion, no narrative, no whatever. I want to watch it on normal speed because you're right. The facial expressions say it all. Her facial expressions are like what we're all thinking if we weren't so mad. And when we're just like, this is dumb, she's like, this is the most ridiculous thing. Like, she's just so dismissive. That's the word I'm looking for. So dismissive.
Any information that would tell you what the speed of that impact may have been or allegedly was?
Well, it didn't hit him, so it doesn't matter.
Oh my God, my hero. And just so straightforward, dude. Oh, wow.
So you didn't care to know anything about the car or the data
Breenan. So you didn't care to know any data about the car. Really?
in the car because you had already formed your opinion?
Yeah, dismissive.
It did not hit him.
It's
so
like, yeah, oh my God, her face. It's like, it's not even worth, she's like, I'm not going to bother explaining it to you because if you don't understand, if you can't get it, there's nothing I can do for you. You know what I mean? It's like, if this, like, this is so basic There's nothing I can do for you. So I'm not even bother trying to explain this to you. Like, it's just, it is what it is.
Well, it didn't hit him, so it doesn't matter.
Okay. So you didn't care to know anything about the car or the data in the car because you had already formed your opinion?
It did not hit him, so it was not relevant to my opinion.
Is that a different way?
By looking at the body, I could tell that there was no evidence of impact with a vehicle.
Is that
So
Dude.
whether the vehicle was going slow or fast is not relevant.
So this could be, I think, especially because of the delivery, I think this could be, if I were on the jury and I was on the fence, this might be like the most important testimony I've heard, especially because of the delivery. You guys, this is, wow. Wow.
Him, so it was not relevant to my opinion.
Is that a different way?
By looking at the body, I could tell that there was no evidence of impact with a vehicle.
Is that
So whether the vehicle was going slow or fast is not relevant.
And so you didn't try to get any information about the speed of the vehicle? It was totally irrelevant to you?
And the thing
Correct.
is like the if you read between the lines there also, it's like that this entire trial is not relevant. You guys hear that? She's like, whether the car was going slow or fast is not relevant. And it's like, just like this trial is not relevant. Why are we all here? Why are we all here talking about the speed of the car? This is nonsense.
There's no evidence of impact with a vehicle. So whether the vehicle was going slow or fast is not relevant.
And so you didn't try to get any information about the speed of the vehicle? It was totally irrelevant to you?
Correct.
And did you also
I love that you said correct. Holy fuck.
disregard?
Wow.
Well, let me ask you, do you ever look at statements?
I look at witness statements if they're available to me.
Were any of
Really? If I were him, I would stop. Quit while don't, this is, dude.
the defendants' statements made available to you?
Unbelievable.
I did hear some of them.
Did you consider the ones that you heard?
Of course.
Which ones did you hear?
I really can't answer that. I don't know what you'd have to give me an example.
You said that when Mr. O'Keefe was first incurred his injury, you think that he was unconscious?
Yes, I think that the severity of
Oh, interesting. She was going to make him say it and he didn't do it. Interesting. He backed away. Huh.
you'd have to give me an example.
You said that when Mr. O'Keefe was first incurred his injury, you think that he was unconscious?
Yes, I think that the severity of the impact made him immediately unconscious.
So if hypothetically Mr. O'Keefe incurred his injury sometime around 12:32, is it your opinion that he never moved again until he was moved physically by somebody else?
Well, I don't know the exact time that he got the injury on the back of the head, but after that time, he could not carry out any purposeful activity.
May I approach sidebar, Your Honor?
Okay. Okay, he's approaching cyber. Yeah, somebody was asking, who was it? Kat Reno was asking, would anyone want him as a lawyer, Breenan? Yeah, I can't imagine anybody, I mean, unless they have never, if they can stay completely clear of this trial and they've never heard of anything from this, then maybe. But like, if you're going to hire somebody who's like a high profile lawyer, you would definitely look into the cases if you didn't already know that ahead of time. I think if you watch just one day, pick a day, any day, you watch of this trial, I mean, I've said this since the beginning, like, it was clear, like, I was like, dude, no criminal defendant would ever hire him. There's just no way. So like I was saying, like, unless the Commonwealth offers him a full-time job, since like money's no object, I don't know where he would work. I don't even know if many prosecution, like DA's offices would hire him, honestly. I would be shocked. You'd have to find one that's just as what's the word? Just as fill in the blank as the Commonwealth is doing. Is that lunchtime?
Okay.
Okay, so some of you guys, I think, thought this already happened. This might be the thing that you thought happened, where she rules on the dog bites. But this is what this might be, because I hadn't heard that yet.
Maybe see it.
All right, so Mr. Brennan, if you can briefly tell me what it is you want to introduce through this witness.
To remind the court, on direct examination, the defense promoted Dr. Laposata's credentials, including specifying her successes with the station nightclub fire and her running of her office. We have an audit from 2005, State Department of Rhode Island, Department of Health. In that audit, it paints a very different picture than was presented on direct examination. In that audit, they investigated, chief medical examiner and they compiled a history of statistics for the medical examiner, which was Dr. Laposata. There were no reports, incomplete reports, and unsigned reports of over 1,500 individuals between June 30th, 2000 to June 30th, 2005. So in that 5-year period, there was an extraordinary number of individuals that weren't properly attended to, showing negligence, if not malfeasance. It was recommended that the standards, policies, and practices of Dr.
I'm just trying to think. There was a part earlier in here where we had to refresh the stream, and I wonder if I accidentally, let me just see here. If you guys are sure that it should have happened, let me just take a look and make sure we didn't miss it, because there's on the record. Let me just double check, because I'm wondering if maybe I accidentally clicked the wrong, like clicked forward and missed. Let's just see here. Also, oftentimes Court TV doesn't have these timestamps correct, and then it's tricky. Let me just see. There's the x-rays. So it would be after that. Oh, hold on. What is this?
Please rise for the jury. May be seated.
Dr. Laposata, you can step out. Okay. All right. I did receive another motion this morning for a curative instruction. I'm not going to even consider this today. We can consider this at the charge conference. So that's where we're at with that. All right. Work it out. If you can't work it out, let me know. I'll come up before the jury.
No, we heard this part. Okay. And then let me see.
Just please go ahead.
You see any x-rays?
I did.
What were the x-rays of?
The x-rays were taken of Mr. O'Keefe at the medical examiner's office, and they were x-rays of his chest.
So we watched all this. I'm just trying to make sure, guys, because there's the arm. I mean, when did they? Hold on. Let's see. Maybe there's a sidebar. Let me just see here. Is this where we? Oh.
Excuse me.
May be seated.
All right. So, Mr. Brennan, if you can briefly tell me what it is you want to introduce through this witness.
To remind
This is where we were. So I guess we haven't missed it yet. Where she rules on that. Maybe it's at the end of this. This. Whatever they're doing here outside the presence of the jury. Oh,
the court on direct examination, the defense promoted Dr. Laposata's credentials, including specifying her successes with the station nightclub fire and her running of her office. They have an audit in 2005, State Department of Rhode Island, Department of Health. In that audit, it paints a very different picture than was presented on direct examination. In that audit, they investigated the chief medical examiner, and they compiled a history of statistics for the medical examiner, which was Dr. Laposata. There were no reports, incomplete reports, and unsigned reports of over 1,500 individuals between June 30th, 2000 to June 30th, 2005. So in that 5-year period, there was an extraordinary number of individuals that weren't properly attended to, showing negligence, if not malfeasance. It was recommended that the standards, policies, and practices of Dr. Laposata's office would need to change because of the extraordinary backlog of cases regarding autopsies. In addition, it was noted that the reports.
I would imagine you'll get paid more than freaking Aperture did. So just if I had to guess.
Confirmed that there was significant concerns with the historical management practices of the medical examiner's office shortly after Dr. Laposata resigned.
I mean, maybe his goal, it's like selling your soul for the devil. Maybe his goal is to just make enough money to where he can retire after this because he knows his career will be over anyway. Maybe that's his goal. Maybe he's going to like run the bill up. He's hoping to make like, I don't know, however much, a fuck ton of money, right? Commonwealth has all this huge budget, whatever. And he's like, okay, I'll do, it's like, it's like pouring yourself out or whatever. It's like, I'll do whatever. I'll like literally ruin my career. But I'll retire. Maybe, I don't know, maybe.
In addition, it was promoted that in the station nightclub fire, Dr. Laposata had a heroic effort. And in her testimony, she also noted that there was a failure, or implied there was a failure because the medical examiner.
It's clear that his motivation is winning and not actually like justice or even just like the practice of law. You know what I mean? Like in terms of like, some people really enjoy the legal argument and the strategy. I mean, I guess there's strategy here, but it's really just for the sake of winning at all costs versus like the art, right? Like, there's no joy for him practicing law, right? I mean, look at the defense attorneys. Even when they're upset about shit, rightfully so, they still love what they're doing, and you can tell. And it's just a huge difference. So that's what I'm saying, right? Like, I don't know.
Somebody did not go to the scene to look at the turf in front of 34 Fairview Road. She suffered the same criticism. For hours and hours after the station nightclub incident, she was contacted with a request to come to the scene. She refused to come to the scene, did not appear for at least 17 hours. Directly on point to the claims that she's making against other people is the same conduct she engaged in on a more extreme scale.
So now he's just
She testified in Commonwealth versus Tompkins. In Commonwealth versus Tompkins, she was listed and testified as an expert, attempted to testify.
You know what I think this is? I think this is retaliation. I mean, who knows what the fuck? I mean, I don't trust anything he says, but him trying to introduce this, in my opinion, this has got to be retaliation for her saying what 3 times he didn't get hit by a car, so it's irrelevant. That's what happened right before this, and now he's like, bah, 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 bah. It's just retaliation, vengeance.
As an accident reconstructionist, which was denied. Inevitably, the court made conclusions. Actually, in that case, her efforts to be an accident reconstructionist were denied. Then she testified in a case called Patino. And in Patino, after
Watch
testifying,
him with his binder. He's constantly flipping. This is the other thing. He's either constantly flipping, or if the papers are loose, he does the angry loose paper stacking. But notice he's not actually finding anything and reading it. It's really funny.
actually, in that case, her efforts to be an accident reconstructionist were denied. Then she testified in a case called Patino.
He already knows the name before he flips to the page.
And in Patino, after testifying, she received great scrutiny and criticism from the
I mean,
court.
now he's flipping to a different page, but he's still talking. And you see what I mean?
The court noted on page 1025 of the transcript when Dr. Laposata gave the testimony, she knew the boy wasn't like this because he fell off a bed. She knew the mother was lying. She read the text messages and knew the defendant had beat the boy. The only reason I conclude that she offered such testimony was to distance the defendant from causing those bruises, setting up an argument against malice, but instead destroyed her credibility. On cross-examination, she came across as a hired gun. Sometimes it's seemingly small things that impeach a witness's credibility. Inevitably, on the credibility determination by the court would agree. The jury gave greater weight to the testimony of Dr. Gilson and Snelling than they did Dr. Laposata for the reasons I addressed previously. The jury was justified in discounting her testimony and concluding the other doctors testified apparently impartial. While she appeared as a paid
I just want to note that this part where it says she came across as a hired gun, what that means is that's like trying to say what she came across to the jury, right? However, this is a court opinion. So in other words, the judge is saying she came across as a hired gun. So let me just make sure that's clear. That's him saying how he interpreted the testimony of her. If whatever he's saying is what he looks like he's reading court opinion. She came across as a hired gun. In other words, that's not like they surveyed all of the jurors and all of them freely spoke and all said that, because jurors wouldn't know that expression, right? Jurors don't know that expression. So just keep that in mind. And so in other words, the jury might not have even thought that. If this, just keep that in mind. This is a judge. But remember, people who are judges or attorneys will assess the performance of witnesses, judges, and attorneys differently than lay people and jurors. So
advocate, at least on this occasion, without impugning the witness's integrity, because that witness is known to the court. But in this case, when she testified, she was not credible. That's a direct credibility determination by another tribunal about her testimony. So I would like to, and that's why I came sidebar rather than ambush, to give the court notice that I'd like to get into the criticisms regarding her run as medical director that led to resignment after she was audited and left 1,500 bodies unattended or incomplete. Also get into the criticism she received for her handling or lack of handling of the station nightclub fire, and finally get into the adverse credibility determination in the Patino case.
So I'm not familiar with the Patino case, so I'll need a copy of that.
Yes.
All right, Mr. Jackson, I'll hear you.
Thank you, Your Honor. First of all,
I wonder if this is the part that, okay.
Said that the audit established that, as the chief medical examiner, the audit revealed that she left 1,500 bodies unattended, was his quote. Bodies unattended. That's absolutely not what happened in that situation. It was a political situation. The medical director for Rhode Island came in and took over. He began to change protocols and cut quality control. He said he did not want a second set of eyes on any of the reports, not the autopsies. There was never a suggestion, ever, that an autopsy was not performed efficiently and timely. Never. The reports that were attendant to the autopsies it was a 2-tiered set of criteria that Dr. Laposata put in place to establish quality control and quality assurance. First, the medical examiner conducts the autopsy and writes a report. Then the doctor herself, the chief medical examiner, because she is a perfectionist, determined that she was going to establish a protocol in which she would put eyes on every single report. Hundreds and hundreds of reports per year. In doing so, she had to prioritize which reports were going to take a priority, which ones were being subject to litigation, which ones were going to be subject to criminal cases, and which ones were never going to be subject to any review at all. For instance, if somebody was found, let's say somebody that was without family, etc., found and unidentified, there's no litigation attendant to that report, she would put that report aside and get to that report after she dealt with the reports that were on sort of on the front burner, if you will. After, by the way, none of the reports were ever not done. They were all completed. There were a small fraction of reports, according to the audit and according to Dr. Laposata herself, that had to take a backseat. When the medical director came in 2005, by the way, this is 25 years ago, right? These are autopsies that were performed, and the audit was performed for autopsies and reports dealing with the year 2000. It's 2025. This is 25 years ago. When the new medical director came in for Rhode Island, he said, I don't want any review of any of the reports because it's more efficient and it's faster to get the reports out in a timely fashion. She resisted and said, I will never, ever, and she was published saying this, I will never, ever sacrifice quality for speed. I want the highest quality coming out of this office. They had a difference of opinion. She walked away because he was asking her, the new medical director was asking her to sacrifice quality of the conduct she was undertaking as the chief medical examiner for the state of Rhode Island. So it's a very different circumstance than was just suggested. No bodies were ever left unattended, ever. Certainly did not involve, the other phrase that was just used is negligence and malfeasance. It was a backlog, and they had a very public political fight over it. Number two, with regard to the Station nightclub fire, her staff was on location immediately. She, as the chief medical examiner, was there the same day. So that's of no legal moment. It's of no consequence. It certainly has nothing to do with her opinions and conclusions in this case. The Tompkins case, we've already talked about that in voir dire, Your Honor. The Tompkins case dealt with an issue dealing with accident reconstruction, which she's not undertaking. I'm not asking her, and she ain't saying.
I've excluded that part of it based partially on the Tompkins case.
Right, and I don't know anything about the Patino case. And what I would say is, given the fact, look, we don't know what the facts of that case were. We don't know what the trial was about. We don't know what the cross-examination was about. We don't know why she was called. We don't know what she looked at. We don't know why she was looking at what she did look at. We don't know why she didn't look at things that she might not have looked at. We don't know why her opinions and conclusions were ultimately rendered. We would have to have a trial within a trial, which I would be happy to undertake if someone gives me a trial.
I love that.
Happy to do that. But I don't think we want to do that. I don't think the court wants to do that. Also, I will say, I don't think that attacking this witness's credibility is in good faith by the Commonwealth. Mr. Brennan himself has hired Dr. Laposata personally,
Oh dear.
no fewer than 4 or 5 times, maybe it's 3 or 4 times. He knows her qualifications. He knows the quality of her work. He's actually undertaken to consult with her as a medical examiner and a consultant. So I don't believe that these last 2 issues are in good faith. I don't believe the station fire has anything to do with anything because she was late, according to Mr. Brennan, in coming to the actual location. She was there the same day, and she had an entire staff that was there immediately. And in terms of the audit, it's a 25-year-old political fight that isn't quite what Mr. Brennan made it out to be. So I don't think any of these things are relevant for prosecution.
You know, next level hypocrite, right? He's hired her multiple times. Breenan has. Incredible.
Examination. Awesome.
All right.
I just want to make a note that Attorney Jackson has a way with words to just inflate or make things up. I have not hired Dr. Laposata 4 or 5 times. And so that is just a mischaracterization, which he likes to do for the public. But the reality is, I've used her a few times, and the last time I used her, I'm not going to disclose why I don't use her.
A few times? If you're going to make a big stink about 4 or 5 times, as if that's like completely wrong, you better be saying 0 times or 1 time. But if you say a few times and you don't give a specific number, first of all, even if he gave a specific number, if it was anything besides 0 or 1, we'd be looking at 2 or 3, which is, I mean, really, are we going to split hairs over that if it's 2 versus 4? But he doesn't even give a number. He says a few. You've got to be kidding me. Disgusting.
Words to just inflate or make things up. I have not hired Dr. Laposata 4 or 5 times. And so that is just a mischaracterization, which he likes to do for the public. But the reality is, I've used her a few times, and the last time I used her, I'm not going to disclose why I don't use her. It's unfair of her in the room. But the suggestion that somehow I'm endorsing the qualifications of this witness, I am not.
Oh, look at Lolly just sitting there. Do you think he just wants to disappear? Let me pull this down so you guys can see his posture. Look at his posture. I think he's doing this thing where he's like, pretend you're not here. Pretend, you know, if I close my eyes, no one can see me. You know, like little kids do. That's what he looks like to me. He's trying to close his eyes and imagine he's on a desert island somewhere, just drinking a pina colada. Like,
that's what I'm saying.
Okay.
He's just
So the
barely alive.
first 2, the backlog issue, if we can call it that, with the ME's office, I'm going to allow the Commonwealth to get into that through questioning. Same with the Station nightclub fire, based on the testimony already in evidence. Those 2 areas, and Mr. Jackson, without leading, you can certainly go back and rehabilitate her. But those 2 will come in. I'm not going to do anything with Tompkins because I used it for the basis of keeping out what appeared to me to be biomechanical engineering opinions of this witness, and she's not qualified to do that. So I have not read Patino. I will read it over the lunch break and see if we get anywhere with that. Okay.
Okay, so maybe after the lunch break is where we get the ruling for real on what she can do.
So I need a copy of that. I want you to give Mr. Jackson a copy as well.
Because that's what I was saying. Is like at this point, the Commonwealth was trying to keep out the dog bites in the arms, but Breenan was just asking her about it, right?
Okay. Okay. So,
I mean, having said that, he's done this with numerous witnesses, but
all right.
You want to do anything? I don't know if I have it now or after lunch or later, because I want to address the issue of the three.
Okay. So let's mark those now.
Sure.
did you say Bree?
There's one ABC.
Okay, there's the actual thing. Okay.
There's no objection to these coming in through another witness.
Okay.
All right. Mr. Brennan, there's no objection to these coming in through another witness. So you agree that they'll be coming into evidence?
I'll stipulate.
All right. And what's the objection to them coming in through Dr. Laposata?
It's not part of the report or opinion.
Are you joking? Stop. Wow.
She's gone beyond the report, talking about the fact that she's studying x-rays and giving an opinion. I think that suffices. It really, I think, is beyond the scope of her testimony to begin with. I'd be gracious with it. Stipulate these and show Dr. Rentschler utilize them for stipulation.
So you'll stipulate to them prior to Dr. Rentschler?
I will.
So you can use them with Dr. Rentschler.
I think that I could, because he certainly used them in his analysis and opinion. I should be subject to the entry of evidence in the defense case in chief. I understand I can use them in Dr. Richard's testimony, but I want to use them with Dr. Laposata. She's a medical doctor.
Would you-
Consider them for purposes of her opinion. I cannot understand.
So what do you want to ask her about them?
Are these the x-rays that you reviewed? Yes, that's it.
What type of question is that, Bev? What do you think he wants to ask her? What is going on? Is she like, why are these x-rays even here? They're so irrelevant and useless. Like, what?
Okay. So go ahead.
That's always going to ask. I won't have a problem.
Okay. Yeah, I have no problem with that in that form.
That's it. Literally, these are the x-rays that we talked about a little bit earlier. Yes, this is the right hand. Yes, that's the arm. Forearm. Yes, that's the upper arm.
All right. So they're cumulative, but if they're coming in anyway, I will let you put them in.
Thank you.
All right. So the last thing is Dr. Rentschler. I need to hear argument from both sides. I have a new PowerPoint. So I'll hear both of you. Mr. Brennan, I'll hear you on your motion.
Oh my God. Here we go. Finally, the Dr. Wenchler motion. Here he goes. Thanks, Liz.
We've received the most recent update to Dr. Rentschler's PowerPoint. There are some additions, different analysis in that PowerPoint. This is within 24 hours of him testifying. There are opinions on page 6 and 8 of his May 7, 2025 report.
Now look at the guy who y'all said is the appellate attorney for the Commonwealth. Watch his face here.
6 and 8 of his May 7, 2025 report. And there are a number of numbers.
He looks not so confident. I mean, I know. So basically, we see him all the time, right? Normally, he's just expressionless. It's not like I'm saying he's normally smiling. Like he's just completely, there's nothing, right? So this is kind of unusual to see him make some faces.
Of his May 7, 2025 report. And there are a number of numbers that we have objections to. Dr. Rentschler just generally shouldn't be allowed to express.
Normally, he doesn't even look left or right. He just looks straight forward. It's really funny, right? But now he's looking, I mean, most people turn their heads, but like literally, I don't think I've ever seen him turn his head or make any type of expression.
Opinions and conclusions about what he thinks about the case or about other
All right,
witnesses.
so I'm looking, I think, at the new
Do you have a copy of the new one?
from today, page
Oh!
6.
You just asked the dude.
Thanks.
Oh, Lolly coming in.
So what I have are just photos with measurements. So I
Lolly's
don't
like, I have a paper. Here you go.
know what the testimony that corresponds with
Yeah,
those.
Lolly.
I've read, obviously, the report of Dr. Rentschler from May 7th. That does not seem to detail everything, and that's no criticism. I'm just saying it's a scant report. So I don't know what the opinions are regarding these.
I'm sorry. Yeah.
I do want to go to Mr. Brennan. I just want to let the board know to come that out. Now, we went through, based on Mr. Brennan's discussions last night, and significantly edited the entire thing. Literally every single slide is got a problem with. There were a couple, we just removed them left, but it's very clear.
I see that a lot of the hearsay has been removed.
Thank you.
I'm sorry? All right. So what are you both I'm going to hear from Mr. Brennan first. What are you objecting to as the report now stands?
I have a most recent copy of the report now.
How does he not know what he's objecting to?
So 9 through 27,
Slides 9 through 27 or pages?
slides 9 through 27 now have Dr. RENTSCHLER identifying and attempting to match different abrasions with different holes in Mr. O'Keefe's sweatshirt. And so basically what he is trying to do is to suggest that there are a different amount of abrasions relative to the amount of holes, or perhaps he might want to testify about that the holes in the sweatshirt were in a different place on Mr. O'Keefe's arms than the abrasions. The reason why this is concerning is because there is no background for him regarding fabrics. This is a different and new opinion that we have not prepared or obtained an expert for. We probably have very little time to get somebody to rebut this analysis regarding fabrics.
The expert he would have used would be Judd Welcher. That's
I don't see anything in his CV or his history that allows him to equate the number of holes in fabric with the number of abrasions on somebody's arm. It does not consider
Oh my God, just stop it. This is
or count that there could be multiple wounds from one hole, or there could be holes that don't create wounds. So whatever the implication is going to be by Dr. RENTSCHLER, we're not very sure, but it obviously would require some type of expertise, which I do not think that Dr. RENTSCHLER has a foundation for. So those are 9 through 27 generally, and then specifically, I can run through quickly the individual objections I have. Slide 6 tries to define the theory of the alleged incident. Doesn't say whose theory it is. It implies it's the government. It's an improper suggestion.
Hold on.
I mean,
Okay, so
what I will say, I agree with him there, and here's why. Because the government's theory, if you can even pinpoint it, has changed a million times and is still changing. So I do agree it's hard to say that what the Commonwealth's theory is.
which one of 1, 2, and 3 on 6?
One is objectionable. What's the core issue of the case? It's an ultimate issue for the jury. An expert reconstructionist or a biomechanical engineer shouldn't be defining the core issue of the case. And then 3, first event is alleged contact between the rear of the Lexus and Mr. O'Keefe's right arm. Again, that's offering an opinion that doesn't have facts and evidence, not in position to draw that opinion.
And is 2 okay? Or are you moving to the whole slide?
No, on number 6, all 3 of them shouldn't be there. Asking what the core issue is in the case, Dr. RENTSCHLER and no expert should be defining what the core issues in the case are. They should talk about their training experience, any testing, observations, evaluation, and then give their opinions, not core issue in the case.
All right.
Slide 9 outlines perhaps his process. The first step of the analysis to determine if the arm injuries are consistent with the physical evidence. Evaluate the abrasions and compare the evidence. I suppose this is what he's done. This is one of the less offensive ones, although unnecessary. It doesn't provide an opinion. I could live with that. The next one,
You could live with what?
number 9.
Okay.
Number 23. Again, this gets into that new core opinion about trying to identify or, I think, compare the abrasions to
I mean, I appreciate, Kim, that you have empathy or, compassion for him. That's
the different wounds.
Does a lot.
I think the part that's objectionable is the words measurements, question mark. I'm not sure if it's implying failure of somebody else. It seems to be an opinion, and I'm not sure of the context of it. 24. The expert is trying to define what Dr. Welcher had done. It may be that he's saying he conducted his testing based on the position of Dr. Welcher's arm. I think that would be an appropriate comment, but it's not clear what they're saying. The pain transfer test, number 2, is the only test noted with respect to the arm.
So without the text, are you objecting to this
No.
slide?
No.
Okay.
31 posits questions regarding ultimate opinions. I think it's inappropriate. And then 32, I think, is improper because it ultimately endorses or vouches for the witness's credibility. I think he certainly can give an opinion that the evidence is inconsistent with the injuries to Mr. O'Keefe's arm, but I don't think it should be on a slide bolstering his opinion. 33, again, is posturing the weight of the evidence. And it's resigning the government to a particular study, one study. It's really a commentary on the government's case. It goes like this. Number 1, Dr. Welcher only did A, and second part, A is insufficient. So that's really what this is saying. It's commentary, it's hearsay, it's inappropriate. 34. I think if one said that that's what he did, I, Dr. RENTSCHLER, took a step to determine the kinetics of Mr. O'Keefe's arm during the alleged incident and asked how would this arm move, I think that would be appropriate. But he shouldn't be giving an opinion on what steps should have been taken by Dr. Welcher. Number 2 on slide 34. And number 3, I don't have a problem with. The next one is 46. Again, this is bolstering the expert's opinion by putting it in writing on a slide. I think some of these opinions are appropriate for Dr. Rentschler to share with the jury, but his final ultimate opinion shouldn't be endorsed on a slide. 47. Again, this is self-endorsement of the success of his tests and giving his opinion about his success. Number 1 and 2.
Sorry.
I think are inappropriate. Number 3 has really no context standing alone. And number 4, if he notes that's his next step, I wouldn't have a problem with number 4. Slide 54.
Notice how much time Bev is giving him to do this, by the way, when all these objections were in the motion listed slide by slide, and we read them last night. Look how much time she's giving him.
Again, number 1 gets into his opinions.
I will say, at the first hearing, he started out seeming promising, right? He was a very different person, I will say, at the first hearing. And over time, I watched him morph. And it's really, he's unrecognizable. If you were to go back to the first hearing, it's insane.
Number 2, he gives an opinion about a different expert, a medical opinion. And number 3, it's, again, self-endorsement on his own opinions. So all these are opinions, either bolstering himself or somebody else's work. I don't think it should be on a slide. 55. I think it's accurate. I think it's proper testimony. I don't think it's proper for a slide. Same with 56. I don't know that he has the basis for number 1. Number 2, I don't have a problem with on slide 56. And number 3, again, it's bolstering his opinion. So I think 1 and 3 are proper too. Not. Slide 58. I don't know what the basis for number 1 is. I suppose we'll have to see. If these are Dr. Rentschler's views, I don't know how they're relevant to the Commonwealth's case, but certainly I think he has the experience to make these conclusions, but it shouldn't be in a PowerPoint. He shouldn't be commenting on the reports of another expert in a PowerPoint, number 3.
It's just insane. I mean, I've never seen.
And number 4 is
That's what
ultimately an opinion that he's self-endorsing. 66.
I feel like even in the last trial,
Again,
they
it
were
is an
allowed to do
opinion.
that.
I don't think it's an admissible opinion, and it shouldn't be in a slide. He's trying to draw a conclusion on what the jury should conclude based on the Commonwealth's evidence. He's not in a position to do that. 67. Parts of this are objectionable. I think that he certainly could testify. He hasn't seen any simulation by Dr. Welcher, but posturing it about in a manner that suggests there should be doubt in some way is inappropriate. 68, I don't think Dr. Welcher's report was introduced, and putting in a fraction of a report, I can't appreciate the significance of it. It's hearsay. Perhaps there's a reason he'll be able to point to the report or talk about the report. I understand that, but putting in a random page from a report is hearsay. Should not be admissible. I don't know if there's going to be a conversation about trying to introduce the entire report, but one page will take it out of context. 72.
Remember when Jackson was like, I just want to read these 5 lines, and she's like, no, nope, it's on the record already. You know?
I think the expert I think the expert has a basis for the opinion. I don't think ultimate opinion should be in PowerPoint because it's self-endorsing. 74. Again, it's a conclusory opinion. It's bolstering.
I'm speeding him up because it's just insane.
Some of these can be said, but shouldn't be in PowerPoints. Same thing with 75 and 76. They're ultimate conclusions. And so I'm not in agreement with all of the conclusions that the expert may try to introduce, but testifying about ultimate opinion and putting it on the board to self-endorse shouldn't be permitted. And those are my objections.
Okay. Ms. Little?
Thank you, Your Honor. First of all, there tell me if I stand here only because I would be able to reference the PowerPoint.
Yeah, that's fine.
Thank you, I appreciate that. First of all, there were no additions, just to be clear, to the PowerPoint. The only changes that we made were directly in response to the objections that are filed by the Commonwealth. We did delete the large section, try to accommodate some of their concerns, as well as shorten some of the opinions and conclusions. So those were the only changes. I just wanted to be clear before. There are no additional opinions that have been set forth in the PowerPoint. With regards to slides 9 through 27, that was not one of the issues that was identified in the Commonwealth's motion. They ended up with slide 9. There's half of those slides are not referenced to.
I do agree. It's a new objection. I just don't know when there's an objection raised how a biomechanical engineer is qualified to testify to tears and clothing.
So this is a his testimony is going to be based on knowledge of forces and forces applied to certain objects and how that results in injury.
And I understand that, but some of the specifics that he says, I'm just saying I had a concern, so I understand it's new.
Be able to satisfy the court's concern by laying proper foundation.
All right, so we can come back to the fabric argument or whether it's beyond his.
And she's like, I have the concern. And her concern's the same as the Commonwealth. How come she's never concerned with the same concern as the defense?
Scope of expertise.
I mean, we know why.
But actually, Ms. Little, if I can just ask you, and I can hear you later, as I assume everybody wants lunch and we're coming back in at about 20 of, quarter of at the latest. Can you just explain to me why these slides, if Dr. RENTSCHLER is permitted to express these opinions, why we also need them on slides? That's the problem I have.
I think that's a great question, Your Honor. And the reason we didn't put these on slides is because we objected to Dr. Welcher's having on his PowerPoint.
So I looked at that yesterday.
A copy of the specific opinion that was placed up on the screen with regard to his opinions and conclusions. That was done over the defense's objection.
So which one? Because I did look last night at that and did not see it.
It's slide 136, Your Honor. The totality of the evidence.
Hold on 1 second. Is it a conclusion page?
I don't know. I just-
Hold on.
But it's page 136. It's entitled Evidence Reflexes in front of you. And it states the totality of the evidence is consistent with the right rear corner of the base 121 Lexus in front of the and this Cherokee, striking the rear posterior aspect of his head on the first ground.
Okay.
So if he's allowed to do that in the front,
So that is different than what I said he could be asked on his ultimate question, right? But it still came in? Was there, I'm sorry?
yes, that came under the defense.
All right. Because what I did note is that I was very careful to say exactly what the ultimate question could be from Mr. Brennan. In fact, there were objections. I sustained them twice. So I wrote out exactly what could be said. And Mr. Brennan asked a variation of the first one, and there was no objection. So I didn't remember that this came in. All right. So I will take a look at that. What I would like to do in the interest of time, so maybe we can talk about that in the conclusion page, but where he outlines everything else, there's so many pages with text that I may not have a problem with testimony regarding this, but why do we need testimony and text so much here?
This is just a scenario. That's
It's what?
just a scenario. There is a significant amount of information needs to be relayed.
Okay.
This is an 80-page PowerPoint. This is solely to make sure that this goes efficiently and effectively. I think it's helpful. We've narrowed down the text on the slides significantly as the court can see for those PowerPoints.
Okay.
Just to the major issues. I think we've streamlined this a lot, but I think having the PowerPoint will allow us to make this go smoothly and quickly.
All right, so I will look at these. What I'll try and do is if there are any changes in the first 15, I'll try and get those done during lunch, and then we can have this argument afterwards.
Thank you, I appreciate that.
All right. All right, we'll see everybody no later than quarter of.
Okay, lunchtime. Okay, let's see what she says. Where'd my mouse go? There it is. Okay.
Second session, may be seated.
All right, the jury is coming over. I just wanted to tell you what I was able to do during the lunch break. So, Mr. Brennan, you argued for 4 points of admission regarding this witness. I'll allow in 1 and 2. I've had a chance to look at 4. I think I already told you I would not allow in 3 because I've already considered it. I've now looked at the 4th one, the case. I'm not going to let you get into that during cross-examination. If the door is open and you think you can get into it after redirect, please come to sidebar.
Thank you.
All right, and also I had a chance to look at the actual exhibit regarding what came into evidence from Dr. Welcher and Ms. Little. Contrary to what you said and what Mr. Alessi was nodding to, page 136 did not come into evidence. It's a blank page. So that PowerPoint did not come in. I had a chance to look at Dr. RENTSCHLER's PowerPoint, and at least for now, maybe you can persuade me otherwise. Any text that has hearsay on it that you say will help assist the jury, what I want to say is I think we have to give the jury some credit here, okay? They have been listening to this case intently for weeks. I don't find that anything that you've recommended here comes in to assist the jury is necessary to assist the jury. So before Dr. RENTSCHLER testifies, those slides that were objected to that have text are out.
Can I have a moment to examine Dr. Welcher's PowerPoint?
No, not right now. You can look at it, yes. You can look at it while we're bringing the jury in.
Sorry, because we have 4 copies of the PowerPoint, and I know that I'd like to be able to. 137 is the report.
Mr. Alessi, please. (136), 137, and 138 are all blacked out. All right, are the jurors on their way, right?
What do you think she eats for lunch? Gravel sandwiches?
Good afternoon, Dr. Laposata.
Good afternoon.
Am I on point now?
You are.
You were asked on direct examination about your qualifications. You were a medical examiner for the state of Rhode Island, is that fair to say?
Yes, I was the chief medical examiner.
For 20 years?
12 years.
I'm sorry, 12 years. When's the last time you worked as a medical examiner?
In 2005.
When's the last time that you conducted an autopsy?
I've done probably a handful of autopsies, private autopsies in my consulting practice.
Since 2005?
Correct.
When do you think the last time you did one is?
Maybe 4 years ago, four or 5 years ago.
4 or 5 years ago?
Yes.
Okay. Since you left the medical examiner's office, have you had any specialized training in brain injuries?
It's all part of keeping up with the medical literature and knowing the forensic pathology literature, reading medical literature. So it's a continuing endeavor to keep yourself educated with medical updates.
The thing is, in order to keep your license and whatnot, right? Board certified, board certificate, you have to continue your education. You got, they know that.
Yes.
Since you left the medical examiner's office, have you had any specialized training in brain injuries?
I've not gone to a course on brain injuries.
Since you left the medical examiner's office, have you taught any students on brain injuries?
Yes.
Have you given any classes or seminars on brain injuries?
Yes, I have.
In coup counter coup, how many times have you experienced that as a medical examiner, that condition?
Well, I myself haven't experienced it, which was good. But in cases, hundreds of cases, it's a common injury.
You said you did differential diagnosis. That is to exhaust any potential bias you have, correct?
Well, a differential diagnosis is to think, how many ways can you get this finding? And it does help prevent bias.
Did you say on direct examination part of the benefit of differential diagnosis is to make sure that you don't have a bias?
Yes, yes.
In order to eliminate bias, you're supposed to look at all reasonable alternatives, correct?
Yes, that's part of it, making a differential diagnosis.
So you don't
Reasonable, Breenan, reasonable.
just look at a person's body, come to a
If I
conclusion.
were him, I would be careful, right? Because if he keeps going down this, he's getting her permission to say that the theory that she was hit or that he was hit by a car is not reasonable. I mean, again, right?
And ignore other evidence, that would kind of defeat the purpose of differential diagnosis, wouldn't it?
Well, you always have to look at all the evidence.
And so if you didn't look at all the evidence and you disregarded some of the evidence because you had already made up your mind, that really wouldn't be the proper study of differential diagnosis, would it?
Right, I don't do that.
I'm sorry, ma'am.
I don't do that. I always look at all the evidence.
And would you look at all the evidence even if it was contrary to whatever opinion you want to give in court?
Well, the evidence allows me to come to an opinion. So it's not like I decide on some opinion I want to give and then look for the evidence. The evidence is going to tell me what happened to the body.
So you would never say, like, I don't need to look at that evidence. If it's presented to you, you'd look at it and study it and consider it in differential diagnosis?
Sure, it may or may not apply, but I'd look at it.
Because if you did that and said, well, I don't need to look at this, and it was relevant evidence, that would defeat the whole idea of differential diagnosis, correct?
Well, you always want to look at all the evidence that's going to help you decide what happened to the body.
If you were to ignore relevant evidence because you already made your mind up, that could create some type of bias, even if
well-
you're not recognizing it, correct?
Well, I don't make my mind up. I make it up on all the evidence I have. Then if something else other evidence comes up later, I have to reevaluate everything and consider that new evidence.
When you were talking about car collisions, I don't want to belabor the point, but you didn't major in physics, did you?
In what?
You didn't major in physics, did you?
No, I took physics, but no, didn't major in it.
And the last time you took physics was probably...
So stupid. I mean, the good news is, right? Like, look, think about Welcher. Think about what's his fucking face, Shannon Burgess, right? Like, there's no question. If you're a forensic pathologist of the caliber that she is, there's really nothing anybody can do to try to make it seem like you should be an expert in whatever the fuck else, like astronauting or basket weaving, right? Like, you do forensic pathology, that's what you do. I mean, but yeah, he still tries, I guess.
What, undergrad?
Correct. Thank goodness.
You have no study in biomechanical engineering?
No, I'm not a biomechanical engineer.
Understood. You never taught courses in accident reconstruction, have you?
Only in terms of looking at the injuries on the body and showing how that they could or could not have occurred from impact with a motor vehicle.
Have you taught classes in accident reconstruction?
Only as far as it would affect the findings on the body.
Do you know what I mean by when I say accident reconstruction?
Well, accident reconstruction meaning, and I'm telling you that my expertise in accident reconstruction is restricted to looking at the body and then understanding how impacts may or may not have occurred to the body. I don't take a car.
Isn't this one of the things he said he didn't want her to testify about? I mean, I remember this when he was trying to keep her testimony out. One of the things he kept saying over and over and over again is she's not an accident reconstructionist. And I kept saying, this is so dumb. She's not saying she's an accident reconstructionist. He's doing that thing again. This is, dude. It's like, don't let this in. Don't let this in. They can't do this. They can't do that. And then it's like the witness gets on the stand and it's like, Mr. or Mrs. So-and-so, and then asks them that exact thing. It's just, I don't know anymore. Ugh.
And look at mileage and such like that.
You don't do any studies of the actual vehicles, you're focused on the body?
I'm focused on the body, but I also look at the vehicles to look at the points of impact that might be possible.
You do not have any advanced study in biomechanics, do you?
No.
Now, you had mentioned that when you were in the medical examiner's office, you had a number of higher profile cases.
Well, every case is important because somebody's dead.
You pointed out some pretty specific ones on direct examination. Were those more important, the ones that were highlighted, or is that the same as every other case?
I don't know what you're talking about.
Well, you had mentioned the Egypt airline crash, station
Oh.
nightclub fire. Those were highlighted or pronounced on direct examination. Are they equally important as every other case?
Oh, absolutely. Every person is my patient.
You talked about some of your commendations. The station nightclub fire, you received quite a bit of criticism on that, didn't you?
Well, there was a flurry of negative press without any basis.
You had mentioned that a doctor, a medical examiner, should have gone out to the scene to look at the area where John O'Keefe was found to make observations. Did you suggest that in any way on direct examination?
You have to know what the scene looks like, and usually that is documented in police reports and in police photographs who document the scene.
The station.
So let me just, so he said, you said, like what Breenan said. He was like, you said that you have to go to the scene. She's like, that's not what I said. What I said was, you need to document, law enforcement needs to document the scene. Great answer, because it wasn't done. It's like, not only is like she correcting Breenan for misstating her testimony, but it's just another little tick, tick, tick for the Bowden defense, you know, and the improper investigation and whatnot.
Nightclub fire, that had numerous victims, didn't it?
Yes, 100.
What is-
And did you receive criticism because you were repeatedly requested by emergency responders and police officials to come to the scene, and you refused?
That's incorrect. First of
Okay.
all, nobody called me to come to the scene, and medical examiners are not first responders. As soon as I got a call that there was that fire in the nightclub, my investigator went right to the scene, and I was in constant communication with him throughout the early morning hours of that horrible accident. And I went into the medical examiner's office because I had to start getting ready to run our office 24 hours a day to not only take care of the poor individuals who expired in the nightclub fire, but also the regular work of the medical examiners. So there was no need for me to go to the scene because I had my investigator there, and my job would be at the office to get things all set up to handle the influx of deceased.
Did you receive criticism that over 17 hours there was an effort to have you come to the scene, but you refused?
There was,
I'm going to allow it in a different way.
that's incorrect. Oh, I'm sorry.
Oh, no, I didn't mean to scare you. Just-
Oh.
I will say that sounds like a media narrative, and here's why. I have never, ever, ever heard of a forensic pathologist that goes to the scene of the death or a crime. Like, that's not a thing that they do. So to have like the way that comment came out from Breenan sounds like a media narrative because it's an expectation that doesn't make any type of fucking sense. But also something funny happens here, so let's see what this is.
Not only take care of the poor individuals who expired in the nightclub fire, but also the regular work of the medical examiners. So there was no need for me to go to the scene because I had my investigator there, and my job would be at the office to get things all set up to handle the influx of deceased.
Did you receive criticism that over 17 hours there was an effort to have you come to the scene, but you refused?
There was,
I'm going to allow it in a different way.
that's incorrect. Oh, I'm sorry.
Oh, no, I didn't mean to scare you. Just-
Oh. Okay.
Aw.
Okay.
Asking differently, Mr. Brennan, please.
Did you receive criticism that officials?
I'm going to allow it based on the ending, pursuant to the ending. Let's hear it.
Did you receive criticism that for over 17 hours officials were asking you to come to the scene and you refused?
It was untrue. It was printed in the newspaper. We looked up all the phone records and provided it to the newspapers and showed that nobody called me to go. I would have gone if I needed to. I had my investigator there. It was just bullshit. No, it was erroneous.
Oh shit, did she say bullshit? No way.
We looked up all the phone records and provided it to the newspapers and showed that nobody called me to go. I would have gone if I needed to. I had my investigator there. It was just bullshit. No, it was erroneous stuff.
She said bullshit. Hold on.
Was there other
Hold on. Did
criticisms?
that happen? How come I'm surprised there wasn't a laugh? Hold on. Did she say bullshit? Oh my god. I mean, warranted, right? Hang on.
It was just bullshit. No, it was.
Oh, I'm surprised I didn't get a laugh. I mean, maybe everyone's afraid that Judge Bev's gonna just like eat them alive, you know, turn their brains into cottage cheese tofu and whatever. Wow. Right? I know. It's like she wanted to pretend like it was you know what I mean? She did that thing. Like she wanted to say bullshit, but she also knows like you're not supposed to in court, but like it was really important to her, like that's the accurate way to describe it type of thing. You know what I mean?
Erroneous stuff.
Was there other criticisms in 2005 before you left the office?
There was a flurry of stuff in the papers. There were union issues, new director of health, new governor. So there was a little flurry of stuff, which was not substantive.
So you inevitably did resign in 2005.
Yes, because my budget was going to be cut, and I knew that if I had to get rid of a medical examiner, we couldn't do a good job for the state, and I'd done it. I'd been chief for 12 years. I'd been on call 24 hours a day for 12 years, which was an honor, really. But then if I couldn't do a good job, if we cut
Can
the
you
budget...
imagine being on call for 24 hours a day for 12 years? How is she even sane? Twiz says, I like this lady now. You didn't like her before? What's wrong with you?
I had to get rid of a medical examiner. I couldn't serve the people of Rhode Island well, so I resigned.
Did you resign shortly after the audits and criticism?
No.
Same year?
Oh, I don't even remember.
After you resigned, you opened your own company?
I love it.
Yes, I started an independent consulting practice.
How much of your business is consulting?
It's a consulting practice.
Yep. How much of your business, how much of your income is
100%.
consulting?
It's consulting.
Do you consult in both criminal and civil cases?
Yes, I do.
What percentage of cases are criminal cases?
It's maybe half and half.
Half criminal, half civil?
I don't keep track of it in that way, but that would be a guess.
I'm sorry, I didn't hear you.
I don't keep track of numbers of civil or criminal cases that I'm consulted in. If I had to give an estimate, it would be half and half. I've worked on over 1,000 cases in my private company.
And fair to say you get compensated for your time.
Yes, I get paid for my time.
Dr. Laposata, you had mentioned that there were some scratches that you had taken a look at on Mr. O'Keefe's body. If we could have Exhibit 165, please.
Boy.
Now, would it be fair to say, Dr. Laposata, you do not know the genesis of that cut on Mr. O'Keefe's right eye?
I do not know what caused it. I can tell you what didn't cause it, but I don't know what did cause it.
You said that was from blunt force?
It's from application of blunt force to that little area that broke the skin.
When you were asked a question about whether that was consistent with a punch, you opined that it was consistent with a punch, yes?
It could be consistent with a punch.
You weren't saying it was consistent with a punch to a reasonable degree of medical certainty, were you?
That would be within my differential diagnosis.
It could be consistent with all other types of blunt impact, or many other types of blunt impact, couldn't it?
That's correct.
Ground, perhaps?
No.
No, an object?
If it was an object that could get into that area under the eyebrow, yes.
You mentioned the spoiler on the back of Miss Reed's Lexus. Do you remember that?
I remember that.
Do you know how tall John O'Keefe was?
He's around 7 foot, 5'11", I think, 7'2", something around in there.
No, he's more closer to 6'1". Does that make sense?
Sure.
Okay. And that spoiler on the Lexus, do you know how high off the ground that is?
No.
Did you ever try to measure it or ask for photos or any information about that?
No, I looked at the photos.
Did you ever ask for any measurements or try to take any measurements?
No.
Could I have Exhibit 166, please? Did you see this cut on Mr. O'Keefe's nose?
That's a scratch. It's not made by a sharp instrument. It's not a cut. It's a scratch.
Is there any scratches on the left side? Do we have a photo of the left side, please? And that, you say that's a scratch, not a cut?
Correct. Because a cut means it's made by a sharp thing, like a knife, and a scratch is made by something that's kind of rounded that has a little point on it, but it's not sharp.
Okay. Do you have any information or basis to say where that scratch came from?
No.
Did you do any differential diagnosis on that scratch?
I don't know what caused that. There could be a number of things that caused it.
There was no scratch on the right side of Mr. O'Keefe's nose?
I don't see it one, no.
Could you zoom in, Ms. Gilman? So the only scratch was on the left side?
Looks to be, that's not a good photograph because there's some blood obscuring the skin.
Yes.
If my memory serves me, there was a scratch on the left side of the nose and maybe a small scrape on the tip of the nose.
And we can go back to the left side? And you said that could not have been caused by a sharp object?
Correct. It's not an incised wound. Incised wound means a bladed sharp cut. This is a scratch, not made by a blade.
Were you aware the defendant made a statement that she pulled a piece of glass from the defendant's nose?
No.
And you would say that that wound is inconsistent with being caused by glass or a sharp object?
It would not be caused by a blade. It could be caused by a piece of glass that was thick.
I thought before I offered you that statement, you had said that it could not have been caused by glass. Do you now have a different opinion?
I don't remember saying it couldn't have been caused by glass.
Didn't you say it couldn't have been caused by glass or a sharp object?
A sharp object.
What
Like a sharp object, like it's not an
Take that down,
incised wound made by a blade. It could be caused by something sharper that's thicker, but does not have a thin blade. So it could be caused by a thicker piece of glass.
If somebody is deceased, does any blood pressure from their heart still move in their body?
No, they're dead.
If somebody removed a sharp object like glass from somebody's face, would they spurt blood if they've died?
If you're dead, there's no blood pressure.
Oh my God.
So if you're dead and you remove something, there may be some superficial blood, but it's not going to have blood flow because your heart's not pumping blood out of the cut ends of the blood vessels.
So it's not going to spurt if you pull something out of a person's skin if they've passed.
You wouldn't get a spurt of blood from arterial pressure.
I just want to ask you a very few questions about
As
hypothermia.
far as that goes, that's from that. The only thing about that where Breenan's getting that from is the Karen Reed, the one interview clip. The first time I heard that, I just discount it. I mean, I just discount it. It's like she's told that story about finding John O'Keefe a million times on all these different interviews, and she only says that one time. But the other thing is this: as we know, it was dark. She was traumatized. I mean, the whole thing. It's like, so between her memory of something like that, that could have been whatever. It could have been her mind trying to hope that he was still alive, so she thought she saw that. You know what I mean? Anything. Versus what all of the science suggests. I go with the science, but of course, Breenan goes with Karen Reed one time said something about the glass, which there was no glass found on him. So like the evidence refutes what she says in those interviews, right? For that type of thing. So
Yeah.
Sure.
You mentioned that Mr. O'Keefe's body temperature at the hospital was 80 degrees.
Yes.
And there's different ways to take somebody's or body's temperature, isn't there?
Yeah, that was a rectal temperature, so that's a good
oh, please, can we talk about armpit temperatures?
representation of the body temperature.
Is the variance between a common practice of taking temperature and by somebody's mouth and rectal, is it about a 3 or 4 degrees difference, or do you have a different experience?
It can be different. A rectal temperature
Remember,
gives you
corner armpit says that thermometers are not accurate. So
a better internal body temperature. The oral temperature, if you're breathing in or if you just had something cold in your mouth, may not register a proper temperature. So the rectal temperature is the preferred temperature for a medical diagnosis.
98.6 is an important temperature, isn't it?
Yeah, it's our usual normal body temperature.
And so, is there a standard? Is 95 degrees considered hypothermic?
If you have, then clinically you would start to worry that the person might be experiencing bad effects of hypothermia.
At 95 degrees?
At 95, you start to worry about it.
And could some of the things that happen is labored breathing?
fair question.
Is what?
Labored breathing?
What about labored breathing?
Well, if someone is hypothermic, they're 95 degrees, does it affect their breathing patterns?
Not especially.
Okay. Does it affect the way their respiratory system works?
No.
Does it have any effects on the human body if you're hypothermic at 95 degrees?
No. You're still okay.
If that temperature continues to decline, it starts to become dangerous, doesn't it?
Who else
Okay.
is hearing this and just thinking about how much you hate in Titanic, how freaking Jack didn't get on the door when there's plenty of room for two? Ugh.
Mr. O'Keefe was evaluated, and at the hospital, his body temperature from a rectal reading was 80 degrees at about, 6:37?
Correct.
Did you know that before he got to the hospital, first responders had him in an ambulance?
Of course.
Did you know they turned the heat up and put blankets on him and tried to provide warmth to him before he got to the hospital?
Yes, that would be standard practice.
And that standard practice would usually add temperature to the person, wouldn't it?
Well, it might.
So it's possible it could, but it might not.
It usually doesn't add that much.
I see. And so inevitably, at 6:37, Mr. O'Keefe's body was 80
Breenan, you are going to make us all jump off cliffs.
degrees.
Yes, when he got to the hospital, his rectal temperature was 80 degrees.
And so that is a drop from the standard, or what's expected of 98.6 degrees. That's a drop of at least 18.6 degrees.
Yes.
You mentioned that Mr. O'Keefe, after suffering his head injury, would not have moved other than twitching.
Correct. No purposeful movement.
Were you aware that he had an iPhone with healthcare data on it?
No.
If there's no movement, assume for a second there's no movement of Mr. O'Keefe after 12:32:16, and he's found a little after 6 a.m. in the morning, that's about 5 hours, or 5.5 hours, correct?
About.
And if somebody is in the cold for 5.5 hours, that's consistent with dropping from 98.6 degrees to 80 degrees in body temperature, isn't it?
If the person is dead, yes.
If a person is outside in the cold and still alive, will their body temperature decrease?
If they can, people can die of hypothermia, but that's not the case here.
Not the ultimate death,
Amazing.
but if somebody's outside and they're alive and they're lying in the snow and it's below freezing, will they lose body temperature?
They will, especially if they're not bundled up well
And body temperature can drop from 2.5 to 4 degrees an hour?
in a dead body.
Okay. In a living person, it can drop 1.5 degrees.
No. A dead body at room temperature will usually lose body temperature at like 1.5 degrees an hour. If a dead body is in a cold environment covered with snow in avalanche environments, the dead body can cool at 4 degrees per hour.
And so a person who is in cold conditions, starting to be covered by snow, less than freezing, they can lose body temperature when they're living, can't they?
If you're sure, you can. People die of hypothermia, but that's not the case here.
Well, someone could be alive.
Amazing, just like the car thing. I love how much she corrects him, but it's not in a way that anybody could find offensive. It's so good.
A cold environment covered with snow in avalanche environments, the dead body can cool at 4 degrees per hour.
And so a person who is in cold conditions, starting to be covered by snow, less than freezing, they can lose body temperature when they're living, can't they?
If you're sure, you can. People die of hypothermia, but that's not the case here.
Well, someone could be alive, lose body temperature, and not die. That can happen, can't it?
Yeah.
So if someone is in the cold, let's assume they're not dead for a second. They're in
right.
the snow, below
God,
freezing,
her face, dude, amazing.
temperature when they're living, can't they?
If you're sure, you can. People die of hypothermia, but that's not the case here.
Well, someone could be alive, lose body temperature, and not die. That can happen, can't it?
Yeah.
So if someone is in the cold,
She's like, are you okay in the head? Because what type of questions are these?
assume they're not dead for a second. They're in the
right.
snow, below freezing, not moving. Can that person lose body temperature if they're still alive?
Sure. They just lie there. They can become hypothermic and die.
Even before they become hypothermic, can they lose body temperature?
Well, losing body temperature makes you hypothermic. Thermic is temperature and hypo means below. So your temperature goes down and you're hypothermic because it's going down.
And people can survive from being hypothermic if they get the right care.
Sure.
And so in that 5.5 hours, it is consistent with a person being outside in the cold and starting at 98.6 and ending at 80. That's consistent with being in the cold for 5.5 hours, isn't it?
For a dead body, yes. That's how a dead body would cool in a snow-covered cold environment.
And it could
I
also,
just have to say, I hope that when Judd Welcher, if they still call him for rebuttal, I hope he dressed up. I hope in the next round he's dressed up like John O'Keefe, but also he's given himself hypothermia just so he can really get in the character.
be consistent with somebody who is alive for some time and then dies, correct?
I don't understand your question.
Somebody could be out in the cold.
Disease, that also struck me as well. The way he goes, if they just lay there, it's just like. I literally thought that was I was thinking the same thing. I'm just like picturing, it's like, are you just talking about somebody just laying there? And then like, I just can't.
The snow, sub-freezing, they could be alive for some time, their body temperature could drop. And then when they pass and die, their body temperature could continue to drop probably at a more rapid pace. That still fits within
No.
5.5 hours, doesn't it, Dr. Laposata?
No.
Okay. Because if someone can drop 4 degrees of body temperature in an hour,
A dead body.
yes, it would only take about a little over 4 hours if it was at 4 degrees to go from 98.6 to 80. Yes?
Correct, yes. So he was exposed to that cold environment for 4 to 5 hours.
If somebody was alive for a couple of hours, it's a lower rate. Say they lose 3 degrees. And then, after that couple hours, they lose body temperature at 4 degrees. That would still fit and be consistent with a drop from 98.6 to 30 degrees,
No.
to 80 degrees, wouldn't it?
No, you were saying a dead body cools in a cold environment at maybe 3 to 4 degrees an hour. And that has nothing to do with a living body and how long they can stay at a body temperature.
Do you disagree that somebody could be alive, lose body temperature out in the cold, freezing temperature below 32? They could lose body temperature at a certain rate, then pass, die, and then continue to lose body temperature. Is that possible?
Anything's possible.
What is happening? Is he just like, I feel like he's forgotten there's a jury there, and I think he's completely lost the point a long time ago. This is just crazy.
It's just what's important is what happened in this case.
I'm asking for your medical opinion, though, rather than to be an advocate. As far as your medical opinion,
So sustained, and I'll strike that.
as far as
Dr.
your,
Laposata,
Yes.
would you listen to the question, please?
Of course, thank you, Your Honor.
as far as your medical experience, could somebody be alive, outside, in the cold, below 32 degrees, not moving, covered by snow, still alive, and lose body temperature?
Sure.
And then could they, after an hour, 2 hours, could they then die and continue to lose more body temperature?
Sure.
What is that for?
You mentioned your opinion about injury on Mr. O'Keefe. And at one point you said that
Oh, so we started it over because we're on a new goal for the other story. So I started it back over at 0, but this time we got to get to 20 for the big goal.
his injury was inconsistent with a taillight.
New counter.
And you said because there was no damage from the bumper. you remember saying that?
I don't think I said it quite that way.
Okay. Do you remember how you said it?
No.
Do you remember discussing or raising the issue of a bumper as part of your equation, that the injury to Mr. O'Keefe was inconsistent with the injuries?
He has no injuries on him that are consistent with being hit by the back of the SUV. That includes the spoiler
I
that
want to hear this part again. I will just note that the reason why we haven't had that many objections being sustained is because since I reset the goal, we've been on cross exam, which means Breenan's doing the questioning, right? As we all well know, if the defense was doing the questioning, we would have reached the sustained objections goal a long ass time ago.
Injury on Mr. O'Keefe. And at one point you said that his injury was inconsistent with a taillight, and you said because there was no damage from the bumper. Do you remember saying that?
I don't think I said it quite that way.
Okay.
Probably
Do you remember
not.
how you said it?
No.
Do you remember discussing or raising the issue of a bumper as part of your equation, that the injury to Mr. O'Keefe was inconsistent with the injuries?
He has no injuries on him that are consistent with being hit by the back of the SUV. That includes the spoiler, that includes the bumper.
If we could play video E, please. I want to ask you, Dr. Laposata, have you seen this video before?
No.
Randy! No! Only got harness could have saved him.
Thank you. You can take that down. Did you see anything in that video that would suggest any contact between that mannequin and the vehicle's bumper?
Objection.
I'm going to see your sidebar on this for just a minute, please.
I mean, she just said, anyway, whatever. He's still either going sidebar. He looks like someone just tore an ACL. I know, right?
All right, so jurors, I am going to strike the last bit of questioning of this witness and the video as it goes to this witness. All right.
Oh, that sounds like a sustained objection.
Dr. Laposata, after you received materials, did you ever ask for any additional materials?
Right. So the reason it's being stricken is because she has never seen it, right? If they haven't reviewed the shit, they can't talk about it.
Let's see. I always make sure I have all the scene investigation, autopsy, medical records, police and witness investigation, and witness statements. So I felt I had a pretty complete database. I didn't get the x-rays until a couple weeks ago, so that was delayed.
That was newer?
Yes.
You said a medical examiner has to make a determination in 90 days. Is that the rule?
When you work in a medical examiner's office, when you get a deceased in, our national standards want us to have the autopsy report completed and all the associated tests done within 90 days.
Can investigations occur and the additional accumulation of evidence happen after that 90 days?
Oh, sure.
Thank you, Dr. Laposata.
It's so funny because it's on the shoulder too, right? It's so fucking funny. Okay, let me hear this last. I was laughing. Let me just hear this last one.
Standards want us to have the autopsy report completed and all the associated tests done within 90 days.
Can investigations occur and the additional accumulation of evidence happen after that 90 days?
Oh, sure.
Thank you, Dr. Laposata.
Redirect. I love the confirmation,
Yes.
right?
Dr.
Okay,
Laposata,
hold on one second. Jurors, when I strike something, that means disregard it. And what I've struck through this witness, the video that you just saw and some of the testimony means that if it's in evidence, it's in evidence, but it is not part of your consideration with this witness. Okay. All right, go ahead, Mr. Jackson.
may I proceed? Thank you. Dr. Laposata, you were just asked a series of questions about a body cooling, correct?
Yes.
Does a body, as it's cooling, does it know if it's indoors or outdoors?
No.
If there's a very cold environment,
I mean, sad that he's redirecting on these dumbass questions, but you know.
be it indoor or outdoor environment, would it still cool?
Oh, absolutely.
And it would it cool at the rates that you earlier described?
Yes,
Even if indoors, if that indoors was cold?
absolutely.
You know what happened to me the other day, guys? I brought an extra sparkle water to work, and there's like a mini fridge with like a little freezer. And it's not like a freezer, like a big fridge. It's just like, you know, the little mini fridges, and there's like a top compartment that has its own door, but like there's no ice in there, or well, there wasn't. In other words, I figured it was like exactly the same temperature as the rest of the fridge, but that if I put it in there behind the little door, it might get colder a little bit faster, and it was like really hot. So I put my sparkle water in the little freezer thing, which I thought was not going to be a legit freezer. And then I forgot about it. And then I came back today and I went to go, and I was like, oh, I'm out of sparkle water. And I opened the freezer thing. And what had happened was it like exploded. So now there was just like a bunch of like chunky ice in there. And anyway, because basically the point is, you know, Breenan's like, if something gets colder, does it get colder? If something is just lying there, what happens to it? If a tree falls in the forest and nobody hears it, does the chicken still follow the rabbit hole through the egg and over the rainbow? You know? Okay.
Your Honor, maybe approach.
Now they're still listening. I bet she liked that one.
Very briefly.
The frozen sparkle water. That's exactly what it was. It was frozen sparkle water. And I was so sad because I was so thirsty. Oh, they're approaching. Well, it's all, I mean, I can't, the thing is it all came out of the can. Like the aluminum exploded and it was just like a shell of aluminum. And then all of the sparkling, slushy, frozen sparkle water was outside of the can. And it's now still in the freezer. So that's why I said that the freezer didn't have ice, because technically now it has ice. Kind of. Sparkling ice. And through the woods. Thank you, Kit Smiths. Yeah, the lid is supposed to open. Yeah, it was like the entire side. It was like someone sliced it open. It was pretty cool, actually, from a scientific standpoint. It probably would have confused the heck out of Breenan if he'd seen it. He'd be like, what's happening? Did it have hypothermia? Did it have hypothermia? Did its hat fall off? Oh my God, the hat. The way he's been really fixated on the hat recently is one of the new things that is interesting of him. Don't tell them.
May I?
Yes.
Thank you. Dr. Laposata, stand back here for a quick second. Before I sat down the last time, I asked you a little bit about x-rays.
Yes.
And the effect of x-rays on an evaluation by a forensic pathologist. Do you remember that?
Yes.
Are x-rays important for a forensic pathologist to consider?
Yes, they are.
Did you find any, you reviewed the x-rays, correct?
Absolutely.
I'm going to relegate my question to just the right arm of John O'Keefe.
Yes.
Did you find any deformities, defects, breaks, fractures, or hairline fractures of that kind on any of the x-rays that you reviewed?
None.
May I approach on?
Yes, I have a question for you. When you printed these, did you print them from a flash drive?
May I have one more?
Sure.
I have some assistance with this.
Do you have them up on the,
We do have electronic versions of this.
why don't we do that instead of the big, you're objecting to this, Mr. Brennan? A flash drive would be used on them. It's not a flash drive. It's a flash drive.
But I don't have full discussion of the court.
All right, jurors, we're going to make this one really quick.
Oh boy, that's what she said.
I'll show these to you and I'll put them on an overhead. May I approach, Your Honor?
Yes.
Do you recognize this document?
Yes, I do.
How do you recognize it?
I recognize it by the medical examiner identification of Mr. O'Keefe, and I recognize the x-ray of the right hand, the right wrist, the right femur, and I can also tell by the R designation here that that's the right side of the body.
Is this what you reviewed in coming to your opinions and conclusions concerning injuries to his right hand?
Yes.
Thank you.
So these now will mark whatever the next exhibit in A, B, and C.
A, B, and C, yes, Your Honor.
229A.
Marked all.
May I approach?
Yeah.
Yes, this is a x-ray of the body of Mr. O'Keefe from the medical examiner's office. The R indicates the right side, and we see here the two bones of the arm. There's no injury to them. We see the pelvis bone. There's no injury to that bone. They're perfectly normal, and there's no abnormal soft tissue swelling. It's a normal right arm.
Thank you. I mean, it's marked as excellent.
That may obviate the need to clean it up, right?
It could.
Are you put a clock on it down? It's in the Breenan clock.
May I?
Yes.
Thank you. Doctor, do you recognize this document?
Getting more of these into evidence. So we're just going to jump ahead a little bit.
Dr. Laposata, that's all I have for you. Thank you for coming.
Okay,
Anything, Mr. Brennan?
No, thank you.
All right, Dr. Laposata, you are all set.
Thank you, Your Honor.
right, is there anything else today? Yes.
Is there anything else today? You mean like the next witness? What is wrong with her? Literally. Sidebar.
Okay.
Here's the thing. The part that I kept looking for, I don't know how we missed it, right? The part where she rules on, I don't know how we fucking missed it. I have to go back and find it because I know that there's a ruling made on the whole thing with Dr. Laposata, and now she's done. So how the hell? So here's this argument. I'm just wondering if it's a problem with the court TV timestamps, or maybe you remember when y'all said the video was kind of glitching? Maybe it was around that time. Let me see. So this is, hang on. Okay, there's the spicy argument, right? Let's see.
On a photograph about the genesis of a wound related to dog bites. The question was specific to dog bites. That's how he introduced the subject matter to Dr. Russell. Then his next question was, have you ever heard of a doctor named Dr. Laposata? Those were.
I remember all this. They're all on break again. I wonder if they came back and see, I might have gone to the timestamp. I bet that's what it is. So normally, right, guys, with this court TV, when they get these correct, you know, like when the next timestamp is, that's when the next thing. I bet that's why it just sucks when they get it wrong. I bet that's what it is. I bet it happened right here. That would make sense because I remembered her saying, okay, we're going to come back in 10 or whatever. And I was like, oh, look, 10 minutes. Go to the next timestamp. Hold on. I just don't want to miss this. Okay.
I think it's outrageous. I think it's outrageous.
Yep. This is it. We didn't hear this. I mean, it's just a short little snippet, as you guys can see, but this is really important because this is following Jackson's, in my opinion, best argument I think I've ever seen from him. All right.
Your rights are.
Yeah, I don't think.
All right. So I'm not going to allow Dr. Laposata to testify regarding dog bites. Your rights are saved. I'm going to give an instruction regarding burden shifting. So.
Yeah, we did not see this. Okay. Glad I went back. I have thoughts.
So I'm not going to allow Dr. Laposata to testify regarding dog bites. Your rights are saved. I'm going to give an instruction regarding burden shifting.
Okay. Again, shouldn't be surprised, but yet still. Your rights are saved. You know, I know that judges usually say that. It just coming from her, it sounds so patronizing and condescending. And then this part, I'm going to give an instruction about burden shifting. The gall of her to try to say that as if it's a curative instruction. That is not a curative instruction. That's a standard instruction. To give an instruction about burden shifting is no different than saying, you know, I don't know, you can't watch shit outside of the trial. You can't go looking stuff up at home, right? Or like, I don't know, the burden is beyond a reasonable doubt. Or, you know, you can choose to give the expert witnesses or any witness, you know, whatever weight you see fit. I mean, any of the standard jury instructions that are not curative, as you know, a curative instruction is outside of those standard instructions, and it only it's circumstantial, and it happens to cure a certain issue, and it's specific to whatever the thing is that happened. And one way you can tell is because it'll have words in it that are specific to the case. And burden shifting? Are you kidding me? Honestly, this is so offensive to me. I would have preferred her to just say the dumb bullshit she says initially and leave that part out. It's that same thing that she does where she tries to make it seem like, look, I'm being fair to you. I'm giving you things. No, you're not giving things. And it's more insulting to me to try to act like it's gaslighting, dude. I'm going to take a deep breath.
All right.
Maybe have a cough drop.
So I'm not going to allow Dr. Laposata to testify regarding dog bites. Your rights are saved. I'm going to give an instruction regarding burden shifting. So.
Oh my God, I hate her so much. I wish you know, here's what happened. When she went to go put these glasses on.
Regarding burden shifting. So. Hold
on. For a fleeting moment, I was like, I hope she accidentally stabs herself in the eye with those stupid glasses.
I think it's outrageous.
That's right.
That's
right, Heather. Giving me things that are actually already mine. Yep. And listen to oh my God, look at that pause. Listen to Jackson.
I just think it's outrageous. I think the conduct is outrageous. And I don't think that curative instruction can do anything except bring the point home again.
Okay.
But if the court is not willing.
She's like, okay. I mean, he shouldn't be calling it a curative instruction. Don't let her gaslight you. It's not a curative instruction. So don't call it that.
To allow her to testify to her full opinion to immediately do science and service, can she at least testify that she reviewed the arm, looked at the arm that's consistent with an animal? And at least split the baby.
I will do that. I'll allow that. Yes. Over the Commonwealth's objection.
And I'd look to have the cross-examiner, because if you want to allow a consistent opinion with the dog,
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience, seeing animal bites, this is consistent with what she has seen in an animal bite.
And that will include, I'll come to sidebar.
Okay. Okay. So now this all makes a lot more sense. This is, of course, before she testifies again this day. This all makes a lot more sense. I'm never going to trust Court TV's timestamps again. No offense to Court TV. I know they're very busy. Okay. So she can, this is a big deal because here's the thing. She was like, nope, she can't testify. And then Jackson was like, sorry, but this time I'm not sitting back down, right? I mean, at this point, it's like, dude, how, I don't blame him because it's like one thing after another, after another, after another, after another. But here's what's so interesting is she gives him something here, right? She's like, she can say animal bites. I mean, that is a big win. Okay, sorry. The defense shouldn't have to, she should have been able to testify to dog bites, right? Obviously, there's just, however, between like in terms of not being able to testify about the bites at all, right? The animal bites is a huge win for the defense when you compare the two, because the jury, it doesn't matter, right? It doesn't matter if it's an animal bite or a schmanimal bite, right? It's not a tail light bite, right? And the jury knows, at this point, there's no confusion which animal we're talking about here for the jury. So it doesn't even matter, right? Like call it an animal, call it a whatever. The jury knows what you're talking about. So it basically for me, she's essentially correcting this in a way that is definitely, but you know what's so funny? Had he not come back again, interesting. Let's watch this.
With an animal.
Hold on.
Okay. Burden shifting. So
I just think it's outrageous. I think the conduct is outrageous. And I don't think that curative instruction can do anything except bring the point home again.
okay.
But if the court is not willing to allow her to testify to her full opinion to immediately do science and service, can she at least testify that she reviewed the arm, looked at the arm that's consistent with an animal? And at least split the baby.
I will do that. I'll allow that. Yes. Over the Commonwealth's objection.
Really? This is very interesting. I wonder why she's doing this, right? I mean, this is like, it's really interesting because every now and again I hear people say something like that she, when it comes to the really bigger decisions or whatever, she tends to side with the defense. And I'm like, I don't know what trial you're watching. Because a moment like this really stands out to me as incredibly rare. It's like shocking, right? It's like, whoa. I mean, because it's like out of 100 rulings, only one of them typically, right? Let's just say since this trial started. I mean, how many times has she ruled in favor of the defense on a minor issue or a major issue? I can't think of any, especially with something crucial like this. I can't think of anything. I'll tell you how I know, because if it happens, it's surprising. So I wonder what the deal is. How did he get her to,
I just think it's outrageous. I think the conduct is outrageous. And I don't think that curative instruction can do
I mean, maybe the appellate counsel back there, the appellate attorney for the Commonwealth was like making a face like, Bev, this is one you can't do. You gotta give them something. I mean, I don't know, because it's just weird.
except bring the point home again.
Okay.
But if the court is not willing to allow her to testify to her full opinion to immediately do
Like
science and
how,
service,
like if there is a way to get her to like change her mind and be more fair, like we all want to know what that is. And then they want to know what it is, right? It's like, oh wait, what did we do right? You know what I mean?
she at least testify that she reviewed the arm, looked at the arm that's consistent with an animal.
Was it the word outrageous?
And at least split the baby.
I will do that. I'll allow that. Yes. Over the Commonwealth's objection.
Because like her ruling was to not let any of it in. So again, this is a huge ruling that in terms of being good for the defense. I'm just shocked.
Because if you want to allow
From now on, whenever we're talking about, was there ever a time where Bev did something that wasn't insane? Like this will be an example that I can give of like again, it shouldn't have been an issue anyway, right? But considering how she normally rules and what she initially ruled, which is none of it's coming in at all, saying, okay, she can testify about the animal bites. Again, it may as well be dog bites, right? So that's like basically just like changing your mind, you know, in a good way. You could be right about that. Kitsmits.
The dog.
No, Mr. Jackson said animal.
I'll leave it at animal if that's what I can get. I'll take what I can get.
In her experience, Mr. Jackson, you have to lay a foundation. In her experience, seeing animal bites, this is consistent with what she has seen in an animal bite.
Okay, so there we go.
I'll come to sidebar before I display anything. That will include a representation of what an animal jaw looks like.
No, it will not.
Why is that?
That's my ruling, Mr. Jackson.
So no visuals.
No visuals, just that one sentence.
He was
But that's
trying to see what
consistent
else he
with
could
what she
get.
has seen.
I don't blame
It's
him.
an animal bite.
He was trying to see what else he could get because it's like, all right, I'm on a roll.
A brief foundation, because I'm letting that statement in as long as she testifies that she has seen animal bites over the years. That's it, Mr. Brennan. That's what I'm doing. So you don't want an instruction, Mr. Jackson? Okay. All right. So there are two other quick matters, but the jury's been here, and I don't think we'll get past the break without this anyway. I may have left it in there. I left it in my office anyway. So
Good job, Bev.
let's just bring the jurors in and move forward with this. All right, Paul.
Okay, I feel a lot better. So that's what we needed to see. Now we've seen it. Okay, now we're going to go back. Finally, get ready, get excited with your wrenches. Now we're going to get to Dr. Rentschler. Ostensibly the defense's last witness.
Face the clerk and raise your right hand, please.
You so sure you understand the court and jury in case they have words the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Feels good.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Sir, could you please, pull that to you. You're a little on the tall side. Pull that to you
You look younger than last year.
right up under your chin if you can. And in a nice, clear voice, tell the jurors your name and spell your last name for us, please.
Dr. Andrew John Rentschler, RENTSCHLER.
Sir, what do you do for a living?
I'm a biomechanist, a biomechanical engineer, and an accident reconstructionist.
Where do you work?
I work for a company called ARCA LLC.
Tell us a little bit about ARCA. What is ARCA?
ARCA is an engineering consulting firm. So we do litigation type work, both civil and criminal, where we look at, for instance, I do biomechanics. So I look at injury causation in different types of events, motor vehicle accidents, pedestrian, automobile incidents, sports related injuries, industrial accidents. We also do accident reconstruction, as well as all types of really forensic type engineering. And we also do
By the way, Twiz just sent me a picture. I think he's trying to say that that's Heather. I don't know what this came from, but that's definitely not Heather, and that's definitely not the Pitbull Autonomous.
R&D, research and development, for private and governmental entities.
What's your current title?
I'm a vice president and director of biomechanics for the Midwest Division.
The director position that you hold, that's the official position at ARCA?
That's correct, yes, sir.
How are you ARCA's
Have
senior
you seen
biomechanist?
Mr. Heather?
I'm one of them, yes.
And how long have you held the position of director of biomechanics and human factors?
It's been at least 5 years. I don't recall exactly how long.
What exactly does is it biomechanist or biomechanist?
Biomechanist, yeah.
All right, I'll get it right by the time we're finished. What is a biomechanist? What do you do?
No, who won't get it
So
right?
a biomechanist really looks at the human body, and we look at the response of the human body to forces and accelerations. We apply traditional engineering, but to the human body. So a mechanical engineer, for instance, might look at a piece of steel, and you know the dimensions and size of the steel. If you apply a force in a certain direction with a certain magnitude, that steel will bend and eventually it'll break. As a biomechanist or biomechanical engineer, I do the same thing, but I look at the human body. How much force has to be applied in what direction to get a specific type of injury, whether it's a fracture of your humerus, a concussion, intervertebral disc injury, any type of injury has what we call an injury mechanism. So we look at the response of how the body reacts to forces in different environments. Ultimately, our hope is to actually help prevent and mitigate accidents. Motor vehicle incidents, we look at the design of airbags and seatbelts, sporting equipment, how can we reduce concussions and injuries associated with that. So ultimately, we try to figure out how to make the environment and the world safer for people in whatever type of interaction you might have.
Is that sometimes called injury causation analysis?
It is. That's one aspect of it. Injury causation analysis is looking at how an injury occurs. So if someone sustains an injury, as a biomechanist, I can look at the events surrounding that incident and determine how the injury occurred. Now, how someone was positioned, how much force had to have been applied to certain parts of their body to actually produce a given injury.
Why is injury causation analysis important in the broader field of biomechanics? Why do you want to know the causation of certain injuries?
Well, like I just said, our main goal and interest is to really mitigate and prevent injuries from occurring. So in order to do that, you have to know how they occur. You have to know, for instance, hockey, we do a lot of work with the NHL, how certain injuries occur, cervical injuries, concussions, shoulder injuries. So if your intent is to prevent injuries in certain settings and situations, you have to study how the body reacts, how those injuries are created, and then you can determine or attempt to determine how to prevent them from occurring in different events and situations.
What sort of contracts or commissions does ARCA routinely engage in?
How much you want to bet Breenan's going to try to attack the whole NHL thing with him also?
A number of different contracts. We've worked in the past with the United States military. I helped design what we call the energy absorbing seat for the MRAP vehicles.
Hold on one second, Dr.
Sure.
Okay.
For the MRAP, which are the mine-resistant ambush-protected armor-plated vehicles that they had over in Iraq and Afghanistan. And the issue there is that when they go over an IED, an improvised explosive device, it would blow the vehicle up off the ground. So we were seeing very severe accelerations and forces going through the vehicle, through the seat, into the soldier's spines. And we're seeing severe spinal and head injuries as a result of that. So we worked with the military to design what we call an energy-absorbing seat design. As the vehicle gets blasted up off the ground, the seat's designed to absorb that energy and that force from the blast and the movement of the vehicle and help protect the soldier's spine. We also, as I said, do a lot of work with the NHL. We work with the Department of Player Safety there, the National Hockey League. We look at the equipment, we look at helmets, trying to help prevent concussions, skate guards, how to prevent cuts and injuries due to skates. One of the big things we did was actually redesign part of the rink. It used to be at the player area. At the end of the player area was a 90-degree stanchion of plexiglass. And what was happening was players were getting checked into the boards at the player area and then slamming up against the glass. And they were sustaining head and cervical injuries. I've mentioned before, it was actually the Boston and Montreal that caused the NHL to take a look at it, the hit of Chara on Pacioretty. He sustained a concussion and a cervical fracture. So they gave us part of the rink to the Winter Classic, the outdoor contest, and we used crash test dummies, hybrid 3, 50th percentile male dummies, and threw them into different configurations of glass. And ultimately, the new design that we developed is a curved piece of spring-loaded Lexan or plexiglass. So now when the players get checked into the boards, it absorbs that impact and they glance off of it. And it's helped prevent and pretty much mitigate any type of head or neck injuries as a result of player interaction at that part of the rink.
Hockey players tend to be pretty big guys, right?
They do, yes.
You said you used the 50 percentile hybrid 3 as a crash test
Yeah,
dummy in
that's a good
ATD to do your work and further into the NHL contractor commission, correct?
That's correct.
Did you need to use a hybrid 3 that was the same size as these big, tall, 6'4", 230-pound hockey players?
No, not at all.
Why not?
There's a 95th percentile male dummy, which not many people have or use. The 50th percentile male is basically the gold standard for crash test dummies.
Oh, nice.
And you're probably most familiar with it if you see automotive manufacturers and the ads on TV where they put the crash test dummy in the car and run them into walls and flip them over.
Oh my God, I can't wait. I can't wait to see this cross exam because Breenan's going to hate that so much. Dude, this is amazing though.
Well, they use the
I hope he hands it to him.
50th percentile for all of those tests. And then they scale the actual injury assessment reference values to different sized people. So they record the force off of that, and they might say, well, for the 50th percentile average person, you can sustain 180 Gs of acceleration to the head before you see a severe injury. And then they'll scale that and say, well, the hybrid 3 has to record, say, 300 Gs before someone twice that size gets hurt. So you just use one size dummy, and then you scale that to whatever size person you're looking at or you want to actually investigate.
Can we just use Dr. Welcher as the dummy for the rest of the studies from now on?
Is that undertaking of mathematical scaling, is that an industry standard in biomechanics?
Absolutely. And I mean, it's set forth in NHTSA, the National Highway Traffic and Safety Administration. They set, well, the government sets the Federal Motor Vehicle Safety Standards, and that's all the crash tests that vehicles have to go through. And during those tests, they have to ensure that the values on the dummy, on the head, on the neck, on the spine, on the arms are below certain values to ensure that they're safe at specific speeds. And they scale, they have a certain papers, a lot of papers actually, which talk about scaling the values for different size people.
Is that an accepted methodology in the scientific community?
Oh, it certainly is, yes, sir.
Dr. RENTSCHLER, do you specialize in any particular research and analysis at ARCA to evaluate the relationships between crash injuries and crash forces?
I do, yes.
What about kinematics?
Kinematics is one of the specialties, yes, sir.
Fancy word. Probably nobody knows. I didn't know it before I met some of the folks involved in this case. What's kinematics mean?
Kinematics is just motion of the human body. So it's looking at how the body moves in different situations. Whether you're in a vehicle and it hits a wall, how does your body move and moves forward? Will it load into the seatbelt? Does the airbag deploy? Or if you're a pedestrian and you're struck by a car, how does the body move as a result of that interaction? That allows us to look at the loading to the body. Forces are exerted on someone's body because their body's loaded by different objects or different forces. So kinematics is one of the first steps. If you're going to look at injury causation, you have to determine the kinematics of an event.
What are human tolerances?
Human tolerance is really just looking at how much force it takes to cause an injury. So there's been generations of testing to look at different forces. For instance, the humerus, the upper bone in your upper arm. How much force does it take to cause that fracture? They've tested the cadaver bones. There's a lot of research for decades out there looking at different parts of the body, the ulna, the radius, the two bones in your forearm, skull fractures. Almost any type of injury, again, has an injury mechanism. And in order to determine how it occurs, we have to look at tolerance. How much force can the body withstand before you start to see a specific injury occur?
Doctor, how long have you worked at ARCA?
I've been with ARCA now for about 17 and a half years.
How many cases have you been a part of in terms of investigating or conducting crash injury analysis?
Over my whole career, probably thousands of cases. I've been doing this since 2004, so for about 21 years total.
Dr. RENTSCHLER, are you able to estimate how many of those cases that you just talked about, those potentially thousands of cases, have involved motor vehicle pedestrian circumstances?
Oh, I'm sure over the year there's been hundreds of cases. A lot of them are motor vehicle and motor vehicle accidents, but certainly a large percent's automobile pedestrian type impacts.
What education, training, and background qualifies you to perform the duties that you just told us about as the Director of Biomechanics and Human Factors at ARCA?
Well, I got my BS in mechanical engineering with a minor in biomedical engineering from Carnegie Mellon University in 1995. I then went on to get my master's in bioengineering and biomechanics from the University of Pittsburgh in 2002. And then I got my PhD in bioengineering and biomechanics from the University of Pittsburgh in 2004.
2004. Thank you. Are you a member of any professional associations associated with your field?
I'm a member of SAE, the Society of Automotive Engineers, as well as the American Society for Mechanical Engineers, ASME.
Are you also a reviewer for an outfit called Archives of Physical Medicine and Rehabilitation in Biomechanical Engineering?
I have. I've done peer-reviewed articles for those journals before, yes, sir.
When you say peer-reviewed articles, you're the peer reviewer?
That's right. If you want to submit a scientific article to a journal, you'll write that manuscript and then submit it to the journal, and then they'll send it out to other experts or peers in that same field, probably 3 others normally. And then they'll review that transcript, send it back with any suggested revisions, and then usually the author will make changes, send it out again, and that's how it gets accepted. Usually it goes through several different iterations before a paper is actually published.
Have you received any additional training following your PhD, formal training or otherwise, in the field of biomechanics?
I have, yes.
Describe some of that for us, please.
Throughout the years, I've taken classes through the NTSB, National Transportation Safety Board, as well as SAE, as I said, Society of Automotive Engineers, and at different universities, Virginia Tech, different seminars and classes with respect to biomechanics.
Is that normal to, even for someone at your education level, PhD, to take continuing education to stay up on issues in your field?
It is. You take continuing education and then also just working with your peers. And when you work in a certain company, for instance, at ARCA, we don't do just litigation. We do the research and development. We have an epic sports branch at ARCA where we look at sports performance of athletes, how to help them perform better, whether you're a baseball player or volleyball player. So it's really the experience and the work that you do that also helps keep you up to date with technology and the different aspects of that field.
Does some of that additional education include biomechanics of high impact injuries that was offered by the NTSB?
That's correct, yes.
Methodology and techniques of crash data retrieval offered by IPTM?
Correct, yes.
What is the IPTM?
That's the Institute for Police Technology and Management. It's actually a school down in Jacksonville, Florida, that offers basically vehicle crash reconstruction and biomechanical classes.
What about human factors and traffic crash reconstruction, also offered by the same outfit?
Yes.
Did you take a course in automobile safety and injury biomechanics from, is this the one from Virginia Tech?
That's correct, yes.
Okay. Did SAE offer a course in injuries, anatomy, biomechanics, and federal regulations?
Yes, that was in Detroit, I think, where SAE is based.
And you took that seminar as well?
Yes.
What about vehicle accident reconstruction methods offered by the SAE?
I've taken that class before, yes.
Linear momentum analysis offered by CAARS?
That was, yes, in a class out in California.
Motor vehicle accident reconstruction offered by SAE?
I've taken that class as well, yes.
Advanced collision investigations out of California law enforcement?
Yeah, I believe that was a 2-week class I took. That's the introductory class that they give to the Sheriff's Department and police officers out in California.
And what about the post-collision passenger vehicle inspection and seatbelt analysis offered by CARS, CAARS?
I've taken that as well, yes, sir.
Have you published in peer-reviewed articles and book chapters? You said you were a reviewer. Have you actually published yourself along with you and your colleagues?
I have published, and that was mainly when I was in graduate school doing graduate work. I worked at the Human Engineering Research Lab. We helped people with disabilities, so we looked at people in wheelchairs, manual wheelchair users, looked at the forces acting on the arms, how to help reduce injuries, rotator cuff tears.
That's good testimony. I don't know that came out last trial.
Carpal tunnel syndrome, things such as that. So I did publish primarily when I was in graduate school at the University of Pittsburgh.
When you were in graduate school, approximately how many publications did you participate in, either yourself or with colleagues?
Probably 10 or 12 papers, and then some abstracts, and I believe a book chapter as well.
Have you been qualified in other courts to testify as an expert in the area of biomechanics and accident reconstruction?
Yeah,
I have,
be just Judd Welcher and know how to read yet.
Yes.
Approximately how many times?
Oh, I've testified throughout my career probably over 150 times in both state and federal courts throughout the country.
I want to talk to you for a second.
You know what's really funny? I wonder if the attorneys at the firm, I wouldn't be surprised, right? Like, I wonder if either of them have actually used some of these experts that we know from trials. Like, that didn't even dawn on me until now. But, like, it's entirely possible.
Dr. RENTSCHLER, about how you began working on this particular case, the case that's before the bench. When were you initially retained in connection with this case?
We were initially retained, I believe it was for the first trial. It was, I believe, maybe it was the fall.
I would say the cat's out of the bag, but, you know, that ship sailed with the cats a long time ago.
Prior to that actual trial, that was last year.
All right. When you were, by the way, initially, were you hired by the defense?
No, we were not.
Were you hired by the Commonwealth?
We were not, no.
Was that a separate agency that hired you?
It was, yes.
It wasn't an insurance company, was it?
It was not, no, sir.
Okay.
Was
What were
it?
you initially asked to do by the separate entity?
Initially, we were kind of constrained in what we were asked to do and to review, but we were asked to
Was it-
evaluate whether the injuries sustained by Mr. O'Keefe were consistent with being struck by the Lexus.
And who at ARCA was assigned on the team to undertake this commission?
There was myself, Dr. Dan Wolf, and I believe Mr. Scott Klein was another engineer who was involved.
And did all three of you join in the analysis that ultimately ended up in a report that you authored, or the three of you authored together?
We did, yes, sir.
What materials did you review in furtherance of your initial consultation in this matter?
Obviously, I looked at the medical records. We looked at photographs of the vehicles, information about the vehicle, photographs of the actual incident scene, various information pertaining to the Lexus itself.
You know who Dr. Dan Wolf is?
I do, yes.
Is that the other person, the Dan Wolf, the Dr. Wolf that you just mentioned?
That's correct, yes.
Did you and Dr. Wolf look at basically the same set of information? You were provided the same set of information?
We did, yes. We were provided a tranche of information that all three of us looked at, yes.
Can you explain the difference between your area of expertise and Dr. Wolf's area of expertise? I want you to get into his analysis, just what area he covers. In other words, you're dealing with a Lexus and pedestrian, correct?
Correct, yes.
What's the difference between the analysis that you undertook and the responsibilities of Dr. Dan Wolf?
So Dr. Wolf really concentrated looking at the vehicle itself and the damage to the vehicle, the damage to the taillight, which is really the only damage we have to that vehicle. And so his analysis pertained to evaluating the force associated with producing that damage, what's consistent with causing that type of fracture and damage to the taillight itself. Whereas my part of the investigation was really looking more at the injuries and looking at Mr. O'Keefe and his kinematics and his alleged or any interaction between him and the vehicle and whether that would be consistent with his injuries as well as the damage that we see to the Lexus as evaluated by Dr. Wolf.
If I could ask Dr. RENTSCHLER one question, it would be, but what did you think of that Bree?
Did you ultimately issue a report, an initial report summarizing your opinions and your conclusions following your analysis?
We did, yes, sir.
About when was that report issued?
I believe it was sometime in February.
February of what year?
It would have been February of last year, 2024.
2024, okay,
Correct.
thank you. Were you able to provide an analysis, given the information that you had, were you able to provide an analysis for the biomechanical aspect of the analysis of the case?
I was, yes, sir.
All right, did you review medical records and other materials?
I did, yes.
Did you make note of anything with regard to Mr. O'Keefe's injury or injuries based on what you reviewed initially when you began your analysis?
I did, yes.
Can you describe what you noted in terms of Mr. O'Keefe's injuries?
There were really just two basically different areas of injury. There was injury to the head. There was a laceration on the rear kind of right occipital region of the head, which resulted in fractures, an occipital skull fracture, which is the rear part of your skull, as well as basilar skull fractures that propagated up through the skull. And then there were injuries which were noted or diagnosed to be superficial abrasions along his right arm.
What is a subscapular hemorrhage?
Subscapular is?
Yes.
Yeah, with respect to the head, is that what? Yes,
as,
yeah.
as it relates to the head.
Yes, well, so when we talk about there's subarachnoid, there's pia hemorrhages, but basically they're hemorrhages, and scapular is hemorrhage under the scalp. But
From what I understand, there's like oversight committees and whatnot. I mean, there's been a million people asking like, what can we do about Bev? My understanding is very little, sadly, that judges, it's really hard for them to get in trouble, even when what they've done is egregious. I mean, basically, I think that they'd have to like, I don't know, buy an automatic weapon and shoot everybody in the courthouse to maybe face the repercussions. I mean, I'm exaggerating, but like, you know, not like, anyways, you know, yeah, unfortunately, I mean, it's like, yeah, the Judicial Oversight Committee, but like, they're already oversighting her and they're like, yeah, it's fine. So
above the skull. So subdural is within on the surface of the brain, but scapular means that it's a hematoma or bleeding that occurs under the scalp but above the actual skull.
Did you note subscapular hemorrhage in your analysis of Mr. O'Keefe's injuries?
Yes, I believe there was extensive subscapular hemorrhaging.
What about skull fractures?
There were, as I described, occipital skull fracture in the back of the skull that then propagated forward the calvarium as well as the basilar or the base of the skull.
You mentioned subdural hemorrhage as one of the issues that you would look at normally. Did you note whether Mr. O'Keefe suffered from subdural hemorrhage?
He did, yes. He had sustained subdural hemorrhage as a result.
And also subarachnoid hemorrhage?
Correct, yes.
What about bilateral orbital ecchymosis?
He did, yes. Bruising along the eyes, basically.
What does bilateral mean? Both?
Bilateral means left and right, correct.
Did you note a 1 centimeter or approximately 1 centimeter laceration to the upper right eyelid?
There was, yes, 1 centimeter, yeah. And so, you know, that's a little less than half an inch laceration right above the right eye.
What about abrasions to the anterior left aspect of the nose?
There were some abrasions on the nose and then I believe a few lacerations as well.
Laceration on the right anterior tongue?
The tongue was lacerated, yes.
You noted, with regard to one of Mr. O'Keefe's extremities, abrasions along that extremity.
Superficial abrasions, that's correct, sir.
Describe which arm we're talking about and what part of the arm.
It was the right arm, and it was from the forearm up towards the top of the shoulder. And there were various abrasions, what were diagnosed as superficial abrasions along that kind of posterior aspect of the arm, the elbow, forearm, and the upper arm.
When you undertake an analysis, do you use biomechanics and kinematics both to try to evaluate whether or not a specific set of injuries are consistent or inconsistent with a proposed set of facts? Or I guess I'll just leave it there, a proposed set of facts.
Yeah, I mean, those are basic steps to look at how an injury occurs. I mean, first you have to identify the injury, and that's by looking at the medical records and determining what the diagnosed injuries are. And then you have to determine the kinematics and the kinetics associated with a certain event. So how did the person move? How was their body move?
Medical records, you say, like x-rays?
Did they interact with anything? And how did that result in loading or force being applied to the body? Those are basic steps of a biomechanical injury causation analysis.
How did you go about undertaking those steps in this particular case?
So in this particular case, we looked at how those injuries are actually produced or created. So occipital skull fracture, you need a sufficient force. You need a force of around maybe 1,400 or 1,600 pounds applied at the back of the skull to actually cause a fracture like that. The abrasion, superficial abrasions, and an abrasion is basically rubbing or scraping or friction that kind of scrapes away the top part of your skin, the epidermis. You have the epidermis, the dermis, and then the hypodermis. An abrasion is just gets into the top epidermis and doesn't get any farther. Laceration is an actual tearing or ripping of the skin, usually down past the epidermis into the dermis. And so that takes either a blunt object or a sharp edge, depending on whether it's an incision or laceration, to actually produce that type of an injury.
Did you look at patterns of injuries on Mr. O'Keefe?
Yes.
Did you also, the other side of that handshake, did you also look at damage to the vehicle, physical damage to the Lexus?
We did, yes. Our goal or what we were tasked with was to determine whether the injuries are consistent with the damage to the car. So clearly, you look at how these injuries are created, what injury mechanism you need to produce them, and then you look at the damage to the car. Can you line up contact between where those injuries occurred and how they...
It's just so crazy. I mean, the jury's got to be like, dude, defense, we get it. Look at what the Commonwealth offered. Look at what the Commonwealth offered, both in the caliber of their final witnesses, right? And what they are trying to say happened that doesn't make any sense. And like the testimony and how they tried to use data, science, I don't know, and failed. And then look at the lineup of the defense witnesses. You know, the absolute exemplar of a professional, and I say a professional as in not a clown like Dr. Welcher. I mean, it's just, and the caliber and like they're not, and even just the demeanor. You compare the demeanor and you compare the quality of the testimony, compare the oh my God, the qualifications and the credibility, right? And the literally it's like one after another. And it's like, it's just crazy that this case, it's like crazy that we're here. And I mean, I wonder if the jury is thinking like, this is overkill defense. We get it. But it's like, dude, if they only knew what happened last trial, they would understand. You know what I mean?
They occurred with damage to the vehicle.
What kind of materials did you review? In addition to, I'm guessing, photographs?
Photographs, yes, autopsy photographs, as well as photographs of the vehicle and the damage to the Lexus.
What about medical records, hospital records, things of that nature?
Absolutely. That's the first step, looking at the injuries, define what the injuries are, what are the diagnosed injuries, as well as it's important to determine what injuries don't exist, because that's also helpful in determining whether certain impacts may or may not have actually occurred.
Did you receive a full file from the medical examiner's office in this case?
I did, yes, sir.
Did you also receive police reports, follow-up reports, witness statements, things of that nature in this case?
We did, yes.
Did you receive any data concerning the vehicle itself? Contained either in police reports or follow-up reports or expert reports?
We did, yes.
Mr. Jackson, I'm just going to ask you to slow down the cadence of your voice a little bit.
It's late in the day and I'm doing it again, aren't I? I'll slow down. I forgot where I left off, but let me ask you sort of openly, was there anything else that you considered and analyzed in at least building a database from which you would build an analysis?
Well, yeah, I mean, we review all the materials that are provided to look at all the injuries, to look at all aspects of the vehicle, damage to the vehicle, information about what the vehicle may have been doing. Any other evidence that may help contribute to looking at what either caused the injuries or what may or may not have caused the damage to that vehicle.
When you and your teammates undertook this analysis, did you even know who we were?
Initially, we did not. No, initially, I personally didn't know anything about the case. And we were asked not to do any research or to look up anything about it. We were given certain parameters, certain information, and that was it.
Did you follow those instructions?
I did, yes.
The undertaking, the analysis that you did, was it in keeping with the accepted methodology or methodologies?
Oh, yeah. You know what else I was remembering, too? The whole signal thing. And you know how Breenan's going to...
In your field of engineering?
It was, yes.
Did you ultimately reach some opinions and conclusions based on that initial investigation or analysis?
I did, and we did it at ARCA, yes. Myself, Dr. Wolf, and Mr. Klein did.
Did you reach any opinions or conclusions with regard to the force required to produce the occipital skull fracture that you noted with Mr. O'Keefe, his head being struck by the rear tail lamp of the subject Lexus?
I did, yes.
Tell me what those opinions and conclusions were.
Well, again, we determined by looking at research and tolerance values that it would take about 1,400 to 1,600 pounds of force to cause an occipital skull fracture. Now, we were tasked with looking at, again, could that result from impact of the car? So one of the things we did is we took a head from a dummy basically that's instrumented with accelerometers, and we dropped it onto a taillight cover to attain a speed of 15 miles an hour. And so that would be comparable to the vehicle striking the head at 15 miles an hour. And I concluded a few things from that. A, that the force wasn't sufficient, or the acceleration wasn't sufficient to produce enough force to cause a skull fracture at 15 miles an hour. And also, when you look at the position and configuration of the occupant, it really wasn't possible to get a skull fracture by hitting the taillight and not sustain any other significant fractures. For instance, where the taillight's positioned to have an impact to the back of the head, you really couldn't have someone positioned in such a manner.
Yeah, I mean, this is all okay. So this is basically, remember, so you don't the head. This is what they were doing last year, right? Because remember, last year the Commonwealth seemed to be going with the head hit the taillight, and then they realized that that was even more impossible than any other suggestion that they could come up with. So they pivoted to the arm thing with the pirouette. So yeah, he's explaining this from last trial.
A few things from that. A, that the
Oh,
force
they started out. Now remember, what he's discussing here is what they were doing. That the testing for which was done prior to them ever having anything to do with the defense, right? This was all from their being hired by the feds.
Force wasn't sufficient, or the acceleration wasn't sufficient to produce enough force to cause a skull fracture at 15 miles an hour. And also, when you look at the position and configuration of the occupant, it really wasn't possible to get a skull fracture by hitting the taillight and not sustain any other significant fractures. For instance, where the taillight's positioned to have an impact to the back of the head, you really couldn't have someone positioned in such a manner to strike just the head and not have subsequent concomitant injury to the neck or any other part of the body. So,
Like, let's just explain why things are obvious. They're common sense. They go without saying. Don't need any further explanation. But let's just bring in every fucking qualified ass witness that's on the planet to come in and actually still explain it. And then hear Breenan be like, nah, you know, signal. You know? Yeah.
my findings with respect to the skull or the occipital skull fractures was that it likely did not occur as a result of contact, specifically with the taillight cover on the rear passenger side of the Lexus.
So as to the question of whether Mr. O'Keefe suffered the occipital skull fracture as a result of being hit by the tail lamp at 15 miles an hour, were you able to scientifically rule that out?
I was, yes, sir.
Was that to a reasonable degree of scientific certainty?
It was, yes.
Did you reach any opinions or conclusions regarding the abrasions on the right arm that you noted earlier on Mr. O'Keefe's body?
Yes, I believe my conclusions with respect to the abrasions are that it was inconsistent with contact to the taillight, and that not only that those injuries are inconsistent, but you would expect additional injuries, likely fractures to the hand and or the forearm, depending on the actual speed of the vehicle.
Other than the expectation that you would see fractures or other damage to the arm, what was the basis for your opinion that the linear abrasions would not result from impact with a non-damaged taillight traveling in reverse?
Well, you have to look at the kinematics associated with that, and that in
I'm
order to
still
get.
not sure how the Commonwealth is going to try to suggest that there's any way that in an imaginary land that the Lexus hit the arm and the arm didn't have any bruises or fractures, unless it was at like half a mile per hour. But if they do that, then you know they don't get a broken tail light. I mean, it's just, I mean, it's like how are they going to do it?
Yeah, it's just superficial abrasions. That doesn't take a significant amount of force, but essentially that to have an arm contact the rear of the car, and we weren't really given any theory of how the arm contacted the car. So initially, we weren't privy to any theories or allegations of how this may occur. So just generally speaking, looking at the arm, how it would contact the car, and subsequent movement and interaction with the light cover, my opinion was that the injuries would be inconsistent, or the injuries that Mr. O'Keefe sustained on his right arm and didn't sustain would be inconsistent with actual interaction with the taillight.
Doctor, were your opinions and conclusions, along with those of your colleagues, reduced to a report?
They were, yes, sir.
Was that report, to your knowledge, ultimately turned over to both the defense and the Commonwealth in this case?
To my knowledge, it was, yes, sir.
I'm going to change gears for a second and bring us forward to the spring of 2024, after February of 2024, moving into the start of 2025. Did the defense at some point reach out to ARCA and contact you and Dr. Wolf?
They did, yes.
That was back in 2024 after the spring, correct?
That's correct, yes.
At some point, did the defense engage you specifically to testify?
Yes.
This year?
This year?
This year, meaning
Yes.
this trial?
For this trial, yes.
Okay.
Yes, correct.
Were you asked to conduct further testing in furtherance of your potential testimony in this trial?
We were, yes, sir.
And were you provided additional materials from the defense In furtherance of your potential testimony and your testing.
Yes, we were provided additional material with respect to, yes, the theory of how this may have occurred and how Mr. O'Keefe may have sustained his injuries, allegedly.
Included in the materials that you were provided in anticipation of your testimony in this case, in this trial, were you provided anything from a company called Aperture?
We were, yes.
What were you provided from Aperture?
We were provided a written report from Aperture, a PowerPoint presentation, about 140 some pages from Aperture, and then a file material, I believe, what was reviewed and the results of some testing that Aperture had conducted with respect to this case.
Was it your understanding that the Aperture PowerPoint was authored by a particular individual?
Yes, sir.
Who authored that PowerPoint, as far as you knew it?
As far as I'm aware, it was Dr. Judson Welcher.
Oh boy.
You want to maybe approach briefly?
Okay.
I can't wait to see what he thinks of that freaking blue paint test, you guys. And I don't know that we get to it today. I think it's gonna have, dude, they're leaving the jury hanging. Jury, you're gonna have to wait another day to find out what he thinks of that blue paint test. Oh my God, that's cruel and unusual punishment right there, man. Yep, they only get the fan. Huh. We only get the fan. The only fan.
We picked up a lot of time today. I think it was because we did spend less time at Sidebar and less time doing things outside your presence. So we're back on track, and we're going to let you go for today, and we're expecting a full day tomorrow. I can tell you, the lawyers tell me that we're definitely winding down. Okay, so please, those same three cautions, do not discuss this case with anyone. Don't do any independent research or investigation into this case. If you happen to see, hear, or read anything about this case, please disregard it and let us know. And please continue to be very careful with your social media use. So we'll see you ready to start at 9 o'clock.
I think it's entirely possible that that's where the jury's at. Remember, we heard yesterday that the jury, well, according to Judge Bev, that the jury seemed quote unquote fed up. And it's like, it could just be that they're like, this is such a waste of fucking time. I mean, you know, I think it's entirely possible, Twiz. I think it's entirely possible. But that's it for today. So what we will do is we will reset the goal for tomorrow with the next goal, and we will save tomorrow for the new story. You guys can have some suspense there. I'm sure there'll be even more stories because tomorrow's another day at the law firm, and with every day there's all kinds of new stuff. So we'll have plenty of fun stuff to talk about tomorrow, and we will have Dr. RENTSCHLER. Now, here's the thing: will they finish with Dr. RENTSCHLER? I mean, who knows? It seems like they should, but anything can happen here. But if they do, then we'll be on to the Commonwealth's rebuttal. If they decide to call, I mean, in the wake of these X-rays, I think they should just give up and not do it. However, if they do call the rebuttal witnesses, Hank said it would be only like an hour or two. That's what he said yesterday. I mean, so basically, if they can finish, I'm not saying this will happen, but like if they finished with Dr. RENTSCHLER, I don't know. Even if they finished with Dr. RENTSCHLER, like maybe slightly after lunch, ostensibly, if Breenan's estimate on the rebuttal witnesses is correct, they could finish all their tests. They could be finished with testimony tomorrow, maybe, right? And then on Thursday, it would be coming in for closing arguments, unless they finish with testimony on Thursday. I don't know. It'll be interesting to see what happens. Or a lot of things could go wrong, and maybe closing arguments will happen on Friday. They still have to have the charging conference. If you guys remember last year, I kept waiting during the charging conference. I kept waiting for her to come back on all the stuff that she said, yeah, we'll get to this. We'll get to this. There's like a long list of things. She was like, we don't have time to talk about now. We don't have time to talk about now. And it was like stuff that they never finalized, right, of the jury instructions. And I remember I kept saying during the live streams, like, yeah, don't worry, they'll finalize this. And we still don't know how she's going to decide on this. And we were really analyzing them. And then they just went straight into closing arguments and were handed the case to deliberate. And I was like, what? Did I miss something? So point being, normally charging conferences are lengthy and thorough, but here it could just be 10 minutes. So we'll see. Twiz, I don't even know. I don't even know with you. So anywho, but you guys are awesome. Love y'all. Love the squirrels. Mary, hope you have fun, continued fun on your vacation. Shout out to Miss Mojo. Happy to see you again as well. And Twiz is going to be, I don't know what Twiz is. Twiz is having fun in imaginary land about Heather being Lucy with pink hair in the basement. I don't know. But anyway, you guys are awesome. We'll be back tomorrow. And until then, squirrel out.